All right, this rulemaking hearing is called to order. My name is Robert Herndon. I serve as Assistant General Counsel in the Department of Commerce and Insurance Division of Regulatory Boards. Would the board members who are present introduce themselves for the record? And we'll start with the director.
Good morning, Executive Director for the Cosmetology and Barber Board. My name's Roxana Gamusio.
Donna Coppinger.
Bobby Fingers.
Yvette Granger.
Ellie Barger.
Ron Gillihan.
Tricia Richmond.
Mona Sappenfield.
Judy McAllister.
Amy Tanksley.
Diane Tafe-Taylor.
9 a.m. on Monday, January 5th, 2015. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the State Board of Cosmetology and Barber Examiners has made public in order to clarify licensing requirements, implement a system to provide temporary permitting for applicants under certain circumstances, and to establish a method for allowing alternative educational opportunities to students attending cosmetology schools through an apprenticeship program. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's Office for review of legality. If approved, they're filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room. Only those who have signed will be permitted to speak. Please make sure you put your address on there too. The notice of rulemaking hearing included the entire text of the proposed rules and was published in the November 3rd, 2014 edition of the Tennessee Administrative Register. Ms. Camuccio, what additional notice was given to the affected individuals or groups?
The board office, through their blast email system, sent out an email to anyone registered to receive emails on November the 7th. That went out to, I believe, although I wasn't given an official count, over 3,000 individuals. We have also updated our website to have the link, and 2 weeks ago put the rules for both the Barber Board and the Cosmetology directly on our website for everyone to be able to view.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I'll read the substance of the proposed rules into the record. First is Chapter 0200-01, the Rules of the Barber Board. Rule 0200-01-.01, Requirements for School License, is amended by adding new subparagraphs 4D and 4E to read as follows. Paragraph D, the school must have at least 15 students enrolled, part-time or full-time, and that school must provide proof of same to the board in the form of signed student enrollment agreements prior to being granted a barber school license. Paragraph E, full-time barber school students must attend school for at least 25 hours per week, and part-time barber school students must attend school for at least 15 hours a week. Rule 0200-01-06, expiration of certificates of registration, is amended by amending paragraphs 1, 2, 3, and 4 to read as follows, and by adding new paragraphs 5 through 8 as follows. Number 1, all certificates of registration for master barbers and barber instructors shall expire biannually on the anniversary date of the original date of licensure. 2, all certificates of registration for barbershops shall expire biannually on the last day and the anniversary date of the original date of licensure. 3, all certificates of registration for technicians shall expire biannually on the anniversary date of the original date of licensure. 4, all certificates of registration for barber schools or colleges shall expire annually on the last date of the month of the original date of licensure. If a barber school or barber college license is not renewed within 1 year from the date of the expiration of the license, a new barber school or barber college license application will be required. 5, a master barber or barber instructor may place his or her license in inactive status by completing a form as prescribed by the board and by submitting that form to the board prior to the expiration of his or her license. A master barber or barber instructor whose license is in inactive status may not engage in any conduct for which a license is required while his or her license is in inactive status. Master barber or barber instructor gives his or her license, places his or her license in inactive status. Such license may only remain in inactive status until the end of the current renewal period. The board may, at its discretion, waive this requirement for good cause shown and may attach any lawful conditions it deems appropriate to such a waiver. 7, a master barber or barber instructor whose license is inactive may reinstate his or her license to active status by completing a form as prescribed by the board and demonstrating compliance with all applicable requirements for license reinstatement. 8, an applicant for licensure meeting the requirements of TCA 43-1304D1 may A, be issued a license under this chapter under application and payment of all fees required for issuance of a regular license of the same type if, in the opinion of the board, the requirements for certification of licensure of such other state are substantially equivalent to that required in Tennessee, or B, be issued a temporary permit described herein if the board determines that the applicant's license does not meet the requirements for substantial equivalency, but that the applicant could perform additional acts, including but not limited to education, training, or experience requirements for the license to be substantially equivalent. The board may issue a temporary permit upon application and payment of all fees required for issuance of a regular license of the same type, which shall allow such person to perform services as if fully licensed for a set period of time that is determined to be sufficient for the applicant to complete such requirements. Number 1, after completing these additional requirements and providing the board with sufficient proof thereof as may be required, a full license shall be issued to the applicant with an issuance date of the date of the original issuance of the temporary permit and an expiration date as if the full license had been issued at that time. 2, a temporary permit shall be issued for a period of less than the length of a renewal cycle for a full license. 3, a temporary permit shall expire upon the date set by the board and shall not be subject to renewal except through the completion of the requirements for substantial equivalency as required by the board or by an extension of time granted for good cause by the board. 4, should an extension to a temporary permit cause the permit to be in effect longer than the renewal cycle of a full license, the holder of the temporary permit shall file a renewal application with such documentation and fees, including completion of continuing education, as are required by the board for all other renewals of a full license of the same type. Paragraph 9. Military education, training, or experience completed by a person described at TCA 4-3-1304D1 B, I, A through C shall be accepted toward the qualifications in whole or in part to receive any license issued by the board if such military education, training, or experience is determined by the board to be substantially equivalent to the education, training, or experience required for the issuance of such license. 10, any licensee who's a member of the National Guard or a reserve component of the Armed Forces of the United States called to active duty, whose license expires during the period of activation, should be eligible for renewal upon the licensee being released from active duty without A, payment of late fees or other penalties, B, obtaining continuing education credits, and circumstances associated with the person's military duty prevented the obtaining of continuing education credits and a waiver request has been submitted to the board, or the person performs a licensed or certified occupation as part of such person's military duty and provides documentation sufficient to demonstrate such to the board, or C, performing any other similar act typically required for the renewal of a license or certification. 11, the license, certificate, certification, or permit should be eligible for renewal pursuant to paragraph 10 for 6 months from the person's release from active duty. 12, any person renewing under paragraph 10 shall provide the board such supporting documentation evidencing activation as may be required by the board prior to renewal of any license pursuant to that paragraph. Rule 0200-01.07, equipment and location requirements for barbershops, is amended by amending subparagraph 1D to read as follows. Every barbershop should be equipped with at least one dry sterilizer or sanitary compartment per station. Rule 0200-01-10, original license fee, is amended by adding new paragraph 2 to read as follows. Barbershop and barber school applications shall expire within 90 days of the date of the application submitted to the board if the applicant fails to provide all necessary application documentation and information to the board. The board may, in its sole discretion and for good cause shown, waive this requirement upon written request by the applicant. Right. The second set is much longer, and I don't know if I can read, my voice will hold out. So I'm going to summarize some of the longer rules. Chapter 0440-01 Licensing Amendments. 0440-01-.01 Requirements for School License is amended by deleting the text of the rule in its entirety and substituting instead the following language so that as amended the rule shall read. The Board of Cosmetology, hereinafter the Board, not issue, reissue, or renew a license to operate a school of cosmetology unless the school is equipped with all workable equipment consisting of at least this list of required equipment. 2, a school of cosmetology offering an aesthetics curriculum shall also be equipped with the workable equipment consisting of at least this list of equipment that was slightly adjusted. Requirements for instructional floor space. Instructional floor space means the floor space of a school designated primarily for the instruction of students and shall not include such spaces as storage, restrooms, utility rooms, passageways, or inhabited administrative spaces such as reception areas, offices, and break areas. B, a school of cosmetology offering a manicuring curriculum shall also be equipped with the adequate instructional floor space for manicuring so as not to compromise or disrupt the teaching of cosmetology curriculum prescribed in the appropriate rule. C, a school of cosmetology offering natural hairstyling curriculum shall also be equipped with adequate instructional floor space for natural hairstyling so as not to compromise or disrupt the teaching of cosmetology curricula prescribed by the rule. A school of cosmetology offering a shampooing curriculum shall also be equipped with adequate instructional floor space for shampooing so as not to compromise or disrupt the teaching of cosmetology curricula. And E, a school of cosmetology offering an aesthetics curricula shall also be equipped with the adequate floor space for aesthetics so as not to compromise the teaching of cosmetology. Floor plan, a proposed floor plan must be submitted to and approved by the board before issuance of a license to operate a new school of cosmetology, issuance of a license to operate a school of cosmetology whose ownership is changed, or reissuance of a license to operate a relocated school of cosmetology. were required under this paragraph, the floor plan shall provide for and the school shall contain at least 2,200 square feet of instructional floor space, including an enclosed classroom for theory instruction. New school. A new school should be closed to the public for 90 days after the issuance of its license unless the school has students enrolled with the required 200 or more hours to perform cosmetology services on the public. A branch school should be considered a new school unless the school has students enrolled with the required 200 or more hours to perform cosmetology services on the public. If an existing school requires an expansion campus facility, the facility must be located within 2 miles of the main campus. All right, Rule 0440-01-03 curriculum is amended by deleting the text of the rule in its entirety and substituting instead the following language so that as amended, the rule shall read, paragraph 1, apprenticeship student means a student enrolled in a school participating in an apprenticeship program with the intention of completing the school's curriculum under that school's apprenticeship program. 2, supervising licensed professional means a licensee in the field of study of an enrolled apprenticeship student who is in responsible charge of supervising and accounting for that student's apprenticeship program, credible activities, and providing the participating school with the student's apprenticeship activity record. The 1,500 clock hours, 45 credit hours of instruction required of applicants for a license to practice cosmetology shall be apportioned as follows. In general, 300 clock hours, 9 credit hours, sterilization, sanitation, bacteriology, anatomy and physiology, shop ethics, personality and salesmanship, and state law. For chemical, 600 clock hours, or 18 credit hours. And for physical, 600 clock hours, 18 credit hours. The 600 clock hours or 18 credit hours of instruction required of an applicant for a license to practice manicuring should be apportioned as follows. 150 clock hours or 4.5 credit hours of general, 100 clock hours or 3 credit hours of chemical, and 600 clock hours, 18 credit hours of physical. And the 750 clock hours, 22.5 credit hours of instruction required for an applicant to practice aesthetics shall be 150 clock hours or 4.5 credit hours of general, 150 clock hours, 4.5 credit hours of chemical, 450 clock hours or 13.5 credit hours of physical. 300 clock hours or 9 credit hours of instruction required to practice shampooing should be 100 clock hours or 3 credit hours of general, 50 clock hours or 1.5 credit hours of chemical, 150 clock hours or 4.5 credit hours of physical. 300 clock hours, 9 credit hours of instruction required for natural hairstylist license should be 120 clock hours or 3.6 credit hours of general, 180 clock hours or 5.4 credit hours of physical. 300 clock hours, 9 credit hours of instruction required of applicants for an instructor's license shall include no less than a total of 100 clock hours or 3 credit hours in lesson planning and motivation. To the extent that the prescribed curricula for courses of instruction are substantially similar, the board may allow general hours of credit accumulated by a student to be transferred from one course of instruction to another. Any person holding a valid Tennessee Barber license will be given credit for 750 clock hours and 22.5 credit hours toward a Tennessee Cosmetology license. In order to be eligible for the above credit, a barber must be enrolled in a cosmetology school full-time, a minimum of 25 hours a week, not to exceed 48 hours a week. After the student has completed the first 750 clock hours or 22.5 credit hours in the cosmetology school, the board may apply the second 750 hours for the purpose of graduating and being permitted to take the cosmetology exam. Notwithstanding any provision to the contrary, any school operated under the Tennessee Cosmetology Act of 1986 may develop courses of instruction and practice incorporating an apprenticeship curricula, which allows an applicant to obtain 50% of the required hours for a specific license through classroom instruction and 50% of the required hours under the direct supervision and responsible charge of a licensed professional who meets the requirements set forth in this rule. Supervision hours received may not be used for credit for more than 50% of the required hours in any instruction subcategory, meaning general, chemical, or physical. The purpose of this rule, responsible charge shall identify a licensed professional in supervision of a student enrolled in an apprenticeship program curriculum approved by the board and responsible for all aspects of that student's apprenticeship instruction. Any school offering an apprenticeship curriculum shall maintain a record of all hours completed under the apprenticeship program, including classroom hours in which credit is awarded in a student's academic file. The record shall include the number of hours completed under direct supervision and responsible charge, the dates these hours were earned, the license number, the professional and responsible charge of instruction who directly supervise the student, and the signatures of both the student and the supervising professional and responsible charge. The required records should be maintained in the student's file and made available for inspection during the student's academic career. Should be maintained for a period of not less than 7 years after a student is no longer attending the providing school, and should be made available to the board immediately upon request during this time. A daily log accounting for all apprenticeship hours awarded under this chapter by any school offering an apprenticeship curriculum should be maintained by the school and updated monthly. The log should be made available for inspection at any time. Any supervising licensed professional and responsible charges provided in this rule should have at least 10 consecutive years of experience as a licensed professional in the field of study in which the supervision is provided and hold a current valid Tennessee license issued by the board in the field in which supervision is provided. The supervising licensed professional's license must be current at all times while providing supervision. The participating school should be responsible for confirming a supervising professional's qualifications to be placed in responsible charge of an apprenticeship student as provided by this rule. The participating school providing hours for supervised apprenticeship credit shall maintain documented proof of a supervising professional's experience and a copy of the supervising professional's current valid Tennessee license. This documentation should be maintained for a minimum of 7 years following the date that the supervising professional last provided supervision for that school. Apprenticeship experience earned in any jurisdiction other than Tennessee would be considered for purposes of complying with this rule, provided that the supervising professional was appropriately licensed in that jurisdiction at all times when responsible charge is provided for the purpose of earning credit. Proof of the supervising professional's credentials must be provided by the transferring student candidate. No participating school shall allow any person not appropriately licensed to provide any supervision for the purposes of this rule, nor shall any participating school allow credit for hours under the supervision of unlicensed persons. Rule 0440-0104 High School Equivalence is amended by deleting the text of the rule in its entirety and substituting instead the following language so that as amended, the rule shall read, for purposes of determining eligibility of enrollment in the School of Cosmetology, an applicant must have completed and passed at least 2 years of high school or obtained a score of at least 450 on a general educational development test. Public and vocational schools are exempt from the provisions of TCA 624122. However, the completion of at least 10 high school credits or obtaining a score of at least 450 on a general education development test must be met prior to the completion of a cosmetology curriculum. The school considering acceptance of any candidate should be responsible for verifying and accepting any substituted documentation for high school equivalency. Rule 0440-0105 requirements for schools is amended by deleting the text in its entirety and substituting instead the following, so that as amended the rule shall read, every school of cosmetology, any school solely licensed to teach natural hairstyling, manicuring, or aesthetics, shall publish readily available and clearly expressed admission policies and requirements, provide a prospective student before enrollment, publish materials which explain requirements for licensure for any one of the categories. However, if the school is licensed to provide instruction solely in natural hairstyling, manicuring, or aesthetics, the school shall only be responsible for providing documentation relative to licensure in the field in which the school provides instruction. And give a receipt to any student for whom money is collected by authorized school personnel. Submit to the office of the board on the prescribed form a monthly progress report on each student enrolled. The monthly reports must be received no later than the 10th of each month for the previous month's hours of instruction. If reports are not submitted by this date, a penalty set by the board will be issued for violation of this rule. And then teach a minimum 10% of theory hours each week in each curriculum offered in the school. Rule 0440.01.06, enrollment of students, is amended so it shall read, every school of cosmetology shall maintain documentation of age and education in each student's file, which evidences eligibility for enrollment under the terms of TCA 62. Enrollment of a student in a school of cosmetology should be evidenced by written enrollment agreement which clearly details the rights and obligations of both parties. The school shall furnish to the student an executed copy of the enrollment agreement and maintain a copy of the agreement in the student's file. And every enrollment agreement should be signed and dated by the student and an authorized representative of the school. Specify the number of clock hours in the course of instruction and an appropriate number of weeks or months required for completion. Identify all costs and charges which the student must bear. Indicate any grounds for termination of a student by the school. State in clear and understandable language the school's refund policy. List any special conditions or requirements for graduation and contain an acknowledgement that the student has read and understands the agreement before making any payment thereunder. All applicant information, including documentation and enrollment agreements required under this rule, should be included in the student's file and made available for inspection by members or inspectors of the board during business hours. Rule 0440.01.09, examination, passing scores, and school attendance ratio is amended to read, the minimum passing scores on all examinations held by the board should be 70%. The school student attends for 60% of the greatest percentage of all hours, including hours obtained throughout an apprenticeship program, will be the school responsible for the pass-fail ratio. Student who graduates from a licensed school must pass all examinations no more than 3 years after graduation. All scores of any past examinations after that date will be vacated, and the graduate must reapply for a license. Rule 0440.1.11, teacher training programs is amended to read, an application for approval of a teacher training program in cosmetology, aesthetics, manicuring, shampooing, or natural hairstyling shall include a summary of the education and experience of each instructor for the program, the scheduled dates of the program, and the proposed curricula of the program. The applicant shall demonstrate to the satisfaction of the board that the teacher training program submitted for approval will contain at least 16 hours of actual instruction, emphasize teaching methodology for its entire duration, restrict the size of classes sufficiently to ensure adequate attention to all participants, and proceed for not more than 2 hours without a break, and prohibit demonstrations or presentations for commercial purposes in classrooms. Training programs may not sell, take orders, or in any way promote a product. Promptly after the completion of a teacher training program approved by the board, the sponsor shall send to the board a roster showing the names, social security number, and ID numbers of the persons who attended the program and the number of hours that each person completed. The sponsor shall provide an opportunity for the attendees to evaluate each class in the overall program. The original evaluation should be forwarded to the office of the board. And then Rule 0440-01-13 fees is amended to read as published here. The fees for application examination, the original license fee, renewal fees, penalty for late renewal. Cosmetology, manicure, skincare, natural hairstylists, or manicure skincare shops. The fees for schools, replacement or correction of a license. Surcharge to issue manicurist license to former shampoo manicurist. Reciprocity. The fee for application through reciprocity must be received along with the applicant's initial application documents. Any reciprocity application received without this fee shall be incomplete and will not be considered. In the event that any check, draft, or order for the payment of a fee to the Board of Cosmetology earned because of insufficient funds, only cash, certified check, or money order will be accepted for the amount due, plus $20 additional fee. Applications for licensure of a salon are valid for 90 days after approval by the board. Failure to obtain and approve inspection for operation within 90 days shall invalidate the application and require a new one. Rule 0440-01-14 civil penalties is amended by reading the text of the rule, so it shall read as follows. The Tennessee State Board of Cosmetology may, in a lawful proceeding with respect to any person licensed or required to be licensed, in addition to or in lieu of any other lawful disciplinary action, assess civil penalties for violation of statutes, rules, or orders enforceable by the board in accordance with the following schedule. And each individual act and each day of continued violation may constitute a separate violation. The amount of any civil penalty shall not exceed $1,000 for each violation. We removed references to all these. There was a laundry list of statutes, and we reduced it to one. Incorporates everything. In determining the amount of any penalty to be assessed pursuant to this rule, the board may consider factors such as willingness of the violation, repetitions of violation, magnitude of the risk or harm caused by the violation, and extent to which the licensee is sought to compensate any victims. Any owner, manager, or cosmetologist requesting an individual with the shampoo license only to perform any service other than those listed for shampooing will be subjected to a $500 penalty. 0440-01-15 practice by instructor is amended by deleting the rule and replacing it so it'll read continuing education. In order for a licensed instructor to obtain credit for taking a continuing education course in a state other than the state of Tennessee, the licensed instructor shall obtain the board's approval before taking the course and submitting a written request of approval to the board within 30 days before the licensed instructor intends to take the course. Such written request must include a copy of the course's curriculum. A licensed instructor shall submit a request for an extension of time in which to take his or her continuing education and credit in writing to the board, along with proof showing good causes relative to illness or emergency prior to the expiration date of the instructor's license. An instructor may only practice or teach the discipline in which he or she is licensed. And then we move to new rules. New Rule 0440-01.16, Schools Providing Limited Instruction, is added to Chapter 0440-01 and shall read as follows. The board may, at its discretion, issue a license to a school solely to training in aesthetics, manicuring, or natural hair styling. No school with a limited license shall provide services to the public in any area other than those for which it's licensed to provide instruction. The board may, at its discretion, grant a waiver to a school licensed only to provide instruction in natural hairstyling, manicuring, or aesthetics, or an applicant for such a limited license from equipment requirements as provided in this chapter. A request for such a waiver must be made in writing to the school, by the school, on forms prescribed by the board, and shall specifically identify the equipment that the school desires to omit and the reasons that the omitted equipment is not necessary for the school's curriculum. Any shop participating in an apprenticeship curricula must post a sign at its entrance announcing its participation and must allow customers to elect whether to be serviced by an apprentice student. And then new rule 0440-01.17, communication with the board, is added to chapter 0440-01. Renewals. All cosmetologists, esthetician, manicurist, natural hair stylist, instructor, and shop license renewals should include the applicant's current address, phone number, and if available, email address. All cosmetologist, esthetician, manicurist, natural hair stylist, and instructor licensees shall notify the board in writing within 30 days of any change in mailing address. Electronic notification is acceptable for purposes of this rule. All cosmetologists, esthetician, manicurist, natural hair stylist, instructor, and shop licenses shall respond in writing to any communication from the board requesting a response within the time prescribed by the board pursuant to the request. Okay, new rule 0440-01.18, expedited licensing for military spouses, is added to chapter 0440-01. A person who's certified or licensed to perform cosmetology, aesthetics, manicuring, or natural hairstyling in a state other than Tennessee, upon application by reciprocity, shall be issued a license to practice or teach in Tennessee if such person's certifications in or licensure in such other state are substantially equivalent to the requirements for licensure in Tennessee. Such person's spouse is a member of the Armed Forces of the United States and is the subject of a military transfer to this state. Such person left employment to accompany their spouse to this state, and such person provides satisfactory evidence of a legal marriage and of such person's spouse's transfer orders. If such person provides satisfactory evidence of the requirements above, except item A, the board shall issue such person a temporary permit to practice while such person works to satisfy the state's licensure requirements. Any temporary permit issued by the board shall automatically expire 6 months from the date of the board's issuance of such temporary permit. On or before the expiration date, the person shall submit proof of completion of the additional licensing requirements in order to receive licensure in Tennessee. If such requirements have not been substantially met, then the individual must apply for a license under the standard procedures as prescribed by the board's law and rules.
Sanitary requirements, chapter 0440-02. Definitions is amended by deleting the text of the rule in its entirety and substituting instead with the language following. Number 1, as used in this chapter, unless the context requires otherwise, the definition of terms contained in Tennessee Code Annotated 64-4-102 are applicable. In addition, establishment means any cosmetology, manicuring, skin care, or natural hairstyling shop or cosmetology school. Licensee means any person holding a valid license issued by the board as a cosmetologist, manicurist, esthetician, shampoo/manicurist, instructor, natural hairstylist, or shampoo technician. C, shampooing is cleansing of hair and scalp and includes 1, brushing and combing, 2, rinsing, which includes removal of color, permanents, relaxers, and conditioners, 3, conditioning, meaning applying. D, shops means a cosmetology shop, manicure shop, skincare shop, or natural hairstyling shop. E, unprofessional conduct shall include but not limited to failure to respond or comply with a board-issued request or lawful order. F, violation means any breach or failure to abide by the statutes, rules, or orders enforceable by the Tennessee State Board of Cosmetology and any unprofessional conduct or any individual or entity licensed or required to be licensed under the Tennessee Code Act. Next, Rule 0440-02-.04, posting of rules and licenses is amended by deleting the text of the rule in its entirety and substituting it instead with the following language. A copy of the cosmetology law, current Tennessee Cosmetology Act, shall be readily available at each shop and school. 2, each holder of a shop license shall prominently display such license in a clear and conspicuous place at all times. Tennessee Rule 0440-02-.07. Equipment is amended by deleting the text of the rule in its entirety and substituting instead the following language. Number 1, every cosmetology shop shall be equipped with at least A, 1 shampoo bowl with hot and cold running water in work area and chair. B, 1 enclosed storage area for clean towels. C, 1 covered container for soil towels. D, 1 covered trash container maintained in a sanitary condition. E, 1 dry sterilizer or sanitary compartment. F, 1 wet sterilizer. G, 1 workstation, standard size, for each operator. H, 1 ultraviolet sanitizer. I, 1 blood spill kit, and J, adequate restroom facilities. All containers for cosmetic products must be properly labeled. Number 2, every skincare shop shall be equipped with at least A, 1 sink provides hot and cold running water in the work area excluding the bathroom. B, 1 magnifying lamp. C, 1 enclosed storage area for clean towels. D, 1 covered container for soil towels. E, 1 covered container maintained in a sanitary condition. F, 1 recycling facial chair/table. G, 1 wet sterilizer for the equipment used. H, ultraviolet sanitizer. I, 1 blood spill kit, and J, adequate restroom facilities. All containers for cosmetic products must be properly labeled. Number 3, any manicuring shop shall be equipped with at least A, 1 manicure table with stool or chair per manicurist. B, 1 patron chair. C, 1 wet sterilizer for equipment used. D, 1 ultraviolet sanitizer for equipment used. E, enclosed storage areas for clean towels. F, 1 covered container for soil towels. G, 1 covered trash container maintained in a sanitary condition. H, 1 sink which provides hot and cold running water in the work area excluding the bathroom. I, 1 finger bowl per table. J, 1 covered container per table for cotton balls and swabs. K, 1 foot bath if pedicures are offered. I, 1 blood spill kit. L, 1 blood spill kit. M, adequate restroom facilities. And N, sign prominently posted stating that the customer has the right not to have drills used on his or her nails. All containers for cosmetic products must be properly labeled. Number 4, every natural hairstyling shop shall be equipped with at least A, 1 shampoo bowl with hot and cold running water in the work area and chair. B, 1 enclosed storage area for clean towels. C, 1 covered container for soil towels. D, 1 covered trash container maintained in a sanitary condition. E, 1 dry sterilizer and sanitary compartment. F, 1 wet sterilizer. G, 1 workstation, standard size for each operator. H, 1 ultraviolet sanitizer. I, 1 blood spill kit. And J, adequate restroom facilities. All containers for cosmetic products must be properly labeled. Number 5, every shop shall contain sufficient equipment to enable it to perform all services offered competently and efficiently. All equipment must be in working order. Number 6, residential shops must maintain a separate entrance without requiring passage through any portion of a private residence. Separate restroom facilities must be provided apart from the living quarters. Number 7, cosmetology, skincare, natural hairstylist, or manicure shop located in a mobile home or mobile unit will not be approved for a license unless it is placed on a permanent foundation or otherwise rendered immobile. Number 8, a cosmetology, skincare, natural hairstylist, or manicure shop must have a separate entrance from any other business except in malls or strip shopping centers or other commercial property approved by the board. Rule 0440-2-.08 attire is amending is amended by deleting the text of this rule in its entirety and substituting instead with the following. Number 1, shops. Any licensee actively engaged in the practice of cosmetology, manicuring, natural hairstyling, shampooing, or aesthetics in a shop must wear an identification tag with file number. Number 2, schools. All students in a licensed school must wear a uniform prescribed by the school. All instructors must wear a name tag with identification number. Number 3, apprenticeship students. All students participating in an apprenticeship program in a licensed school must wear attire prescribed by the school and participating shop collectively. The student must wear a name tag identifying the student as an apprenticeship student and identify the school under which the student is practicing in the apprenticeship program. Rule 0440-02-.10. And this is the last. Animals is amended by deleting the text of the rule in its entirety and substituting instead the following language. Number 1, no animals, birds, or fish shall be permitted in any establishment with the exception of animals used to help disabled persons as prescribed by the Americans with Disabilities Act. If a service animal is kept in the establishment during business hours due to the necessity by an owner, manager, or employees, the necessity must be justified with documentation provided by the Americans with Disabilities Act and/or any other applicable authority. This documentation must be maintained in the establishment's license file and be available for inspection verification upon request by board member or a board inspector. Back to you.
That wasn't so bad. Before we get to the comment period, there's a few marks in here that need to go ahead and correct them. On page, if you go back to the beginning, on page 3, Rule 0440-01-.01, in the first paragraph it says the Board of Cosmetology. That needs to say the Board of Cosmetology and Barber Examiners. Page 9.
Rob, would you repeat that, please?
Page 9.
On page 3?
Oh, I'm sorry. Very first paragraph, it says the Board of Cosmetology, here and after the board.
Under the Barber rules,
It's chapter 0440-01, which is licensing, so that's cosmetology rules. The second set. First read the notice for barbers, for barbering. This is the second set for cosmetology.
those would be the rules that were emailed to you
Okay.
last week and a half, 2 weeks ago.
So I was saying under Rule 0440-01-.01, which is a requirement for school license. In the first paragraph, it says the Board of Cosmetology, but it's not correct anymore. Board of Cosmetology and Barber Examiners. So I just would like to add that in there. And then if you move to page 9, Rule 0440-01-.09, examination passing scores and school attendance ratio. It's sort of in the middle of the page. Paragraph 3 should read like this. A student who graduates from a licensed school must pass all examinations no more than 3 years after passing the initial theory examination. Otherwise, it looks like you got to pass everything within 3 years of graduation. But that's not what we want. Some people may never take the exams. Second sentence will say, all scores of any past examinations after that date will be vacated, and the graduate must retake and pass the initial theory examination. Following that, we go to page 12. At the top, paragraph 10. It says, in the event that any check, draft, or money order for the payment of a fee to the Board of Cosmetology, that needs to say Board of Cosmetology and Barber Examiners. And then down civil penalties in paragraph 1 of the next rule there. Once again, this is the Tennessee State Board of Cosmetology, that needs to say Board of Cosmetology and Barber Examiners. And then on page 14, paragraph 3, right there, sort of at the top, the last sentence says, if such requirements have been substantially met, then the individual must apply for a license under the standard procedure. If such requirements have not been substantially met, then the individual must apply for a license under the standard procedures as, not and, as prescribed by the board's law and rules. On the page 15, Rule 04400201, posting of rules and licenses, we need a third paragraph there that says, every holder of a personal license shall prominently display such license at any location that the license holder practices or teaches.
Read that again. Every holder.
Third paragraph should say, every holder of a personal license shall prominently display such license at any location that the license holder practices or teaches. And Roxana pointed out above that paragraph F, once again it says Board of Cosmetology, needs to say Cosmetology and Barber Examiners. On page 16, it's kind of embarrassing how many typos are in here. Paragraph 8. A cosmetology, skincare, natural hairstylist, or manicure shop must have a separate entrance from any other business except in malls. This needs to be a comma and strike that or. Shopping centers or other commercial property approved by the board. Those are the cleanup comments. Oh, sorry. Get out your barber rules, the first one we did. Three. Rule 0200-01.06. The first paragraph needs to say this. All certificates of registration for master barbers and barber instructors shall expire biannually on the last day of the month of the original licensure. Go down to number 2. Same thing. All certificates of registration for barber shops shall expire biannually on the last day of the month of the original licensure. Number 3, all certificates of registration for technicians shall expire biannually on the last day of the month of the original licensure.
Instead of the anniversary date?
Yeah, I'll change it.
Do you want to reiterate that anybody that needs to sign off Just a quick notation, if anyone came in after we had started, if you would like to speak as soon as we open the floor, please make sure that you've signed in the back, because I'm going to go ahead and take that clipboard in just a few minutes. Thank you very much.
On page 5 of the cosmetology section, I'm about halfway down the page, B, under the manicures hours, this is supposed to add up to 600, and that is broken down and adds up to 850. So I think the physical is supposed to be 400? Or, did that make it right? No? Oh, 350. Some kind of math.
There we go, that's right. I've got my rule book. I'm gonna
So
check to
the
see.
physical under manicure should be 350.
Anybody else notice any housekeeping things before we go to actual written comments? If not, we'll go to address our written comments, and then we'll take oral comments. All right. They have these. Look at this one first. I'm going to read the comments, and then the board needs to address the comments, whether or not you want to make amendments based on them or answer any question that's in them for both. All right, requested, and these come from Ms. Sappenfield. Number 1, the School of Cosmetology offering aesthetics or curriculum should also be equipped with all workable equipment consisting of at least and sufficient facial steamers, 1 suction machine or level 1 or 2 microdermabrasion machine, 1 class 1, 2, or 3 FDA regulated electric machines to include light indoor laser device with the manufacturer's intended commercial use statement for hair removal, skin enhancement of face and body, sufficient protective eyewear, glasses recommended by manufacturer of laser light devices for such student and instructor, 1 LED light with the manufacturer's intended use statement for skin improvement, 1 wax depilatory heater pot with manufacturer's intended commercial use statement, 1 hands-free magnifying lamp, 1 hot towel cabin, 1 reclining facial chair table, electric brushing machine or sonic brushing device, 1 electric heat mask that needs to be deleted, she says. Delete the 1 pair of electric heating mitts, 1 sink which provides hot and cold running water other than the bathrooms, 1 enclosed storage area for towels, 1 covered labeled container for soiled towels, 1 high frequency instrument needs to be ultraviolet sanitizer, 1 wet sterilizer, 1 professional makeup kit station providing a color matrix palette of makeup products, sufficient disposable applicators of makeup application, 1 skincare product kit representing 2 products from each category, cleansers, astringents, and toners, moisturizer, problem prep, and protective products, 1 autoclave instrument sanitizer, 1 covered trash container maintained in a sanitary condition at each teaching station, and sufficient work area for each student, 1 sharps container for biohazard material removal, 1 blood spill kit, and in all containers cosmetic products must be properly labeled. And then for Rule 0440-2-.062, which is the skincare shop equipment list, that rule needs to read like this. One sink which provides hot and cold running water in the work area excluding the bathroom, one hands-free magnifying lamp, one enclosed storage area for clean towels, one covered and labeled container for soiled towels, one covered and labeled trash container maintained in a sanitary condition, one reclining facial hair chair table, one wet sterilizer for the equipment used, one ultraviolet sanitizer, one blood spill kit, one sharps container for biohazard material removal, adequate restroom facilities with hot and cold water, one electric hot towel cabin, one facial steamer, one wax depilatory heater pot with manufacturer's intended commercial use statement. All containers for cosmetic products must be properly labeled. That's Ms. Sappenfield's recommendations of how those two rules should read. What's the board think? We're essentially deleting 3 or 4 things on the first one that don't need to be. We're updating the list.
It's a little bit of housekeeping for more modern practice, an education of a more modern. It follows the standard books that are taught. There are chapters that address all of these things. And it's deleting the high-frequency instrument actually complies with our own law that says we can't use it, so it doesn't need to be taught in the schools.
It changes a few things for the schools, so as the schools go through, they'll have to make sure to have that equipment, and then the same thing for the new shop applications. If all these pass, then we'll have an effective date, and the new shops applying for skincare will have to include all those things.
On the suction machine or level 1-2 microdermabrasion machine, in essence, microdermabrasion machines are suction and they're dual purpose. So it's just an option for a different one or the other.
You said all new schools would have to comply with that. Would there be any grandfather provision for existing cosmetology schools?
I would think that when they renew,
They're
renewal,
good until
they
they
need
On
renew.
renewal.
Okay.
Skincare shop, is that a specific license, or would that be all cosmetology shops?
Cosmetology shops are full service, so they would have to include it as well. Just your skincare shops, you have a lot of skincare and manicuring shops, they would have to comply, and then the full service, so it would affect potentially those 3 type of shops.
Just correct me if I'm wrong here. A lot of, like you just mentioned, manicure shops have their cosmetology shop just because they do eyebrow waxing. And they would have to have the facial machine, steamer, hot towel cabinet, if this is passed.
If they're applying for a skincare shop, most of the shops that do the manicuring and the waxing have the dual, it's a skincare and manicuring. So they don't have to have the hair cutting equipment like the full service, but they would have to comply to all these things when they get inspected, yes. So it is adding, I think, maybe a couple of things, Mona, am I right? That they will have to have, and taking out what isn't needed, which is good.
Correct with the manicuring, because the manicuring shops have grown in sophistication with the LED lights and the curating lights as well, so they need the safety protection of adding the safety glasses. And
But now, is that listed under the schools or the shops, the safety glasses?
I think I read that under the schools.
Yeah, the 0440-1-.01 is for the schools. And then the equipment for the shops starts in -2-.06 under the sanitation for this equipment.
So I'm looking at some new things here. The facial steamer, is that brand new?
it's in the rules now.
Okay, so, but before it wasn't required to be there?
What I did was I took the established rules and I just implemented the words delete where those things needed to be deleted. And then everything that was added to is after a hyphen colon. So I didn't really take anything out unless I said delete, and I didn't add anything unless it was in addition to.
I guess my question would go to shops who are not doing facial or any
But there is an
specifically.
aesthetic shop license, so this would be applicable to the schools that are teaching aesthetics, so that those students would be better prepared for servicing the clients and the safety of it all. And then there are some things that were included in the schools that are not in the shops, because there is that option of whether they wanted to practice, but at least they would have the education and information to at least make that choice.
But this wouldn't be a choice. This would be, going forward, all shops would be required to have these new additions. Is that what I'm understanding? And it wouldn't just be shops offering aesthetics. It would be all cosmetology shops would be included in this.
Every skincare shop shall be equipped with at least.
Skincare shop, from what I'm hearing, is also included in cosmetology shops. I'm specifically getting to, a facial chair
Well, I
or
took that
table.
language on 0440-206 2 straight from the rules. So if that needs to be changed to every maybe singular licensed aesthetic shop to differentiate that from a skincare shop in under the multidiscipline shops with hair, nails, skincare, to set them apart is those that, if they're going to be doing skincare and that's what they're doing, this would be the, if they're saying they're doing skincare, they would need this equipment to be able to do
I don't disagree with you. I'm just curious about shops that are not doing skincare but would be included in a broader cosmetology license.
well, it doesn't say cosmetology, it says every skincare shop.
Will that be like a barber shop that does the facials for men too?
No, not,
No, because this is under cosmetology.
and the barber is a little bit different. If I could interject, under equipment, under the current rule, the way the shops are broken down is you have number one for every cosmetology shop, and then it lists what they have. So cosmetology shops, which are really full-service shops, they do have, if they're doing the nails as well under the full-service shop, they would then need to have the items that the manicuring shops do as well for the nails.
Gotcha.
So if your full-service shop is just really cosmetology and that's all they're sticking to, then they could stop at just what the cosmetology shop has to have.
Gotcha.
And
Okay.
not add the manicuring piece and not add necessarily the skincare piece.
Okay.
Does that help?
That
Yes.
was its intent.
Okay. Yeah. And I totally agree with where you're headed. I just wanted to clarify who would be included in this and who would not be included in this.
Right.
Because these are some specific things that people may or may not need.
So that's for the folks who are providing those services within those shops. They would need to comply with that.
Correct.
Do we have any other concerns, changes, or do we carry forward with these?
Motion to carry forward.
Second it.
Or who seconded? Thank you.
Vote.
I thought you were the moderator.
Oh, you're still the chairman.
Okay, I'm sorry. We have a motion properly seconded to accept these recommendations. Is there any other discussion? Those in favor say aye.
Aye.
Those opposed say no. Motion carries.
The next page is Ms. Richmond's comments. There's some bullet points here. Students must have completed all tests required by school before apprentices. And then able to take the theory portion of state board after 750 hours completed and pass before being able to apprentice. Salon must have a licensed instructor. Salon approved by board to take apprentice. Salon must have time clock and send in weekly time to schools in order to keep our records current for the state. Failure to do so could be fined or removed to participate in program. School owner or employees of school can check in on student at salon to make sure they are there by phone or person. School must feel student is learning with hands-on experience because at end, the school is still responsible for their education. Would like to discuss?
Well, I think Ms. Richmond was brilliant to come up with the student has to take the theory portion of the state board after 750 hours completed and pass before being able to apprentice, because my concern was always, are they going to get what they need in the 750 school hours? Because if you see the breakdown of the school hours, it's like I'm so concerned as to where do you take out 750 of those hours. So that is just, that to me is great. If they can pass the theory portion, then they can apprentice, and I love that.
I think it defines what a lot of the concerns were.
If we could, because I think the rest of the notes that everyone has copies of in paper, I didn't do them this time on our iPad, so everyone has the paper versions of what was submitted. They were submitted a little bit late, and so I thought if we have paper, then we'll all be looking at the same things. We may want to vote on these differently, maybe at the end, because we're going to be looking and then hearing from the public, so we can, yeah, they may contradict each other when we're done. So I think going through everything that we have, maybe till the end, and then opening it up, and may make sense to sort out what pieces we end up with. Does that sound good?
All right, let's set these aside. All right, the next ones we'll do is I'll read them into the record, and then if you'd like to make a summary of them, we can do that. Okay, following a careful examination of the cosmetology and barbering rules and the laws of the following states: Kentucky, North Carolina, South Carolina, Georgia, Florida, Mississippi, Alabama, Louisiana, Arkansas, Michigan, and Oklahoma, it's suggested that the following minimum rules be considered in regards to the Tennessee Cosmetology Apprenticeship Program. Note, in most apprentice programs studied, apprenticeship hours are greater than those required by Tennessee, including doubling required hours for apprentices. Supervising professional. Minimum requirements for applicants seeking approval is a supervising professional for the purpose of apprentice training. Prior to approval, evidence minimum 10 consecutive years work experience in the licensee's field, maintain a current license at all times, satisfactory proof that the applicant has attained the age of at least 26 years, high school graduate evidenced by a certificate of diploma or possesses a general equivalency diploma, and holds a valid cosmetologist, manicurist, esthetician, or natural hairstylist license issued by the board, and has completed a board-approved course in instructor training of at least 300 hours within a period of 6 months, and must have been examined by the board and determined to be qualified to train a cosmetology student, and/or they can pass a minimum grade with a minimum grade of at least 70% the instructor's theory and practical examination. Such examination should be held at such times and places and should consist of such materials or practical demonstrations as the board may determine. Must attend and complete all continuing education requirements currently required for all licensed instructors, consisting in its entirety of teaching methodology and supervising professional shall train an apprentice in only the field in which the professional is licensed, and each supervising professional shall be approved for a total of not more than one apprentice at any time, and shall be directly responsible for that apprentice's training, and the supervising professional shall supervise only the apprentice assigned to them by the supervising school. The supervising professional shall be present and supervising at all times during which an apprentice is receiving credit for training hours. The supervising professional is responsible for ensuring the apprentice's knowledge of and compliance with all applicable state laws and rules governing their profession, and disciplinary actions brought against a supervising professional may result in the suspension or revocation of the supervising professional's approved status. I'm going to go back through here because there's rationale notes for these. Number 3, the rationale for being at least 26 years old. Minimum age for licensure is at least 16 years, therefore, with the 10-year minimum work requirement, minimum age must be at least 26 years at the time of approval. Students and apprentices are required to meet minimum age requirements prior to enrollment in all programs. Then we skip down to number 6. This one again has completed and passed a board-approved course in instructor training of at least 300 hours within 6 months and been examined by the board and determined to be qualified to train cosmetology student. The rationale here is the ability of a licensee to perform certain practical skills in the course of everyday business operations in no way evidences the individual licensee's ability to communicate and impart knowledge, teaching, in a sufficiently credible manner that ensures an apprentice is receiving a proper education amid the distractions of a commercial shop. And then we go over to, well, the next one. Was taken pass with the minimum grade of at least 70%, the instructor's theory and practical exam. The rationale is for the protection of the general public and the apprentice. Any licensee who is acting as a supervising professional is in fact instructing unlicensed personnel. All persons entrusted to be responsible for educating a potential licensee must therefore demonstrate at least a minimum ability to teach. Number 8 is must attend and complete all continuing education requirements currently required for all licensed instructors. And the rationale is attendance at such continuing education programs better equips the supervising professional to identify and meet the educational needs of the apprentice. All students do not learn best in the same way. Number 9, the next one down, the supervising professional shall train an apprentice in only the field in which the professional is licensed. This is because the supervising professional holding a manicurist license is not to be fully qualified to train a full cosmetologist and so on. Supervising professional shall be approved for a total of not more than one apprentice at any time and shall be directly responsible for that apprentice's training. And then the note is a supervising professional is assumed to be operating, working in a business for profit. Therefore, due to the attention required by their own clients, the supervising professional may be distracted or not directly observing their apprentice at all times. At such times, the danger to the public welfare is increased and safety may be jeopardized. In a school setting, a student is not permitted to be left unsupervised at any time, and the instructor is not permitted to serve clients. The next one down, a supervising professional shall supervise only the apprentice assigned to them by the supervising school. This is because as the person responsible for an apprentice's training, only the approved supervising professional is deemed qualified to certify appropriate training has been completed. Next one is a supervising professional shall be present and supervising at all times during which an apprentice is receiving credit for training hours. Note is only the approved supervising professional is authorized to certify training compliance. In addition, apprentices should never be left unattended as their knowledge and skill is not sufficient and potential harm to themselves or the public may be greatly increased. Number 13, the Supervising professional is responsible for ensuring the apprentice's knowledge of and in compliance with all applicable state laws and rules governing their profession. As laws, the apprentice must be taught not only the written laws and rules, but how to properly implement and practice the same. That's for apprentices. Next is displaying a license. Each supervising professional shall display adjacent to their professional license a certificate not to exceed 8 inches by 10 inches in dimension, issued by the approving school college, stating the name of the supervising professional, the name of the apprentice, the program they are supervising, the date in shop salon training begins, the date in shop or salon training begins, and the maximum completion date for that apprentice's program, as well as a passport-style photo of the apprentice and the supervising professional. The rationale for this is inspection of shops and identification of personnel is essential in the interest of public safety and welfare. To ensure that proper identification of the apprentice and supervising professional may be easily ascertained. Apprentice records. The supervising professional shall maintain a daily log. Each day training is provided, signed and dated by the supervising professional, the shop establishment owner, and the apprentice, identifying each practical skill attempted and successfully executed by the apprentice. This log shall include at a minimum the hourly attendance of the apprentice, each practical skill attempted, and the time the practice began, the time the practice was completed, and the rating or the grade assigned for each. This log should be submitted to the approving school no later than close of business on the first day of each month for the previous month. The rationale is tracking of the apprentice's progress is essential, as well as ensuring no credit is given for non-productive hours. The apprentice is entitled to know his progress status. Salon shop establishment owners and managers must maintain records on each apprentice for a period of 7 years. These records must be accurate, complete, and available to the Tennessee State Board of Cosmetology and Barber examiners for inspection at all times. And should an apprentice change salon shop establishment or supervising professional, a notarized transcript of total hours accumulated shall be signed by both the salon shop owner, manager, and the master supervising professional, hair, and submitted to the approving school within 10 days. Of completed training should be included with the examination application. Hours are accumulated according to the actual number of credit clock hours of performance and training in the shop or salon after being registered. Responsibility of the salon shop owner manager to keep an accurate record of the apprentice credit clock hours. Credit will not be allowed for hours completed for which the registered supervising professional is not physically present. And no credit hours should be awarded or considered successfully completed for which no evidence is submitted as to the actual practical skill attempted. Apprentices are not janitors or maintenance workers. Credit hours should not be awarded or considered successfully completed for time spent engaged in such activities other than the extent necessary to maintain sanitary and safety requirements in their permanently assigned work areas. Apprenticeship will be effective on the date the apprentice actually begins training in the establishment with a supervising professional, and approving schools will maintain all apprentice records submitted by supervising professionals in approved establishments for at least 7 years or as otherwise required by the board. Approving schools will report apprentices' progress in its monthly report as with all other students, noting whether enrollee is regular student or apprentice. The approving school will maintain a current list of approved supervising professionals and establishments. Under their direction, shall submit said list as a note on its monthly hours report, noting any changes as they occur.
Requirements. This is for salons and shops with apprentice. No apprentice shall operate any establishment while registered as an apprentice, and the rationale for this is that an apprentice operating an establishment in which they are being trained represents a conflict of interest with their supervising professional. Number 2, no apprentice shall be approved to be trained, no hours or credits be earned in more than one establishment at a time. The rationale is that rules exist limiting the maximum training hours permitted in any one day or any 1 week period. This eliminates the likelihood of students exceeding the maximum hours, as well as ensuring consistency in training of the apprentice. Number 3, each time the apprentice changes supervising professional or approved training establishment, a new application must be filed with the approving school. The supervising professional must notify the approving school that this apprentice is not training in the establishment under supervising professional and submit a notarized transcript of total hours accumulated by apprentice within 10 days of termination of the apprentice. The rationale is that timely reporting of all status changes is imperative if the apprentice is to be able to continue their education without hindrance, as well as the approving school has oversight responsibility under the Authorization Act. Number 4, apprenticeship must be worked and all hours or credits must be earned in an establishment licensed for the apprentice fields of training. Number 5, any salon or shop providing training to any apprentice shall prior to commencement of training, apply for and receive a new shop or salon inspection and submit the corresponding fee in accordance with current application costs and standards. Not intended to create a new license. The rationale for this is in order to ensure that an establishment has the necessary facilities to adequately train an apprentice, an inspection is in order. Number 6, a statement from establishment owner granting permission for apprentice training to take place must be filed with the approving school prior to enrollment of the apprentice and/or commencement of the training. Number 7, any salon or shop providing training for an apprentice shall ensure that each apprentice shall have a permanently assigned working station meeting the requirements of the Tennessee State Board of Cosmetology and Barber examiners, and that station is not shared with any other licensee for the duration of the apprenticeship. Number 8, any salon shop providing training for an apprentice shall ensure that each apprentice is provided sufficient towels and consumable supplies to allow the apprentice to successfully perform all services appropriate to the license. Apprentice training. Apprentice training shall include the curriculum and attendance requirements for licensure in that approved program. Students and apprentice hours shall under no circumstances be combined. A shop and salon shall have no more than 2 apprentices in training at any one time. An apprentice shall only practice under the direct supervision of the supervising professional he or she is assigned to apprentice under. Each apprentice who completes training under the supervision of a supervising professional in an apprentice program and fails to make a passing grade on the state board examination will be required to complete a minimum of 300 hours additional training in a licensed cosmetology school or college and may reapply to take the examination upon completion of the additional training. All requirements for books, kits, supplies for all programs of study shall apply to the apprentice program as a regular school or college enrollment for each program of study.
It looks like, I think the remainder is some examples of some affidavits that were mentioned in the written comments earlier. And, is that correct?
Those are just samples. The hours in the coursework is not necessarily accurate, but just an example of what it might look like.
Okay. Right, the board can consider those comments as well. The last written comments we received are from Mr. Agee. After which time we'll open the hearing up to people that want to make oral comments. The first comment here is that Rule 0440-01-.03 3B2, chemical hours listed as 100 should be 150. And then the next subparagraph in that same rule, the physical list, 600 hours should be 450. I think we fixed one of them.
Well, wait a minute.
End of that same rule, what is the apprenticeship curricula? The rule allows for the development and only guidelines are 750 hours or 50% of that. Does board approve such curricula? Below mentions approval but not specifics. Rule 0440-01-03 3H1IL contradicts vaguely suggested apprenticeship curriculum must be approved. The rule reads, for the purposes of this rule, responsible charge shall identify a licensed professional in a supervision of a student enrolled in an apprenticeship curriculum approved by the board and responsible for all aspects of that student's apprenticeship instruction. What is approved by the board? The curricula? How and where is that specifically stated in the rule on the process of submitting and obtaining approval of the apprenticeship curricula? And nothing defining a clock hour or credit hour. Our apprentice is paid. Amount of time to complete the 750 apprenticeship hours rule leaves this open-ended, and the program could go on for years before completing the 750, thus practicing without a license legally. How long will the state allow for the program to go on without licensing of students? Nothing on overage or requirements to complete program which would limit the student to service an establishment without a license. Nothing states the student must be actively enrolled in licensed school to participate in the program, only that a participating school should be responsible for maintenance of hours and approval of supervisor. Schools must license instructors, but nothing but apprenticeship instructors do not. Let me start over. Schools must license instructors, but nothing but apprenticeship instructors do not need license, just 10 years of consecutive experience. Board approved participating apprenticeship schools. Nothing in the rule about it. How does school know who is providing instruction, supervision in salons or establishment? Does the student pay for apprenticeship hours? Nothing stops the school or salon from charging for the program. There's nothing in the rules regulating the level of supervision the student must receive from the instructor while performing service for the public. Written, the rules would allow a student to be free or inexpensive labor for a salon for an extended period of just time, answering phones, cleaning, etc., while never performing any services. We believe this program is ripe for abuse. We're doing the public a tremendous injustice by discussing the structure of this program before we have even ever had a serious discussion to determine if this program is appropriate for training in this industry. We strongly believe and want to be on the record that this program will expose the citizens of Tennessee to great risk. That concludes the written comments. We'll do the oral comment period, and then after all those are done, we'll come back and comment on the written ones. But as people come up and make their comments, the board can respond to them as they come up. All right, the first one here is Mike Agee. If you'll come up front. Either use the podium or you can sit.
As you speak, Mr. Agee, just make sure that the light's on, that's all.
Okay.
Thank you.
I'm Mike Agee. I am here representing the Tennessee Association of Beauty Professionals. Thank you for the opportunity. Happy New Year.
Mike, could you give us your address as well, please?
My address is 625 Bakers Bridge Avenue, Suite 105, Franklin, Tennessee, 37067, and I'm surprised I remembered it without looking at my card. So
Good
I'm
to see you.
impressed. Thank you for an opportunity to address you. He just read our comments, and I'm not, in respect of your time, I am not going to go back through them. I will simply summarize. As stated, we do have concerns based on our experiences in other states that have similar programs, that this program, if not properly regulated, is open for abuse. And most of our comments lead to things that we think should be in the rules to address that and to limit that. Obviously, we had not seen, tried to listen as closely as I could to the comments of the chairman. And it sounds like he has addressed a lot of our concerns, and we appreciate that. And we would strongly support those fixes that he is proposing. There is one thing that I noticed this morning as I was going through my notes that I failed to put in here that I would like to put on the record. And I couldn't hear, you may have addressed it in yours, but I couldn't hear clearly. And I will take the opportunity, hopefully, to read yours at some point. But if this program is as popular as it is believed by many to be within whatever time frame, the next several months, you could have students in hundreds of salons across the state, which are then extensions of schools. We see nothing in here of where there will be personnel available and required to inspect those school extensions as you currently now inspect our schools. Not only do we not see the people, we don't see the cost associated with that. And we believe that is a real cost that will occur, and we believe those are people that are going to be required because these salons will become extensions of those schools. I will close my comments by just a quick comment about the process. You are the professionals in this industry in the state of Tennessee. You are the people that the citizens look to regulate this industry. General Assembly adopted and passed this program based on the belief that the experts of Tennessee supported it. That debate has never taken place either on the previous board or with this board, and we think that is a mistake. I think that's an injustice to the state of Tennessee. Whether this is a good program or not doesn't matter. It should be vetted and debated by the experts in the state, and that debate hadn't taken place. And we would strongly urge you, we believe you have the power and the obligation to have that debate, and we urge you to do that. Thank you for your comments, and if you've got any questions about our comments, I'll be glad to answer them, but if not, thank you so much for your time.
Next person on the list is Lisa Thomas.
As long as, yes, turn that to you, make sure that the red light's on.
I just basically, I have some questions, more so than comments.
Get your address, please.
Yes.
As you approach, if you'd please just give us your name and address for the record.
Lisa Thomas, 1524 Clingan Ridge Drive. That's Cleveland, Tennessee, 373. Basically, what I was wanting to find out is to whether I'm a salon owner. I also used to teach for Franklin Academy, which is presently, we have some people here from there. And my question is to whether my salon would be, I guess, appropriate for this apprenticeship program. And does there have to be a licensed instructor there? Answer to that, or?
this point, that hasn't quite been decided. It was read into the record just a bit ago. I believe in some of the comments that I had produced, we would be seeking to have anyone who is going to be a supervising professional in whatever field that may be, that they would obtain an instructor's license, and that they would submit to continuing education standards as all instructors do.
Something that also I was wondering about is whether there would be a specific insurance needed to carry to have an apprenticeship program for a salon, an additional insurance, that is. And does the school have to participate with the apprenticeship program? Is it an option for the schools to participate?
May I? Yeah, it's my understanding that the law is the permisory law. The schools can continue just as they're going, or they can, become involved with the program. And I would like to also comment on the licensed instructors. When this law was discussed early before it became a law, there was always that question, who would these apprentice instructors be? And how would they be qualified to do this? And from a commercial standpoint, it was discussed that in entrepreneurial business, as most salons are, 80% of those people fail in their first year of business. And only 2 of them are likely to be standing after 10 years of business. And it was understood by the legislature that this would really be significant in providing a student a good experience as an intern with someone who could offer them not just the instructional, what they would also be gaining in school, but through the discerning customer, that they could actually work with the public in a safe environment with someone who had the 10 years business experience in the related field. With this practical experience, it would enhance the student's education, so that's really where the 10 years came. And I don't really feel like that, and not speaking for the board, but I don't really feel like that it was the intent to bring instructors out of the schools and in salons to actually apprentice one person in a school. I think it was to give that exceptional student another opportunity in learning, because in education, different people learn different ways. And the intern program will offer people that do not learn as well in a school environment the opportunity to become, to have, a new career and job and new opportunities for people in the state of Tennessee.
And just to add on to what Mona said, I do believe that if a licensed stylist is in the salon already, they've already been trained under the theory and under the instructor, and with those 10 years experience, they don't need to have an instructor in the salon to carry on the apprenticeship, because at that point they're trying to get hands-on experience.
There's like 6 people in our salon, and we've all been doing hair for over 10 years, like over 15 years. So I agree. I think it would be really good for the upcoming stylist or nail technician, which brings me to my next question. Does it have to be a full-service salon to have an apprenticeship program?
That's not my understanding at all. And I did want to address, too, your insurance question. I, with confidence, can say that I am an international expert in the field of aesthetics. There's no country in the world that does not apprentice estheticians except for the United States, and that's actually on a state-by-state basis. In my apprenticeship programs with Sedesco International, I have apprenticed several estheticians from France and Switzerland, and my insurance is accepts them as any other employee. So there's nothing really, there's not a rider on the insurance as well. Yeah.
Also, if someone already has, say, the required 750 hours previous to this, could they come back and actually do the exam for the theory, like what was said before, and then be an apprenticeship program for the 750 hours additional, like before this law has taken place?
How long has it been since they had their 750 hours?
Not long, within a year. So
I don't know, I'm still confused about what the curriculum is for a traditional student as opposed to an apprenticeship student who is getting just half of the hours. So if they've gotten 750 hours traditionally, I don't know if, this is cart before the horse.
Yeah, to me, I think at the schools that 1,000 hours is when you really see the difference in your students. They catch on more. And, to me, I would like to, I guess every school can do what they want to do, but maybe you could keep them to 850 to 1,000 hours and then let them apprentice the last 500. That way they've gotten all their tests and everything.
Well, it's already set that they just take 750, but I'm concerned, her question was if they've already gotten the 750 hours, can they jump into this apprenticeship program? Well, are the hours going to be, is the curriculum going to be different for these apprenticeship students from the very beginning for their 750 hours than it would be for a traditional student?
I would say it would have to be, as a school owner, if I'm going to have someone who's ready to leave the doors at 750 hours, I have got to have a specific curriculum to teach to those students that covers not just the theory, because there's not 750 hours worth of theory required. I have to have enough hours to also teach them the practical assignments, and then that comes into a division of what are those practical assignments and how many hours per assignment, or per skill, I should say, should that be. So I will agree with you in the curriculum. We're absolutely cart before the horse. I think that has to be hammered out here.
My next question is there a tuition due to the salon for the students? And if so, who decides? The salon, the school? Just the other research that I've done for other apprentice-friendly states, there is, but, I don't know how this one is going to be.
If a student come to school and paid for the school, they would probably want to just finish at school if they were going to have to be paid again at a salon. That'd be each choice for the student.
I think we addressed it in the last board meeting that would not be regulated. That would be like an over-regulation of what it's at. We just have a lot of things to decide. And, for all purposes, well said on, the schools are going to release and graduate. There is going to have to be some kind of common ground in the curriculum. But I thought we discussed that we weren't really going to regulate that we had a curriculum, and that curriculum would, if the school accepted someone who was going to apprentice a student, that would be a relationship between the school and the student and the teacher or intern supervisor and so on, that I didn't feel like that we were moving forward to regulate that piece of it.
Were you specifically asking about the fees? Is that what it was?
Yeah, basically, because I'm just confused about it. If they're going to be
Join the club.
I understand. If they're going to be spending, I guess, 750 hours in the school and 750 hours simultaneously at a salon training, in order to, go through the school quicker, then I was wondering if the tuition would be the same for the school, even though it's half the time in the school.
Right, I
If
had
there's
that question
any
as
kind of-
well.
Well,
And I wondered, but you're still gonna be on that school's roster. You're still on the roll. They're still responsible for you. They still have to make sure that you're, and they're having to spend time to verify your hours as an apprentice. And so if I'm a school owner, there's not much break in price because you're still in my,
well,
my
in most
program.
of the contracts, it says 50% and over, you owe the total amount of the school tuition. So there won't be a break for them.
Okay.
Well, it wouldn't be my school, I don't know, but yours, Ron.
It's in
Same
every school
thing.
that I'm aware of. I think one thing that we should think about here just a bit is when a school, which is choosing to participate in the apprentice program, a school does not have to participate in that. They do not have to offer it. But if they so choose, they would have to develop within their own business model a plan for how they're going to make that financially feasible to themselves. Some schools I can see would charge that student whatever their tuition, X dollars, would be, and part of the arrangement, because the schools, as I understand it, will be approving the training personnel and the establishment. So they would make some arrangement with that establishment, perhaps on behalf of the student, perhaps not. That has to be decided. In that case, I have read in other state rules that different shops are not allowed to charge an additional fee to that student. Others, they can. So that is a choice.
Well said. The real word, I think, is choice. There's going to be a lot of choices here. So I think it's a new economy for the schools to have another way of operating their businesses, another economy for well-educated, successful salon owners. But again, it's a choice. And so I think that as we move closer to it, if we're trying to regulate it, that would be a terrific mistake because it is commerce.
Can I ask you a question, please? Robert, is there a legal issue with labor as far as compensation the other way?
The specific question?
Question is, they were talking about whether the student or apprentice would be being charged a tuition or a fee. And as a salon owner, I'm sitting here saying, now, wait a second, am I going to be charged at least a minimum wage or to where I got to pay the person who would be an apprentice and not be able to do X amount of work?
We're not really anticipating regulating the business part of it. I think the chairman has looked into the other states, as you said, how they manage that. I would hate for us to affix that in a rule on how that's done.
On the side, Frank, if I understand you, are you referring to the salon paying the apprentice while they're on
Yes.
staff? I believe the statute says that that would be an arrangement between the salon and the apprentice themselves. That's in the statute.
Okay, so same as the other way.
However, there have been a number of lawsuits around the country where people have apprenticed in huge companies and felt they were underpaid and were awarded large settlements for the time they spent as an apprentice, even though they were being paid some minimum wage. So again, a salon, a shop, an establishment who chooses to take on this responsibility of training is going to also assume liability for that. You asked about insurance, and I would further say about your insurance that you would probably need to talk to some legal or insurance professional that you trust because each person, each owner should assess their own risk abilities.
I guess my last question would be, is there a date, a guesstimated date that we're looking at of goes into effect, I guess, is?
Well, from after the hearing, all the comments have to be addressed. Answers that the board gives to questions made by the public and the rules themselves will all be sent to the Attorney General's office. The AG's office will review what it is, make comments back to me that I'll address if there are any. Then after that, it goes to the Secretary of State's office, who's responsible for publishing the rules. 90 days after that date, they become effective. And at some point during that time, the Government Operations Committee and the legislature will want to review these rules too. They have say over whether they become effective or not. So after the Attorney General returns them, 90 days after that, they will become effective. So it's probably summertime.
Thank you.
Next person we have is Ryan Hurd. Is that correct? Your name and address, please.
Yes, sir. I'm Ryan Hurd. I'm at 780 West Avenue, Crossville, Tennessee 38555. Good morning still. I'm very fortunate. I had a lot smarter people talk before me, so I don't have to say a whole lot, but just kind of sum up what my concerns are as a licensed cosmetologist, as a school owner, and as a professional of 22 years. I guess Mr. Agee and Mr. Gillihan made most of the points that I was concerned about. Just re-emphasizing, I feel like it should be, it's appropriate that a licensed instructor be there for a 750-hour program. In the aesthetics and the manicuring and the lesser of hours, I don't know how much of a need that would necessarily be. I'm not really proficient in those categories, so I can't give a solid opinion in my. But in the cosmetology side, it being 750 hours, and we're still going to be required as a school to have a licensed instructor, and then you're going to allow this, in my opinion, some of the most important practical portions to be taught by a licensed professional who has their own opinion on how these things should be taught. Now, take it back, if I had the opportunity to apprentice under Frank Gambuza, I'd probably still do it today. But that's not everybody that's going to be doing that, therefore that's a concern. You're going to have salons that, in my 15 years as being a distributor sales consultant and as owner of a beauty supply company, seeing a lot of stylists and a lot of salon owners and helping them, mainly in hair coloring, because that's where I'm proficient in, but in other avenues as well of helping them to increase their business ability or increase their knowledge. Absolutely scares me to death that person would be teaching one of my kids. Scares me beyond belief. One of the reasons I even got into the school business, which is I did better in the beauty supply side of it than you do in the school side. But at the same time, 15 years of teaching professional stylists who have already been through school, own a business, and doing well, and still teaching them what I find to be the fundamentals of certain aspects of our business, coloring, cutting, whatever the case may be, and having to teach them, I decided that at that point, a school was probably a real good place for me to go to next. If I want to make Mom and Dad always said, if you want to fix it, then go fix it. So that's what I wanted to do. I'll just open up my own school, and I'll teach them the way that they should be taught, and then that way they're better prepared when they go out into the world and do better. Now, granted, every school owner will tell you 1,500 hours is not a substantial amount of time for us to get across everything that we need to for them to be successful, but we do the best we can with what we've got. Now you're going to take a time frame of that we have trouble, and you're going to cut it in half, and you're going to give the remaining opportunity of education to someone who may or may not have the same, ideas on your education as a school does. Now, not all schools are to the caliber of the people that I associate myself with, but at the same time, they're still regulated very well on what they're supposed to be taught. And word of mouth works. If you're a crappy school, then you don't get students. If you're a great school, then you have waiting lists. And that's just how it works. But this concern of that happening. So I agree. One of my statements that I wanted to make that I thought about was that the theory test after 750 hours is It's a beautiful thing. I think that needs to happen. That way that there is at least a little bit of a sigh of relief on my part as a school owner saying, okay, they at least know what I taught them. And I can be confident of that because they passed the state board's test for that. So I'm great with that. I do believe, I agree with Mr. Gillihan, they need to have some form of a certificate that explains to the consumer that they could potentially be worked on by a non-licensed individual. Now, as a school, you make that very relevant when you walk in the door. Every door has to say that all services are performed by students and supervised by licensed instructors. That helps us also from an insurance standpoint. That covers our butt, that if you come in and we turn your hair green and it falls out, you took that risk when you walked in the door of a school. The consumer's not going to be so kind to that happening to their hair if they walk into a salon and have that. So there will be insurance regulations. Now, talking to family members in that industry, but not by any means, that's my own research. I'll talk to Sissy and ask her opinion. And she said that is a big concern or a big issue that can't come back, whereas we are protected as schools. The salon will not be protected in that manner. So something I want you guys to really consider as well. That needs to be looked at because that can hinder at the end of the day, what our goal has always been is to protect the consumer. Okay. How long is the apprenticeship program allowed to take? We, as a school, students only allowed to take so long to go through your program by your own contract and then by the own laws of the state or by the federal government. So we need to have some form of a end of time frame that they can do it. For example, in a school, it's 150%. So you have 150% of the time frame to finish the program and then to take your test, to graduate at that point. So it gives you a deadline. There needs to be a deadline, because I know that if you worked at, this sweet little old lady shop around the corner from my school, she'd just keep you there forever, rolling hair and sweeping up whatever you needed to do. So there's got to be some kind of a deadline, in my opinion. And then, let's see. Actually, I think that was all I had on my notes as far as what wasn't addressed that I felt was a concern. So, again, and this is, I'm a barber school owner. This rule does not affect me. I'm a licensed cosmetologist. It does affect that license. But I'm here more for the purpose of our industry and what concerns me in our industry. School-wise, it doesn't affect my school because right now we're just talking about cosmetology schools. But at the end of the day, it is something that the consumer who sits in the chair and could care less if you're a licensed barber or licensed cosmetologist, they don't care, nor do they usually even know, unless you go to a traditional form of a barbershop or salon. So outside of that, it's very concerning on my part of what the consumer and what could this eventually ramifications it could have all the way around. So please just take your time to think through exactly what the rules need to say and exactly what needs to happen, because you are our voice and you're the only voice we have. So appreciate your time. Thank you.
Can I ask an opinion
Yes, ma'am.
from you? I'm hearing a lot of concern from school owners like yourself. I'm trying to understand. I'm a business owner. I'm a barbershop owner who sits on the other side where Frank is of how does this impact us. But for the schools, do you see this? It doesn't sound to me like current school owners see this as a positive thing for their current business. So with that being said, and again, that's what I'm hearing from folks, would this be a new program that your school would have to create specifically? Is that the way you're looking at it? Or are you with the understanding that these are going to be new schools created just to coincide with the apprentice program? Because I haven't heard an existing school say, we can't wait to roll this program out and we can't wait to do this. Have I missed that?
No, you haven't.
Okay. I'm just trying to understand who are these, because apparently the onus is still on the schools.
Right.
Is what I'm hearing. I mean, they're ultimately responsible. Who are these schools.
Right, and I guess, I don't know of one. All my communication with the school owners.
Traditional current schools is what
Yes,
you're
ma'am.
saying.
Yes, ma'am, with who's currently licensed in the state of Tennessee to give instruction. And those people that I've talked to are scared to death, simply because of, not just from a state regulatory standpoint of we're regulated and we have to follow the rules. From a federal standpoint, if we're an accredited school, what we have to look at and the ramifications from that standpoint. And not that you don't have to be accredited and you don't have to have Title IV funding to be a good school. I know a school owner that has that ability, and she does fantastic, and she's still scared. It's because what it boils down to is the regulatory standpoint of what the state sees, and then what all the other regulations that we have to follow along. There's a lot of contradiction to it. So from a business standpoint, from my numbers, I'm not as worried from a numbers standpoint. Again, I'm a barber school, so I'm really not worried at all. But
Not yet.
Not yet, not yet.
Will be.
But as long as we can,
next.
as long as we can continue showing the legislature that they're the last people that need to make a decision on a consumer-based business without consulting the boards and asking them their opinion, then maybe at that point they'll come to the board and they'll ask, should we do this for barbers? And we can have a resounding no. But whatever your decision is, the curriculum that would have to be made is going to be challenging, because then as a school we have to say, okay, well, we've got to teach you this book that generally it takes me about 40 weeks, 38 to 40 weeks, depending upon vacations or breaks, to get the entire book taught to a student. Now, that on an average of 35 weeks, that's well beyond 750. So I have to find a way to get a student taught well enough on the theory portion in 750 hours, which will be totally different than the way I teach any other student that's there for a traditional 1,500 hours. Because those students I have multiple weeks and multiple
My
hours.
question would be, what would your incentive be to take a different type of student?
At this point, I don't see any. I'm really crossing my fingers that there will be someday. But at
Now-
this point, there is nothing that's going to give me any real desire to go through the extra energy and effort and work to create a curriculum that I'm responsible for, that I can't put my thumb on every hour of.
Well,
I don't like I said, it's and only because I've known this man not on a personal level but on a professional level for many years, that I would be able to feel comfortable and confident knowing that Frank's going to run that program the way it should be. I don't know his staff that's actually doing the nuts and bolts of it, though.
Well,
And
keep
so-
in mind that it is a choice for the school, so you don't have to do it.
Right.
So if you decide that you don't want to take on that responsibility, you don't have to.
Right. No, I agree.
Yeah.
Yeah, I have a comment to what you said. Maybe this program will, in reality, work for the schools that operate in multi-states, not just Tennessee, or new schools that choose to open with the sole purpose of being an apprentice school.
I guess I'm a business person.
Yes.
So my brain is
And there-
immediately
and then
going to
maybe
how do you
yeah.
schools
I
are
think it'll- I think
a
it'll
for-profit.
open- yeah,
This is
I
not a
think it'll open
nonprofit
a
situation.
new avenue for entrepreneurs that want to pursue apprenticeship schools.
And Amy, if I could interject regarding why would he consider it, we at the board office get calls from students who want it.
They will
So
find it.
Your students may dictate a new school
There's a
needs to open to
demand
do
there.
that. Parents and students call us and they're ready why the law didn't take effect, and we explain we're working on the rules.
And is that financially driven? I mean, what is there? I'm surely curious as to
Why the calls or
Mm-hmm.
what their interest. I think it's hands-on. This is a new generation that's used to hands-on. They want to get out there and start working. Just reading the book isn't that interesting, and I could go on, and that's not what I wanted to do, but we get calls from the students and parents.
it's helpful.
Yep.
At a curriculum level too, to my knowledge, every single school in the state has a clinic floor where they do hands-on. So I've heard that argument from other students when they've come in asking about the apprenticeship program and their enrollment, and the real simple answer is there's a salon right around the corner of this. You're in a building that has a salon. So your hands-on work is going to be regulated by people that are teaching you principles instead of in a salon being taught an opinion of someone based upon the business that they structure?
Well, a lot of times I'm a salon owner myself, and I have had students come to me asking about the apprenticeship in the salon, and their biggest complaint is that they didn't learn, because once they go out onto the clinic floor, they continue to do one thing that they're good at, and the instructors keep putting them on, let's say, a roller set. So they do 50 roller sets in one day, and they need more hands-on and natural hairstyling. So now they come to a salon, and the salon owner have to make the decision: do I want to take this stylist on that, professionally, and teach them all over again what they need to do to be successful in that particular area? But they can, hands down on a roller set, because that's what they've done the whole while they're on the clinic floor. So I think that's where some of the demand comes from.
I think, Amy, that it would be a mistake for any of the members to perceive this as a case where schools don't want to do this because they think it's going to dip into their pockets. I think any good business, any good school is going to see opportunities wherever they'll present themselves and try to take advantage of a good business opportunity. I think what I would rather have considered is that when as Ryan said, when a student comes into a school, there is a clinic in that school. They do have the opportunities to work on clientele. Yes, sometimes students do a lot of repetitive work, but repetition builds muscle memory, and that helps increase skill as well. But from another point of view, students like to do what students like to do, and if they don't like to do a pedicure, for example, and they're in a shop that perhaps doesn't offer pedicures, that student is still going to be required to pass whatever testing standards are required to do any of that skill work. So they're actually, in some situations, if we're not really, really careful with curriculum, they're going to end up not being exposed in a sufficient manner to a full skill set. Those who are in a full cosmetology program, for instance. I'll say again, I think that any good business will look for opportunities to make money, and they'll find a way to make a program work if they can see a profit in it. But don't lose sight of the fact that many of the schools out here who are struggling with this and who are not against a program necessarily, but they just want it to be done correctly in a fair and equitable way that's not just cited to the school, but actually ensures that that student receives the training that they are paying for. In a setting where a student is just doing one thing every day. In my own school, I can tell you, we do a lot of repetitive work, but that repetitive work has developed tremendous skill, and the graduates from our program are evidence of that. So without repetitive work in each skill set, you lose something. Students typically don't like to read a book. They don't like to sit down today. That's a challenge for schools to address educational opportunities in a broader manner, to be a more dynamic educator. It's not necessarily a statement that, well, students know everything in the book. Test results show that they don't. And speaking from my own school, it is a struggle every day to make sure that my students have actually read assigned work, completed those assignments, and trust me, we stay on that every moment of every day. At no time is a student in a regulated school left unattended. If an instructor is sitting there literally watching them do everything they do all day long, ready to assist and ready to instruct and take them to the next steps. I think that some of that can be lost in just a apprentice program where we don't have pretty good regulation and oversight of those providing the training. It's not necessarily a school thing. It's let's take care of the students, because that is going to in turn take care of the schools.
So I guess my question, maybe this is where Nina comes in, and I mean, I think this is very interesting.
Yes, I
But-
do agree with Nina that a curriculum should be set in place for, some of the concerns
But what,
that.
what are those bare minimums? I hate to say bare minimum, but what is if this person is spending, if the student is spending 750 hours, and I don't think that's been determined completely, but is that the time that you're in the school, and what are they responsible for? Is that what we're trying to nail down? And then once they go off into a partnering salon, what is that curriculum? And there's obviously been quite a bit added that we heard today, which is very helpful on how that will be facilitated and turned in, but are we trying to get down to the nuts and bolts of what's included in the schools and what's included outside? And then, to Frank's point, how or if apprentices are paid would be completely outside of.
That's been decided. We're not
keep in mind-
regulating
We're not,
that.
and that's
We're not doing
that's,
that.
well, no, and I agree with you, Mona. I just want to be clear that once that apprentice would go into the salon, then.
I think if you understand the law was passed and we've been asked to set forth rules, I agree with the curriculum. I mean, it's we have to know what we're actually with the students in mind. Aside from the 80 school owners in the state of Tennessee, there are 60,000 licensees, and their parents and the students are calling the board every week. I have people call me about this. When can we start apprenticing? I have a drawer file this big of people who would love, and I'm complimented they would even think that I'm going to apprentice someone, but I don't even have time for that because I think it's very, very important when I apprentice someone with Sedesco that I have set aside that time for that 4 to 6 months that I'm going to be with them and they do get a good education. And I just don't think you're going to find a 10-year professional that is going to just let this program run amok. I think that these are committed people that are going to work with the schools, and curriculums and programs will be developed. It's, I understand a little bit of the fear of the 80 schools, but I am a business owner and an entrepreneur, and I look at it as a business opportunity for everybody. But the end result is the student who comes and files an application with me and says, I've never seen a microdermabrasion machine. I've, never applied a chemical to someone's face. They are so below the mark and they're so underserved by cosmetology school instructors. They are trained as the minimally competent for that PSI exam. And this is a chance for the estheticians and the manicurists and the natural hair people to finally break through what all these beauty school owners want, have our own schools, our own curriculum, and be able to work in careers. I have been in 13 beauty schools since I got out of school 25 years ago. 13 beauty schools last year. I've never been in a barber school. Would love to see all of this instruction and what's going on. But the 13 beauty schools that I've been in have been so different. It's almost like it's unregulated. So I can see your fear because you know what your competition is and you know what you're up against. But at the end result, when it's that student that cannot walk in my door with a resume and an application and look forward to having a career, then all those schools, all of us have failed them. And I didn't get on this board and come to 3 hours every month, 3 hours home, 3 hours back, to fail those people. We have to move forward, people. That's just it.
But on the other side of it, you're talking about the curriculum. There is no curriculum right now for this program. There is no curriculum.
There's a curriculum for the student. And I didn't understand that we were going to mandate between the curriculum established for the schools. The schools, the onus, yes, is on those schools to work on a program if they decide to accept an apprenticeship student.
All it says right now is 750 hours.
Okay, I have
And
a
that's
point to make.
750 hours of the.
I didn't understand that we were going to regulate that.
Or 50% of the hours.
That's the law. We aren't going to regulate, I understood, what the schools were going to work with the apprenticeship programs.
We have a question from Ms. Barger.
Okay, so I think there's
So do I.
one thing we do agree on, that everyone seemed to like the idea of taking the theory portion of the exam before they are allowed to apprentice. I think everyone felt pretty good about that. So that would dictate what the curriculum would look like while they were in the actual school building. and it would be to master the theory portion and learn the theory behind each skill set and all that. So that would maybe a jumping off point.
And to do that, are they not gonna have to change it where they don't have to complete 1,500 hours to take the theory test? Because as it is now, you have to complete the 1,500 before you can take the theory.
Well, I think if we agree on that, that's something that it'll be written into the rules.
Recognize Frank.
I think this is a recipe for disaster if we don't regulate what the salon has to do as well. All right. I currently have a 50-week formal program in place that's after somebody graduates 1,500 hours. And I guarantee they're calling and saying they're wanting to rush this thing up. I mean, these are kids who grew up with remote controls and microwave ovens and give it to me now. For the most part, I mean, my kid got a trophy for coming in 7th place. I wouldn't even let him take it home. I mean, you know, it's ridiculous.
Good for you.
All right? So in a 50-week, 2-hour-a-week program, it's 100 additional hours of one-on-one training, or it could be up to 4-on-1 after 1,500 hours. And I think, Mona, to your point, I can give you somebody and you train them beautifully. I know your level of quality. That's the upper 10%, the upper 20 maybe. The other concern is if we leave loopholes and we don't button this thing up tight, it will run amok, because I can guarantee you people are going to beat the system where it's left. So I feel like there's too much divide between whether it's going to be a school or a salon. If we don't work together on this and make it where the school passes the baton over to the salon and we're all on the same page, it's a recipe for disaster. I'm all for the concept. I just feel like the speed of it and pushing it through without having some kind of formal understanding of curriculum both on the school side and the salon side is a dangerous situation.
Well, I was thinking that maybe the salon could, in conjunction with the school, give a certain curriculum for the salon to go by in reference to hands-on and practical, and they go by that. That way they're still on the same agenda per se, but still getting that salon experience and salon operation hands-on with customer service or something like that.
Well, I pay them now. They're paid while they're in class. They're getting paid $8.50 an hour to be in class, and they're not doing towels. They're not being janitors. They can't even cut their way out of a paper bag, and they think they're ready for a chair.
Yeah.
So not only do they want to hurry up getting out of school, they want to hurry up and get on the chair when they are so unprepared for it. And I know this has been passed, but I think the one thing, the topic on the table is curriculum, and I think that piece is imperative.
The chair will recognize Ms. Coppinger and then Ms. Roxana. I believe you had something.
Okay, well, I disagree with you, Mona, when you said that at the end of the day, we don't want to fail the student. At the end of the day, we want to protect the public. We want to protect the consumer. And so if you're very qualified, which you say you are, in your area, then you would be a great supervisor. But where did all these cosmetologists go to school? They went to the schools that you're complaining didn't prepare them to get out, and so they've gone to these schools, and now they're going to be supervisors for these students who really need to know their stuff. So I don't see that. I'm like Frank, that there is probably 10% that top notch, but we need to protect the consumer, and we need to make sure these kids are prepared. And y'all see firsthand that there's a lot to it, and I just have one more thing I want to ask Rob. Public Chapter 447, this was approved and passed when there was a previous board. This is a new board. The previous board, since it was passed at that time, was charged with the responsibility of making the rules for this new law. Does this board have to take on that responsibility as well? Are there any, I hate to say this word, loopholes where, I'm sorry, we are being forced to
do this.
And I'm just wondering, help here, help. This is a new board, a new day.
Nope,
I
we've
believe
been-
we can do it, though. If we work hard and decide to have meaningful, and if we're all working toward the same goal, we can do it.
And yeah, Nina, you mentioned something about the stylists coming from the instructors that we claim didn't teach us anything. I think that's where the 10-year experience come in, because a lot of times a student can go in and get 1,500 hours from a school and then turn right around without any experience and become an instructor. And sometimes that supervisor of a stylist have way more experience with 10 years under their belt than an instructor that has never been in a salon.
Ms. Granger, I actually have a salon that I'm a consultant as well. I've consulted with a salon who has 3 stylists that have all been in the business for over 15 years. The week before Thanksgiving, we did a fundamentals of basic coloring in one of the most successful salons. They didn't know what the color wheel was anymore.
Well,
I agree with you that the problem starts at the school level. One of the reasons I wanted to own a school was to eliminate that opportunity, but then there's also that real concern that at the end of the day, those same ones, they may not know exactly what they're talking about anymore, even with those years of experience.
Well, that may come under another issue that we may have to discuss, where instructors may need to take, stylists, professional stylists may need to take continuing education classes as well. So I do understand your concern.
Gary's going to recognize Roxanne.
If I could, just in, so that we can get done, I have a thought. We've got one individual signed up. We couldn't make out the name, but we'll call him in a minute. And then Representative Parkinson is also signed up. We've got, that means only 2 more on the list. I wonder if we can get through those 2 names just to hear everyone. That way also, if the public wants to stay, of course, they're always welcome to. We can continue and really pinpoint everything we need to address at that point, having heard everything.
Right.
If that sounds, did you have anything else?
No, ma'am,
Mr. Hurd?
thank you.
Okay.
Appreciate your time.
All right.
I think this person's name is Boyd. Is that? I'm sorry, but it's really.
If you've signed up to speak and haven't come forward yet.
Besides Mr. Representative Parkinson, who was the other person that signed up to speak? Are they still here? May not be. All right, Representative Parkinson.
Thank you. That was actually my alter ego that signed up, but he left.
Thank you.
First, let me tell you thank you so much. I am the author of the apprenticeship bill and the freestanding natural hair care, natural schools and schools of aesthetics and schools of manicuring. Also, I want to thank you for your service. You know, I know this is we're in a transition in the cosmetology industry. And I appreciate everything that you guys are doing. And this is very healthy dialogue. And so, you know, I don't take offense to it. But I do stand strongly by the legislation that I presented that we passed unanimously in both houses, publicly signed by the governor. The governor and myself, we want to get people to work as soon as possible. We have some, you know, our cosmetology laws are antiquated. You know, there's going to be more. A lot of cleanup coming, and we're looking forward to, you know, a bright and robust cosmetology and barber industry. I grew up in the salon. I didn't just show up and start talking about hair. My mother's a stylist. I was supposed to be a stylist. You know, obviously I went a different direction somehow, some way. But one thing about it is I truly appreciate those that are in the cosmetology industry. I know your value and the value that you add to our society, and from an industry standpoint and economic development standpoint, I truly understand that as well. And so I'm here to answer any questions about the legislation and the intent. If anyone has any questions, I'm happy to answer them.
Ms. Parks, I have a question. The law was passed with the previous board, am I correct?
It was.
And now it's our responsibility as the new board to put forth the rules. Am I correct?
It is, and let me talk about that very briefly. You know, in drafting the legislation, you know, we could have drafted the rules inside of the legislation with no input from the board itself. But I felt that it was imperative that the board was involved in the creation of this of our new direction. Not just that, it's not true that industry professionals were not consulted in this. There were tons of industry professionals and members of the board that were consulted as this legislation was being drafted. The legislation didn't just pop up as an idea. It was cultivated actually probably about a year or so before we even brought it to the state legislator. And one of the previous board members knew about it, because it was, the idea was in the media, and they actually contacted me about the the idea. So board members knew about it. And let me respectfully rebut one more statement that was made by Mr. Agee, who was my friend. And the organization that he represents is not the makeup of the entire industry. I think there are approximately 60 or so school owners in the state of Tennessee, or maybe a little bit more, a little bit less. But there are 45,000 licensed individuals. That's the industry, and that's who I represent. And those individuals say they want apprenticeships. Those students want apprenticeships, and it is my job as a legislator to represent and give and deliver what the people are asking for. So with that, I open up to any more questions.
Well, Mr. Chair, I don't have a question, but I was on the previous board, and the majority, I don't know how many people on that board actually knew about this. The majority of that board did not know anything about this until after it was passed and became law. That is fact. And what the law, what started out to be, was something totally different. And I know as the laws go through and, they're worked over and played with and fooled with, then this one was amended. And at the last minute, the apprenticeship program was put in. And so I know some people knew about it, but the majority of that board had no knowledge of that law till after it became law. I just wanted to say that publicly.
Well, thank you. If you don't mind me responding to that. While I respect, your position on that, the fact that I know is that as this law was being developed, and yes, you're correct, in the lawmaking process, laws, they evolve or sometimes they're diminished in some aspects as the process is going on. And I do know that members of the administration came before this board and let the board know that the new laws were coming. It wasn't in its completed form at the time, and in the posture that it is in now, and you're correct with that. But I also do know that former members of this board who were sitting at the time knew about the law and the apprenticeship side of it and where we were going with it. Now, whether or not they chose to discuss that with the other members of the board, obviously not.
No, sir, there's a sunshine
right.
law. No, sir.
Right. Well, but you can discuss it at a board meeting. And so there were board meetings, between the law being drafted and the law being finished. But my job is to pass the laws, not necessarily to go before the boards and commissions and present the laws. And I'm not saying that, and I'm by no means in any derogatory form. I'm just saying, my hands are full in passing the laws. And so there are other individuals that are charged with, laying the laws out before the boards and commissions. And let me address one more thing, and thank you for that also, and I appreciate your comment on it. Let me address this also. We have an issue, a challenge in our state with instructors. Instructors, in a lot of cases in these schools, instructors are are becoming licensed as cosmetologists. And then when there's no job placement, they immediately turn right around and go back to school to get their instructor's license for 300 more hours. So in that process of getting that instructor's license, not even becoming a licensed instructor at the time, they are teaching the classes that they have just come out of and graduated from. Now, this thought went into the presentation of the legislation. That's how we came up with the 10 years experience, and why we came up with the 10 years experience. Because this is a practice, a common practice in our schools in the state of Tennessee. Now, I can tell you this moving forward. we will be looking at legislation that will require instructors to have some experience before they're able to apply their instructor's license moving forward. But this is a real issue because what you have now is students teaching students. And so if we want to really place a blame or look at where the decline of the cosmetology industry is, or why we're not competing with states like Georgia, states like California, New York, Michigan, and other places that are leading in cosmetology industry, is because we are allowing our students who have just become basic licensed cosmetologists to teach the other students that they were in class with. And that's an issue. That's a problem.
What are your indicators on leading? How are you defining that?
I'm looking at it by economic development, by the revenue
Just
generation.
pure dollars,
Pure
of
dollars.
top line revenue
Yes,
in
yes,
the
ma'am. Because
business.
people will spend their money where they feel that you know.
I'm just
people-
curious. I mean,
Yes, ma'am.
everyone measures
Yes,
it differently. I didn't
Yes,
know how you were comparing us versus other states.
Yes.
Thank you.
Do you think that they will up the hours for someone to become an instructor? I think 300 hours is not really enough.
And you know, and I take that input, and I would definitely, you know, actually I look forward to you consulting with me on it as we draft this legislation. But I think the biggest thing is the fact that these instructors have no experience, you know, and they're teaching classes, you know, and that's not in all cases in all schools now. So let's be clear on that. And let me say this also on when it came to 750 hours and 750 hours, you know, we went right to the Gould's website to look at what their book time, their classroom time, their hours were. And they were 600 hours. 600 hours. And so we said, well, why don't we take that a little bit further to add more classroom time before these individuals get out there on the floor with a 10-year tenured, experienced stylist that has been in business, been licensed, knows the ins and outs, and can deliver the final part of that education. Now, I agree that the theory testing, you know, at the end of that 750 hours, I think that's a wonderful, wonderful idea. And maybe we should even look at possibly delivering that part of the licensing, you know, after they've tested, and then let them go on to the practical part in the salons, and then begin to deliver that part of the license also.
Like when they are doing their 750 in a salon, okay, at our school we take 1 day a week, one day a month, and just do nothing but state board practicals, okay? So will they be prepared for their state board practical in a salon?
That's the absolute goal. That is the absolute goal
there's
here.
just so many things that they have to do, like the finger waves and
Yes, ma'am. That's
all
that is the absolute goal here. The goal is not to just sit them in a salon just you know, because it's pretty. It's really to get them in there under, you know, experienced individuals that can teach them. And also, here's what's vitally important too. This is where, and I don't want to speak for the governor, but I think this is where we really locked in at. You know, the fact that they're in a salon. There's an opportunity there. Let's talk about job placement real quick. There's an opportunity there for this salon owner now to vet this individual. And not only the salon owner to vet this individual, but the individual to vet the salon owner and to see if this is a match. Is this a good place for me to work? Is this what I really want to do? And so in that, we think that we'll increase our job placement. With that, we think we'll be able to help or begin to build a clientele for these students to come out immediately and go to work with, and we want to get these students to work faster and you know and better, actually. And it's no knock against those schools that are doing the right thing. But picture this though. What about that student that comes out of the high school cosmetology program, and in a lot of cases, the schools would not even accept that individual, would make them start their hours completely all the way over. And that's, in my estimation, due to financial aid. Now, that student should not, after doing so many hours in cosmetology in school, they've obviously got on the trick that they want to be on starting early, which is a great thing. But they should be able to go an apprenticeship, do an apprenticeship somewhere and finish out their hours if the schools do not want to accept their total hours.
our school does accept all their hours they bring from any vocational school.
That's awesome, but a lot of them will not.
Yeah,
a lot
they
of them
won't.
will make them go and get a $15,000 or $20,000 loan that they're
Yeah.
stuck with to start their hours over.
Yeah, and we adjust our rate too for them.
Yes, ma'am.
And a lot, you were mentioning how would they be state board ready in a salon. Well, maybe the school and the salon can work together where the salon actually go by a curriculum.
Well, there's
where-
a PSI that, everybody can print the PSI off.
Oh, yeah, that
You
too.
know, they're just going to have to push it for them so that they're ready for their state board.
I'm pretty sure if the salon is participating salon, they're really going to be adamant about that and train them the way they're supposed to be, because they're going to have to be licensed eventually. It's going to be an expiration date on the training.
I just don't want to see somebody going to their grandmother's house because she's got her license and I can just hang out there and get my hours, and that's the only thing that worries
Oh,
me.
that is definitely not the intent of the law, of
Right.
the legislation. Absolutely not.
Right.
How would you guard against that?
Well, I think that's where that comes into rulemaking. In fact, it would have to be a salon, number one, and you can't operate it. You illegally, you cannot operate a salon in a house.
You can.
Legally.
Yeah, you can.
Yes, you can.
Yes, you can.
You sure can.
You
You
can
can do
have-
it in a double wide if it's tied down.
Okay. Well,
Yeah.
thank you
Do
for
you
that.
see what I'm saying?
What and what I'm referring to, and is the kitchen stylist.
Right.
So that's
Right.
legally you cannot be a kitchen stylist.
No.
And that's what I'm referring to.
Because even in the house, you still have to be inspected and such. So
Right.
you just
Right.
can't
And
say,
that-
hey, come sit, on the floor of my couch or whatever.
Right, and that's the case, and with anything, I would caution us to be careful with this is a change. This is a change, and anytime there's a change, there's concern, but I would caution us to be optimistic and look at this thing from a positive perspective, because I think and a lot of us think, not just myself, we think that this is going to really, really help us to move forward. And remember, to those schools that this bill is permissive, which means that you do not have to do this if you're a school owner. If you don't want to, you can choose not to do it. Now, what happens is this: I'm a Democrat, but this is my Republican side coming out. We live in a capitalistic society, and the market will determine whether or not people want this or not. So if you choose as a school not to operate in this form of fashion, continue with the traditional way that we've been doing it. We're fine with that. But if you're a school that wants to shift over into a hybrid mode and do both, or a school that wants to do this only, then by all means shift into it, because the students will determine your success or not. Because they're going to go where they feel comfortable, where they feel like they're going to get the best and the most out of their experience as a student.
And even if you offer it in your school, every student don't have to do it if they don't want to.
It's
Right.
completely
Totally up on the
permissible.
student. Okay.
I believe we had a question, Ms. Coppinger.
I just want to give the board something to think about when we break here in a minute. I'm a teacher in education, so I've had student teachers come to me in the past. So I'm the supervising teacher for this student, and the school that she's going to, she has a supervisor from that school as well. And so while she's in my classroom, and I have to, there's paperwork for me to do based on what she's doing in my classroom, but the supervisor from her school has to come and observe her so many times. And so if you apply, or if you make an analogy to this program, then the school instructor or the school owner or whoever's in charge of this person at the cosmetology school, we need to put some responsibility on them as well to go and observe in the shops, because they have a lot of responsibility for that student coming out of their program. And so like this in education, this teacher at the college, she is required as the student teacher supervisor to come and observe so many times and to make sure. So that puts a little more weight on the school instructor. So that's something else to think about as well.
I think I made that suggestion on that we could go in and see, just pop in when we wanted to, not tell them we're coming, just to make sure they're not having them sweep hair.
I mean, in
and all that kind of
education, it's a
stuff.
requirement,
Yeah.
and there's so much paperwork that has to be followed up with that. So I'm just just the whole program. You know, I'd love for it to work, but there's a lot to hash through to get it to work.
There is. And there are details that need to be worked out. And I think everyone in here agrees with that. You know, I think it's a great idea to, you know, to allow for, you know, I think that being that the school is the person that's still ultimately in charge of the student, they should be able to pop up anytime they want to. And that's probably not anything that we have to put in, you know, in policy or regulation. They should be able to just do it.
Well, then they may or may not. I mean, if it's not regulated that way, there's got to be a regulation on their end. I
understand some oversight. I agree with you wholeheartedly.
Anybody else has a question?
Does this 750 hours have to be done before the apprentice, or if they're going into an apprentice program, can they not do half the week with us and half the week in a shop where they're getting what if they run into a question in the shop? You know, after their 250 hours, and they get into a question in the shop, then they can come back and bring it to the teacher, you know, does that make sense? Do you understand what I'm saying? Why they couldn't do their 1,500 hours, why it has to be separate, where you don't, as a school, as an instructor, have any control over the practical, but as a school, as a shop,
I think that's
you
an
don't have
excellent
You
point.
don't have any control over the theory.
Well, I think it's an excellent point to this board getting involved in regulating how these things are going to work the best. I think that is a relationship. There is a curriculum out there to have that student come before, you know, to get their licenses and to finish them up for the PSI exam. And I think that really should be worked with through the school and whoever they accept, and and look over for the supervisor. I think you have to be really careful about mandating and making rules that may not work. And I've sat here, and I'm not a school owner, and I've already listened to 4 different ways it might work.
Yeah, it'll work. You can make it work.
But I do think that the school owners will see the opportunities here, and they will rise and work, and it'll work. I do believe that. I don't think it's going to run amok, you know.
I think it'll
because I've
benefit.
seen it on international levels, and and I've seen it in hospitals. I mean, speaking to your interns, your medical students, and how they do their rotations, they're not as supervised as what some of the things that I've heard here. And it's just too much regulation for a PSI exam. It's crazy.
That's if you want to go just with the PSI exam. Now, I'm one of those high school teachers, okay? And when my girls graduate, and they know more than that PSI. And I think every instructor here strives for that.
I would hope so.
But you still, as that high school teacher, I only have these students 3 hours a day for one semester until the next year. So this would really benefit me. One semester I could have them, one semester they could be apprenticing. I can see where this would work, but I also see where this can be setting them up for failure. So then that's what I'm wondering, why can't we do this together instead of separate?
Yes, sir.
Thank you, Mr. Chair. The way it was explained to me, I don't think in the framework of the rules that are presented now, it mandates the hours being divided up in a certain way. So I'm assuming, am I wrong in that?
Correct. It does not.
I'm assuming that the schools can say, okay, 2 days in the classroom, 1 day apprenticeship, you know, or 1 week in the classroom, you know, however they decide that it fits for their business. Does that help?
Am I missing something? I was thinking it had to be 750 hours of classroom first.
There's nothing in the current law that says when or how, or that you have to take the exam or can't take it. It's really pretty open, and it isn't 750. I mean, it is if you're a cosmetologist, but it's half of the curriculum in a traditional school and half in the salon under the supervision of an experienced professional. So it doesn't have to be half-half. It could be every week you rotated, completely open for everyone to decide.
But after
hopefully
7:50,
today.
they could take their exam, the theory
There's nothing that
portion.
says they couldn't, so we could decide
We could
today that they
decide
could.
that, because that comes back to the schools on their pass ratio failure part, you know, so you want to keep your stats up for NACAS and for everything. And if they're gone for 7:50, or if they're there just half the time, at least you know they passed the first theory portion.
I'm all for it, and to your point, sir, I'm about as optimistic as it gets, because I was an apprentice. That's 43 years ago. I spent 18 months apprenticing, and that's how I got my license. I've never been to school a day in my life.
That's awesome. One last thing, if there are no more questions for me, I would like to add is, one of the things I heard. I hope I'm covering everything. I was trying to take as many notes as I could, but y'all were going a little bit too fast for my thumb. I think we should be careful also in adding or adding to the law. The law says a licensed stylist with 10 years experience can be an instructor. It didn't require an instructor. And there was a reason for that, you know, because, you know, we would be back in the same boat that we're in with new instructors that hadn't had any experience, you know, being over a student in a salon. And so, but the law, the way the law was drafted for a licensed cosmetologist with 10 years experience, continuous experience, that could supervise an apprentice. And so, you know, I think, and I'm not an attorney, but I have to consult with an attorney, that if we added more to that requirement, then it would probably have to go through the legislative process.
I could comment on that, and I apologize. Was not here earlier to introduce myself. I think we've met before, all of us probably. Tony Glandorf, I'm the chief. I would agree with the representative that you would have a difficult time if you tried to add another license to this supervising person to be an instructor. It would be difficult to get through the Attorney General's office on constitutionality and board, because the legislature specifically wrote into the law that they shall be licensed as a profession, you know, within this chapter. So adding on the instructor, which is not itself a profession, it's just a qualification, would be very difficult, and that would, I mean, that may off track you with what you're trying to do. The last thing you want to do is have the Attorney Generals reject your rules and they come right back here. I think you would have a very difficult time getting that passed through them.
Thanks. Any other comments?
Yes, I want to, for clarification, Roxana, we keep saying 750 hours, but any licensing under 750 hours, is that half of that time? So a natural hairstyling is 300, it would be at 150, they could do that?
Correct. Okay, that's correct.
Representative, thank you very much for coming and being with us to share with us today. I did have a couple of observations I'd like to say. Like yourself, I'm very much an optimist. I love to look to the bright side. But as a board, we also have to be realistic. And while we would like to feel like every person who is going to train someone in a salon setting is going to give their all, give their best in order to protect the public, we also have to take into account, seriously, the other end of that spectrum, and the folks who are going to absolutely look for the shortcuts, any way around it. A trainee may be sitting in a chair in a barbershop on his cell phone all day collecting hours. I would like to hear from you specifically your suggestions for dealing with that, for not setting up a situation where that could happen.
You know, I agree with you wholeheartedly. You know, there's no such thing as a perfect scenario. And I'm a realist also. There are those that will try to skirt the law, and those that will try to get around the process. You know, however, just as we still deal with non-instructors that are instructing classrooms, and you know, these instructors that are in school and instructing classrooms in these schools, we have rules and policies in place that is supposed to be the oversight for that. And I would expect that this board, you know, in the rulemaking process, will make sure that there are policies that would create the oversight to make sure that those individuals that are serving in a supervisory capacity will adhere to the letter of the law.
Thank you very much. I
Thank you.
appreciate that.
Thank you so much.
Are there any others on your list for speaking?
Done with our comments, so the thing left to do is to,
I'm sorry, we have, Mike, the chair, would recognize Mr. Agee.
Thank you. I had an opportunity to offer our comments, and I'm not going to rehash that. I would like to make one comment. Representative Parkinson is my friend, and I have the utmost respect for him. And even though I don't agree with everything he says, I will never call his integrity into question. But I feel like that he implied that I misled you on 2 points in my comments, and I want to be very clear. First of all, when I said I represent the Tennessee Association of Beauty Professionals, I never said who those members are and that they represent the entire industry. I didn't go there. Secondly, on the, I never implied who knew what in the previous board. I simply said this program has never been debated by this board or the previous board, and that is a true statement. It was discussed at a board meeting at my request through Senator Jackson, or Jack Johnson, and the previous board did vote on it, and they voted that they did not support this program, but it was never discussed or debated, and that was my comment for the record, and I just want to make sure I'm clear on that. I never implied who knew what. I simply said it's never been debated. So thank you so much for letting me clarify that.
Thank you.
all right, we've heard all the comments. I recommend that we recess for a lunch period. When we come back, we need to assimilate the comments we've heard and integrate them, if you feel appropriate, into what we have drafted here. After that, we have the regulatory flexibility analysis, and then we'll be done.
Ladies and gentlemen that have been here waiting, we would encourage you to stick around for the rest of the afternoon. Please come back. We're about to take our lunch. 1 hour, 30 minutes,
Whatever,
members?
45.
45 minutes? Okay. We'll be in recess for 45 minutes.
Okay. There's the beginning. We'll get through it. We'll get through it.
Right.
Back.
The State Board of Cosmetology Barber Examiners is back in session. And Mr. Moderator, we'll go to you.
All right, we've vetted these rules to the public, so now we're gonna start with the Barber rules. And the best thing to do, now that you've heard all the comments, is we'll go through each rule and amend them as you feel necessary. When we get to the end, we'll have the board vote on the amended rules, and that'll be how they're gonna look. After that, we'll do the regulatory flexibility analysis, and then that'll be it.
If I could take a second before Rob starts, I went ahead and printed the public chapter from last year that passed into law, Public Chapter 447. So that's the other document you'll probably see on top of your paper that you left. It's simply so that when we get to the apprenticeship part, which is the one we're going to be debating and creating so much on, that you can read that chapter if you haven't done so lately. I'm sure at some point you have, but that way it'll be fresh. Thank you. All right.
Let me know when everybody's
Looking forward.
looking at the Barber rules.
We can have copies of those. We've kind of been,
Oh,
I can go print some. Does that sound good? These are the ones that were the corrected ones. Okay, let me let you.
just kind of been
start.
sharing over here.
Okay.
Maybe if, I'm sorry.
Nope.
I should have mentioned that earlier.
Who needs them? I may have them on my iPad, my email. Well, I printed.
I know to print them off from now on.
I got dependent on technology.
Paperless.
That's what my principal says. Paperless. Let's go paperless.
Yep.
Every time we turn something in, paperless.
Not there yet at the state. What I will do is I will read the rule as it appears right now, and the board can discuss what changes, if any, they want to make to it, and we'll move on that way till we get through them all. So right now we have Rule 0200-01-.01, which is requirements for a school license.
What page are you on?
Page 3 of the first rulemaking notice. Currently, new subparagraph D says, the school must have at least 15 students enrolled, part-time or full-time, and that the school must provide proof of same to the board in the form of signed student enrollment agreements prior to being granted a Barber school license. Or discussion on any changes that need to be made to that. Or if there isn't any, we'll move on.
Is that a change from?
It's an added, it's new.
Cosmo's 20 and Barber's 15.
15 students. And then the next new paragraph, full-time barber school students must attend school for at least 25 hours per week, and part-time barber school students must attend school for at least 15 hours per week. All right. The next rule is Rule 0200-01-.06,
Sir, is that going to remove the maximum of 40 hours a week they're able to attend class? Because there's no maximum now. In the present rules, it's a maximum of 40 hours a week that a barber student can attend. This is just a minimum. So is that removing that?
creating a minimum.
It's creating a minimum?
Yep.
Okay.
At least 25 hours per week for full-time, and part-time at least 15 hours.
So the other rule will stay in place for the 40
Correct.
hours maximum. Okay.
Okay. Paragraph 1 on Rule 0200-01-.06. We have, at the very beginning of the hearing, I made a change to this out of necessity because this is the way our system is set up. All certificates of registration for master barbers and barber instructors shall expire biannually. Somebody wanted my attention. Last day of the month of the original licensure. 2, all certificates of registration for barbershops shall expire biannually on the last day of the month of the original licensure. And number 3, it's the same thing for technicians. They expire every 2 years on the last day of the original month of licensure. Is that acceptable? Made no changes to paragraph 4, 5, 6, and 7, did we? Number 8, an applicant for licensure meeting the requirements of TCA 4313 issued a license under this chapter under application and payment of fees required for issuance of a regular license of the same type. If in the opinion of the board, the requirements for certification or licensure of such other state are substantially equivalent to that required in Tennessee. This rule number 8 is the military spouse temporary permit rule. Rather than read it all over again, does the board have any suggestions?
Hey, Rob, can I go back to 7 real quick? And I just want to ask you this question. It says you completing a form prescribed by the board. Is that form already in place for reactivating a license?
I will have to ask Roxana, somebody who's in the board offices, if we have that form.
I'm certain that if you have a license that expires, there is a form.
I think there is.
But if you put it on inactive status and then reactivate it, I mean, I'm assuming there is. I just wanted to make sure it wasn't something we had to come up with.
Well, the rule's gonna require that.
See that?
We can produce that for you at the next board meeting if you wanna see it.
Oh, no. I just want to make sure there is one, since it's in the law.
I'm not sure that proscribed is the right word. Might need to be prescribed. Any comments on the temporary permit rule?
For the military?
Military spouses?
I like that there's an expiration date of the 6-month
Yeah.
time period, so it's not open-ended, but yeah, I think that's a good thing.
6 months to fully qualify for it. Right. Touch number 9. We didn't touch 11 or 12. Is there any reason to alter those? All right. On rule number 7, equipment and location requirements for barber shops, we amended subparagraph 1D to read as follows. Every barber shop should be equipped with at least one dry sterilizer or sanitary compartment per station. In the last rule, we added a new paragraph. Barber shop and barber school applications shall expire within 90 days of the date of the application is submitted to the board. The applicant fails to provide all necessary application documentation and information to the board. Let me read that again. Barber shop and barber school applications shall expire within 90 days of the date of the application is submitted to the board. If the applicant fails to provide all necessary application documentation and information to the board. The board may, in its sole discretion and for good cause shown, waive this requirement upon written request by the applicant. No comment on these barber rules other than what we've amended. We could have the board vote to approve these rules in this chapter is amended, if that pleases the board.
Any other questions on those? It's really just a little housekeeping and freshening up. Is there a motion?
Motion to amend.
Second.
Who was the second? We have a motion that's properly seconded. All in favor say aye.
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 Those opposed say no. Motion carries.
That was easy.
All right, cosmetology rules.
I'll second.
Starting on page 3.
I ask one question prior to moving on to cosmetology. We've already hit the gavel, but the birds and the beer and the wine and the fish and all that with barbershops, where is? I need a little help on that one, because I'm a little confused.
In the cosmetology world, they're not permitted except for service animals. In the barber world, they had not been permitted except for service animals until just a couple of years ago. Now, a barber shop is permitted to have a fish in an aquarium or tank and a bird if the cage is cleaned daily and so forth, and there's some cleaning and sanitation in there, as well as service animals.
Every time I make a move in either my barber shop or my salon, it's like the opposite one wrong. And I had some people picketing out over some goldfish one time we had in a bowl, some like crew, and it's like it was illegal in a salon, but okay in the barber shop.
It is now. In the past, it had been illegal in both.
But we're trying to blend these two things together. So are we dealing with them separate and then together, or is that something that we could have?
Something we should, but
because it's too late.
well, we haven't really considered it in this particular rulemaking hearing, and I'm not so sure if the statute would allow us to do much to it right now. But we will come back to it.
All right. I just want to sort of know what
We can talk about goldfish and wine in the same capacity.
and pool tables,
And pool tables, yes.
because I had to like build a wall for that.
In the barber world, you can't have alcohol on the premises or serve. In the Cosmo world, you can. However, I believe I'm correct in saying that if you have duly licensed shops, the more strict license prevails.
Can't sell it.
Can't sell it, you can give it away.
Give away wine. Be a liquor store.
We don't do either one of those with liquor.
All right, the heavy lifting, chapter 0440-01, starting on page 3.
Yeah, we are. See how much gets done when you leave?
While we're having these papers passed around, I'd like to take just a minute, if I could have all of your attention. We lost someone very dear to our profession in December of this year. Mr. Wayne, who has been the proprietor of Cosmetology School in Cookeville for as long as I can remember, since I was a young boy, I guess. He's more or less a legend in our field. He had been suffering from a ongoing illness and succumbed on December the 8th. We'd like to remember his family and folks and remember the contribution that he has made to our industry, as well as Miss Patricia Richmond beside of me lost her husband Eddie on Christmas. So I'm sure we all can extend our condolences to her as well. But folks, a lot of people contribute to our industry in a lot of ways, not always inside a board meeting or a school or a shop. But our family and our friends and the people who support us, our customers, we always need to be mindful and thankful of those.
Roxana, while you were out, I had one question on the barber. Where a barber instructor can put their license on inactive status, and then they want to reactivate by completing a form prescribed by the board. Is that form already in place?
No. If this is approved, we would create a form just that says I, and then their name and license number, I'm ready to go back, because they'll probably have to catch up on their continuing education if it's
Okay.
an instructor.
Okay, so that's something that needs to be
Yes, that
taken
will need
care
to
of.
be created. And then just like any other forms, I would present it before the board for you to approve.
Okay, thanks.
Thank you.
All right, we're on page 3. This first rule, requirement for school license, the only suggested change I had was change Board of Cosmetology to Board of Cosmetology and Barber examiners. And then there's the list of materials here that are required for a school. I believe we had Ms. Sappenfield submitted some suggestions on materials that would go into schools and shops.
We voted on that this morning.
Correct. So we'll incorporate
We'll
those into
incorporate
these.
that. Okay. Requirements for instructional floor space. Is the board okay with that?
If I could point out on page 4, right now, with the full cosmetology school, we require 2,200 square feet. So this is not stating what the square footage would need to be for each of the specialized school. The thought is they have to do an application, come before the board anyway, that they would request a waiver, I believe is how we're putting it, that they don't want to teach the other curriculums, but only teach, let's say, manicuring or natural hairstyling. And so I do get calls in the office that say on occasion, what square footage am I going to have? So it's just something for the board to consider. We don't want to overregulate and say you must have 500 square feet if you're a natural hairstyling school or a manicure school. But on the other hand, if it's just something to consider, do we need to put the square footage?
So we've got the wording adequate
Yes.
instructional floor. I love
Right.
that.
And it's wide open.
I think I heard before that there was going to be a chair associated to that person, to everybody that's in the school, so there's, no.
How did we get to 2,200 for a barber school? I mean,
Cosmetology school. Barber's
cosmetology.
1,500. It's been in the rules, I think, since the beginning, pretty much, where square footage was determined, and it's based on the learning space and the space needed for the salon to operate, if the school has one.
Get both of those on the same page too eventually.
Pardon me?
Are we gonna get both of those, the barber and the Cosmo, maybe on the same page?
Not during this rulemaking
But
hearing,
maybe
but
later.
yeah.
We had some schools with the previous cosmetology board that people were cramming things into hallways and storage areas, trying to get that square footage, which is why this says instructional floor space shall not include storage rooms, restrooms, utility rooms, passageways, or somebody's office. It actually has to be real, and because that rule with the set square footage was causing problems for people. All right.
not having any set at all, will that create its own set of issues?
I think in our guidance, at least what I've been saying, based on the fact that it's open and we're thinking of not over-regulating it, then it would be whatever is adequate for how big you intend or think you want to grow. So if this is a school that's wanting to do manicuring and they are going to prefer to do small and stay within the 20 students, they may be fine at 750 or 800. But if they intend to grow, it's something they would have to consider, but we wouldn't regulate it. We would just say it's adequate. So it's based on your desire, I guess.
So on application by application basis, we're gonna get a projected plan from them?
They'll
Don't
still,
end-
yeah.
You don't end up 50 square feet short, you know?
Yeah.
Which is bad.
There was a case of a barber school several years ago that ended up being like 20 feet short, and it had to do with the measurement of the bricks, fascia on the front of the building versus the inside. of the
Outside
windows.
dimension versus inside?
Mhm.
What would, one thing maybe to consider, only because in salon design and barbershop design, there's usually X amount of square feet allocated per chair, or in this case, maybe per student, and that would kind of blanket anybody being able to be the size they want, but with some kind of,
Minimum at least.
yeah.
Yeah.
There's already a requirement, I believe, that stations are separated by at least 5 feet center to center of the station.
54 inch centers.
So that's going to give you some
Well, 60-inch
minimum
centers.
Dimensions to be able to.
And your cosmetology schools have to start out with at least 20 students for us to approve them. So this isn't saying how many for a manicurist or natural hairstylist or aesthetic school they have to have. Are we going to stick with the 20 minimum students, or?
And there's other forces at work too. The local codes people are not going to let you just cram stuff in there. Adequate means adequate. So I think we're probably better off not having the set square footage.
So that's your recommendation?
Doesn't motivate people to cram stuff wherever they can find a spot. All right, where are we on floor plan? The proposed floor plan must be submitted and approved by the board before they get anything. And there's the 20.
Square footage, just because it came up last month with the online school. Assuming now that Shantae or someone else could come back with their space for what they're trying to do.
This is the cosmetology rule. So that particular school was Barber only. She'd still have to comply with the 1,500 as it is right now.
Just
Right.
cosmetology.
Right.
Okay.
And section 3 is for the floor space, and it's listing the specialized schools, if you will, where we're leaving the adequate instructional space as adequate. So we're not going to set square footage for those specialized schools. But the cosmetology schools are still at the 2,200.
Broader.
The broader, yes.
Okay. Thank you.
Sure.
And Barber is still at 1,500.
Correct.
Sorry, thank you for the clarification.
Absolutely.
You know, Roxana, you mentioned the minimum number of students required. I'm sure in the past, there was a good reason for putting 20 in the cosmetology schools. So why should we leave it wide open for these specialized schools?
Shouldn't.
All the way across.
Or maybe it's not 20, maybe it's in proportion to the industry as far as the percentage of services it does.
I don't know.
Something that's formatted versus open-ended. Otherwise, we're going to be dealing with case-by-case issues on a regular basis.
I know that with aesthetics, it's not a chair. There's more privacy and intimacy, even in the training. Like, say, some schools don't adequately train on body waxing because there's not that privacy. So an aesthetic school, like some of the ones that I've attended in outside the United States, the rooms are quite large. There's quite a bit of dedication of space to get that kind of instructional training in there. And that would be on a application by application basis, I think, different than opening a manicuring school, which would require less equipment and privacy and intimacy. So there are some things that are different with this with the category of aesthetics.
I wasn't talking about the square footage or anything. I was talking about the number of students.
That we ought to keep it like the same across the board.
We have no minimum
Right.
requirement
You can say
for the
2
number of
students,
students.
and you can open up a manicure
Right.
store. Yeah, I think you
And
probably ought to keep it to
This
the
would be the
20.
time where we want to set that minimum. And
Right.
it may not need to be 20, just because you may have a real need. I mean, we've got at least 3 or 4 schools ready to go with natural hairstyling and manicuring. I mean, they're calling and ready for the applications for this. And I don't know that either of them will have the 20. That's a lot of students.
I think for those services, that's probably a high number.
Don't you think? Yeah.
I think in
I do
aesthetics
agree
that
it's
would
a
be
high
really high because I went to 13 schools and only 2 of them actually had aesthetics programs, and one of the programs only ran 2 classes a year.
Students.
So
How
it
many
was,
students per class?
they were taking in 30 per class on that program, and on the other program you could start any Monday, but it seemed like they had between 20 and 35 students each time I went in to visit.
I believe I may be able to parse that out a little bit. In the cosmetology setting, in the school setting, that school is required to have 20 students. Of those 20 students, we're not dictating whether or not there's 20 cosmetology students. There may be 7 cosmetology, 12 nails and 3 estheticians. or some breakdown in that manner. So it really would not have an effect if we maintain the 20 on the cosmetology schools. On the specialty schools, which only deal in that specialty, a natural hair school only deals in that and nothing else. Those are the numbers we probably need to address.
Would you want to cut them in half or something, maybe?
That's not a specialty of mine. I don't know the numbers that attend in that.
Is there any reasoning behind the 20 or the 15 to give us context?
I think that and I'm just drawing over history and what I've seen in the industry. I think those numbers originally were derived from seeing schools open up on every, so many months. They would enroll 4 or 5 students and then not be financially sound enough to continue. The students end up losing all the way around. And today we even have bonds that must be applied for new schools as well. So it was really, I think, to protect the students in the beginning. Ensure a better foundation for a new school to get started, and they'd have sufficient students to actually be able to make it through startup periods.
What would be your best guess based on your background in schools and understanding the?
I think a 20 number on the Cosmo program is fine. As far as manicures, they are much smaller programs in most instances. If it's a specialty school, you might go as low as 7 or 10.
I think with the specialty school, probably as low as 7.
I think we should have a number, though.
I'm only saying that because with that number of students, I don't know what the overhead would be in a school that only does manicures or nails, but it would probably be proportionate on the space size they'd have to have.
Is there a way to do a survey of those schools and their current enrollments to get an average?
By those schools, are you referring to those that are interested in opening the programs, or?
I'm saying our current.
I would say if of a typical school that submits monthly hours with 20, there's no more than 3 to 4 in natural hair, maybe 5 or 6 in manicuring. I mean, the
Total
majority
students.
of the 20, if we're looking at 20.
Okay.
The
Well,
rest,
I was just curious because if we're saying 7,
yeah, they may not quite hit the 7, depending on the school.
Still high?
It's still,
Okay.
yeah, it's still a little bit high. The majority of the 20 are still the cosmetology or
I
curriculum.
would think on the sustainability of keeping the business open, having less hours to train compared to full cosmetology program, the specialty schools would have more enrollment turnover.
Yeah, that's what
so
I was thinking too.
that they may have enrollment at certain times at 5, but it would be continually 5. And
Something to
so-
keep in mind is let's say we set it at 7, once they're approved and get going, if they drop below that, they're fine. We don't ever really question their numbers if they're still renewing each year.
Right, this is just to open them up.
Open them up,
Yeah.
yes.
We're trying to come up with a number to open them up, like 20 for cosmetology. So to open up these specialty shops, our number would be, I don't know.
Let's go down to 5, just, to get the school open and to start it up.
For manicures?
Natural hairstyling.
Natural
sure.
hairstyles, okay.
I would say 5 for aesthetics.
5 for manicuring.
If we keep it the same across the board for the specialty
Yeah,
schools.
that'd be great.
Just like we're doing the adequate, I think that would be good. Rob, would that go under number 5, where we're talking about new schools? We're gonna have to add that number. Okay, so it'd be 5D.
That's where we're sitting.
Okay. 5 is the number.
It will read a minimum of 5, okay, to open a specialty shop.
They still have to provide a bond as well, Roxana?
Yes, that wouldn't change. If we could come back to number 4, even though we skipped to the number of students, but it jumped at me, and I knew we had to fit it in here somewhere. Under 4 for the floor plan, A and 1, 2, 3 are logical. They talk about needing to have the square foot, the license to operate the school, cosmetology ownership if it changes and if it relocates. B is, do we need to specify that the 2,200 square feet if a cosmetology school and adequate square foot if it's a specialized school? in that sentence, because otherwise it kind of trumps what we said previously. Does that make sense? Okay.
If I can, I'd like to recognize Mr. Hurd. I believe you had some expertise on this.
Yes, sir. I just want to clarify that if the standard for Barber and Cosmetology at 15 and 20 is also the standard for instructional staff to number of students. So one instructor to 15 students for a barber, one instructor to 20 students for a cosmetologist. Is that going to be, basing that you're stating that that number is what you have to open with, will the specialty schools opening with 5, will that be the requirement for 5 students per one instructor?
I think
because it's still under that
you're looking at it
cosmetology.
from the wrong direction. That's a maximum number, I believe. Whenever you have one instructor, he can only, or he or she can only take up to 20. So if you start off with a minimum 5, that instructor still can take up to 20.
Up to 20, because it's still following under the cosmetology laws. Okay, thank you.
So B, where it says we're required under this paragraph, the floor plan shall provide for and the school shall contain at least 2,200 square feet. I think we need to put if a cosmetology school of instruction floor space, and then an adequate floor space for specialized schools.
Okay.
And then separately, including an enclosed classroom area for theory.
We can make B say, we're required under this paragraph, the floor plan shall provide for and the school shall contain at least 2,200 square feet of instructional floor space for a cosmetology school, including an enclosed classroom for theory instruction, and then a new sentence. Paragraph.
Okay.
Where we can say, new paragraph, we'll just say we're required under this paragraph, the floor plan shall provide for and the school shall contain adequate instructional floor space, including a classroom for theory instruction. And then going on to new school, we added paragraph D, minimum of 5 students, right? We get into the curriculum. This is a long rule. A lot of new stuff, so let's just go through it. Paragraph number 1, apprenticeship student means a student enrolled in a school participating in an apprenticeship program with the intention of completing the school's curriculum under that school's apprenticeship program.
I'd like to ask the question, please. Will our apprenticeship program under Barber be operated the same way under COS?
If it comes up, it'll have to be operated very similar. Just for our purposes of regulating it for both. Number 2, supervising licensed professional means a licensee in the field of study of an enrolled apprenticeship student who is in responsible charge of supervising and accounting for that student's apprenticeship program credible activities and providing the participating school with the student's apprenticeship activity record. Any tweaking for that definition?
The curriculum for the apprenticeship program will be done by each school to achieve.
Yeah, we're the partnership between the school and the salon is more of a business arrangement that we're not going to attempt to regulate too heavily.
The NACAS will not accept the apprenticeship program we offer here. So that means if they don't take it, the U.S. government won't approve the grants for the students. So the apprenticeship program may be just for private pay students only. That's what I've been told.
Works for me. I was private pay.
Yeah, but there's so many students that get the grants. So.
We're still defining the supervising.
Yeah, we're still under that definition. Does that definition need any changing?
By law, that has to be someone with 10 years of experience.
Yes. And even if it's in our rule, it just pairs.
We could add that to the description, to the definition of a supervising licensed professional, the 10 years, because the law has it. Now, if it's tweaked, we'd have to change the rule to meet that. This is the definition in the rule.
The law that you
Yeah.
handed us, that was very helpful, Roxana. Where is that? Am I missing that?
Down on number 2. I think if it's part of the requirements, it needs to go in there.
The definition, I do too.
Yeah.
Yeah, I think that's a very good point.
Can I ask a question then on how that's defined? Because I've heard the word continuous thrown around, 10 years of continuous. Are we hung up on continuous? Because I have a problem with that in our industry only because I think a lot of people get into this industry for flexibility. God forbid they would leave and have children and come back. I would just hate to see someone with 10 years of experience who took a year off here and there and wouldn't be technically included on how we would word that. I think there's a lot of reasons why people would take breaks in any career.
And I think I'm going to read that portion of the law. It says, and this is Public Chapter 447 that passed July of 2013, 50% of the hours needed for the specific license, so that would be manicuring, aesthetics, that's why it's not 750, it's for that specific license, from apprenticing under the supervision of a person licensed pursuant to this chapter who has at least 10 years of experience. So the law doesn't say continuous. So if we've added the wording continues somewhere in there, we'll have to be careful to pull it back out or leave it for debate now, because you make a good point. A lot of our professionals do take a break. They'll put their license on retired status, then they've got to come back in and retest, but they'll retire for a little bit if they decide to not keep up with the fee is mostly what. But otherwise, we don't know at the board if they're actually practicing for 10 years. So they might not have been practicing, but if they kept up with their license, we have no way of knowing that they really were actively.
That's a really interesting point.
Yes, yes.
When we offer reciprocity, though, we have to, we require proof from someone from other states that they have been actively, continuously employed.
The only time we look at their work history is if they're missing hours, and we have to take into account work experience in lieu of hours. But we never know that they've been really working otherwise.
The question's a continuous license more than continuous employment.
And the
Continuous
purpose
out.
is experience. I mean, as I read the law, it really is 10 years experience. So are we trusting that the supervising professional?
They're saying that 10 years experience equals 10 years of being licensed. And to your point, you can be licensed and not.
That is absolutely correct.
Well, but Amy, to your point, if I took my top 20 hairdressers, who would be the ones I would put apprentices under,
Yep.
I don't think one of them qualify for continuous. They've all been with me 15, 20 years.
Right.
But I bet you 80% of them had a break in there somewhere.
Oh, I don't disagree. I don't
No,
disagree with you.
I'm agreeing with you, actually.
No,
because
yeah,
my
I'm
best
in the
people
same
wouldn't
boat.
qualify under continuous employment.
Yeah.
Wasn't that the representative's point, though, that those people had experience, and just carrying a license, is that really experience?
But he didn't use continuous either. It's 10 years experience.
No,
I
but
think
there's
experience is the key.
the implication is that you've been licensed for 10 years, so therefore you've been working for 10 years.
Possibly, I mean, I know we've talked about the schools who choose to participate. Maybe, maybe it would fall on them to determine who would be the supervising license.
Partnering with them, if you will, maybe through a resume being required at the time of establishing.
Yeah, so basically,
connection.
the school will look at the work history, and we can keep the word continuous out of it.
So the school owner would approve whether somebody in my company could actually be an instructor or not?
At least look at
No.
work history.
If they would be a supervising licensed professional for that school.
Yes, the school would be looking at that.
They're the ones ultimately that are establishing that relationship, if you will. And they're gonna have to communicate back and forth with the supervising professional to get the hours and the log and what have you, so.
Of course, I'm sure you as a business owner could say, nobody in here is gonna be a supervising licensed professional. I mean, that's
Well, the
in
same
our
way
rule book.
a school has the right not to participate, right?
Right, like,
Correct.
and you as a business owner don't have to participate either.
This is getting narrower, this is getting more narrow as the day goes on.
Yeah, there's a lot of choices here.
Actually, I think there's less than you think.
So the way that the law 447 is written is 10 years of being licensed. And that-
10 years of experience.
Experience.
Yep, 10 years experience.
So if a school asked for a resume and your resume has no work experience, but you had a license, you would not qualify based on this wording, because experience would mean that you can present a resume of some sort that shows you've worked for 10 years. It doesn't.
And I'm sure, sorry to interrupt, I'm
No.
sure a school would be picky on who they would place their students with, because they want a positive outcome as well.
And as the salon owner would be picky about who they put in charge of the student.
I'd question both of those myself.
I can see a loophole there, but I can also see it working out as well. So
So in our
blanks
rules
there.
on page 5, do we need to include under this just verbatim so it matches the law?
Pages down, this is,
Gotta make sure that's on.
sorry, and I apologize to interrupt your discussion. But on page 7, if you look at 3, he talks
That's
about the
it.
credentials of the supervising licensed professional. So what you saw earlier was basically an introduction as to what the definition, what they are. Now, the requirements are on page 7, because I heard the discussion about putting the years of experience in the definition, but the definition is who they are. In order experience is on page 7 and 3 there. So it would be redundant if you put it in the definition, is what I'm really trying to point out. And that on the years of experience, 3 here says that it's consecutive years of experience is what was brought forward from the past. I think experience and license would be unlicensed activity if you weren't licensed during years that you had experience. Executive would be up to you.
I'll just nod and smile. I mean,
Thank
because
you.
there's no continuing education requirement for our industry in the state of Tennessee, I don't necessarily agree with you that being licensed and having experience are necessarily always the same. Maybe as you're an attorney, you have to.
No, I think if you were providing services to customers and being paid, you would require to be licensed.
Agreed.
Right.
Yeah, and I don't disagree with you. I'm just laughing with you, because it's very. It is what it is. How about that? With the 10 years, there's no other way to go out about deciding whether or not that's the case.
And
Well, they could say they had done their own salon, or they had been working for someone,
Well, doesn't the industry
think-
change fairly quickly, too?
I think when this
Things change? I don't know. But I have a teacher license, and it's current, and it's good for 10 years or something, but I'm not teaching currently. I haven't taught in 3 years, and a lot of things have changed. since I haven't been teaching, but I hold a license.
That may cause for another discussion as far as licensed stylists having that continuing education requirement, which, if I'm correct, we do not have at this point, but we have the power to change that.
But if we required these supervising licensed professionals to have instructor license, then they would be getting their continuing education.
But the
As I said earlier, I don't think that that's going to pass through.
You'd only have
I
about
don't think you
3
have
of
the
them, though.
authority.
Nobody would do it.
I mean,
The way that those statute was written, it doesn't require the licensure to be a instructor license. That's very specific.
I think the 10 years gives you good odds that somebody is qualified to be able to oversee an apprentice.
There was a lot of discussion on this before this law was written on this particular, who would be doing this. And I guess the point at that time was that it is such a changing, evolving industry. On our earlier discussions, we were concerned about unlicensed people who become like, like certified manufacturer reps, or nurses who think that they have better licensure than estheticians, or a color person coming in and having a color school and calling it and being part of the apprenticeship program. Those were things we addressed early on, but it really was nailed down to that 10 years of experience and having a license attached to that 10 years. And we looked at it all the way around. This is just, it's good for discussion, but it just didn't seem to be.
Who is we? Who are you talking about?
Well, I sat down with many legislatures, desk sides, that the discussions were coming up. I actually came before the board that you were on when Linda Colley was chairperson, and discussed some of the things that were going on over at Legislative Plaza that I had become involved with, and some of the actions of other agencies against the Cosmetology Board and what was going to happen, particularly with estheticians, in better education and better regulations on our education. So all of those things were discussed as early as, I would say February 2012, a long time ago. But we sat down and talked about a lot of things. Groups of us got together, not with the board, but professionals in our industry.
So are we good leaving the definition as is, since more's added later, or do we want to add the 10 years?
No, I think there's another place for it. I appreciate that.
I think we're good.
Anybody object to leaving that definition? Good.
All right. Now we're in 3A, 1,500 clock hours or 45 credit hours of instruction required for applicants for a license to practice cosmetology shall be apportioned like that. I don't think we changed this. But it always was. But the rule is open, so we can move on, or you can take a look at it.
Change it to 3,000,
50,000.
1,500 apprentice, 1,500 school.
There you go.
Can we actually increase it?
It was open. The
Ladies
thing
and
that-
gentlemen, on that note, let me just say, in my humble opinion, as an educator and as a 25-year barber who's owned and run shops and salons, I think that the amount of hours required for training is not enough. As I
agree.
look at other states, across the board, I'm seeing 1,800 hours, I'm seeing 2,000 hours. There's at least one state that had, if you chose the apprenticeship program in that state, it required doubling of the hours. And that came out to be somewhere around 3,000 or more.
But
That's
just as a barometer.
That's just 3,000 apprenticeship. It's no schooling. Right, okay,
Right.
I just want to.
Well, as I spoke earlier, I was an apprentice in 1971 through 1972 and a half. It was 18 months of 40 hours a week. So if you run the numbers on it, I think I think we need to increase the amount of hours necessary, and then that way they get plenty of schooling in and then plenty of hands-on in with the apprenticeship. Because look, my family came from Italy where hairdressing doesn't even have a license, and minimum apprenticeship is 5 years. I mean, now is that over the top? I don't know. It takes probably that long to become a master, but at the same time, I think 1,500 hours is probably where the crux of this whole issue begins, when we're trying to divide up 750 and 300 and 750 and all that. I would definitely love to keep this dialogue going to extend the amount of hours necessary to become a licensed
That
professional.
way they could do their last 750 apprenticeship and they will have over 1,000 to go with. And
Well, no,
I would
it's
feel better
50% of whatever we,
Yeah,
Whatever we do.
50%.
yeah.
So if we decide that we want a student
1,800?
to be in a school for 1,000 hours, 1,800 hours.
Or 900 hours in a
It's
school,
90.
900 hours as an apprentice.
I really think that their instructors need to be more than 300 hours. That is just, they can't get their grants for it, and a lot of people want it. But I think that.
That's not what we're discussing at the moment, though,
Well,
right?
the
first
I
one,
agree with
the
that.
first one's the
Floatable in here.
cosmetology, and we'll go down all of them, yes.
Okay.
I agree.
And can the in-school program hours be different than the school/apprentice program hours?
50/50. Is that true?
However, if they have, a specific amount that they can get all their work in, then more hands-on the better. I mean, or not hands-on, but apprenticeship,
Does it have to remain half and half legally?
The
It is,
law
okay.
says
That's what I'm asking.
50%, so it could be 1,800 total, 900, 900.
However,
If-
we
That
could
would be
go,
good.
we could go
Right,
with,
right, right.
we could go with in the apprenticeship portion that they do, 2 weeks or a week in apprenticing, a week back in school, 2 weeks apprenticing, then report back to show what you've, observed or what you've practiced.
How about if we pick a number and kind of toss out some numbers here on the amount of hours for the program in total? And then we can start looking at how the curriculum can fall in it. Is there anyone who would be in favor of 2250? That was a number we heard from the audience.
Are we talking about every cosmetology program or just the apprentice program?
Every cosmetology
In general,
across
like
the board.
across.
So even if they don't do the apprenticeship, they're still going for those high
Exactly.
hours.
They're getting more hours of instruction.
I think that's serving the public in the best capacity.
I would agree.
The curriculum isn't different for the apprenticeship program. The curriculum is set right here. It's what we're talking about. So now's the time. But nothing in the law says that you have to do all 750 and then head out. So you could do exactly as Ms. Barger's suggesting, a week, 2 weeks, whatever, and go back and test in between. So yes, you want to cover now cosmetology if we're looking at the first one.
Increase the hours for cosmetology. They should be increased for the manicurists, the estheticians, the natural hairstylists, and the barbers.
And as Diana mentioned earlier, they can, instead of the week on, week off, they can actually do a couple of days a week classroom, a couple of days a week salon.
I think that would probably be up to the school and whoever they're
So that would
working
be
with.
Yeah, we
to the
won't,
school.
will we set
Yeah.
that? How
Oh,
it's
we're saying
unfolds?
they will, right?
Don't
My
have to.
proposal is
More hours.
raising from 1,500 to 2,000, and for the apprentice, it'd be 1,000 in school and 1,000 in the salon. That's my proposal
For the cosmetologist piece.
for
'cause that's the first
cosmetologists,
one.
and then we can rate accordingly based on the current
Now, we
portion.
can't do anything with the barbering because that rule was not opened.
Right.
So next year, when we look at rules, it's something we need to keep in mind because as we're now one board, it's going to be tricky if we've got a big discrepancy between hours. That doesn't mean that it can't be done, of course, but we'll deal with that then next year.
Ladies and gentlemen, if y'all will indulge me for just a minute. Frank, I appreciate your 2,000. I'd like to call on Ryan for just a minute. I know the answer to this question, but I'd like y'all to hear it from somebody else. Why did you say 2,250 hours?
2,250 hours is 1,500 plus 750. So it actually takes, as a licensed cosmetologist with 1,500 hours, you can attend a barber school for 750 hours and become dual licensed in the state. So it's kind of setting the groundwork at the 2,250 hours gives ample time to train a student in both sides. And then that's the potential for dual licensing in the state. We are a dual board. That may be something that can go on down the road. But at the same time, you have 750 additional hours from a businessman standpoint that I'm going to be able to teach business strategies to a child that I can't teach right now. So it's the premises is to have the amount of hours it requires to become a cosmetologist and then so barber or vice versa. But that's the 2,250.
So if someone's not interested in both, they're going to go through both?
Yes, sir. So that means I'll show you how to do a finger wave and I'll show you how to shave a face. You know, it's the premises of giving you the option to have everything laid out in front of you as a student, and then you determine what direction you want to go. I produce some of the best colorists in the state, but I'm a classic barber school. So I'm going to teach you how to shave that face as well. But that way, the school has the option, has plenty of hours under their umbrella to teach the student and guide them in the direction that they want to go, allowing them to choose where do they want to specialize.
They may want to spend more time on nails or on skincare, esthetician work.
Correct.
Within the scope of that cosmetology program.
Correct.
So that was my reason for calling
Can I
it
ask
out.
a money question? If we're talking about raising hours, what does that mean for tuitions across the state?
Raising tuition.
That's why I recommend that if you could do something like that, you have to write a rule that says, as of so-and-so, it'll be this much, so the people already in the programs can finish.
Right.
For the Department of Education requirements, 900 hours constitutes one program. If you make it at minimum at least 1,800 hours, that's to the Department of Education standards 2 years, which means that a student could get funding for 2 years. And more so thinking of the student being able to pay for their education, not how much money the school's making. But that does open the opportunity for the student to get 2 years worth of grants to be able to attend school at a minimum of 1,800 hours, because it's 900 hours per year.
I think one thing to consider, if we keep students in school for a longer amount of time, as an older person, when you don't have other income, you have to remember that they're going to be in school longer, so they may not be making money in order to have a living. And I think that's the reason some people drop out of beauty schools, is because they've not been able to afford to work and go to school because of all the hours. Does that make sense?
Yeah, but if they're
does.
going to
Something
get
to
to
consider.
apprenticeship, like the last 1,000,
Then they could get paid
then they
while
can
they're,
get paid while they're going to school.
yeah.
Yeah, because on the other side of that, Anita, I get them after school, and if they're not 100% ready to go then they're not making money for the first year they're out of school, and that's where I get 7 or 8 out of 10 drop because of the lack of income there. So I think if we can keep it in school from 18 to 2,000 or whatever, get them more prepared and get them more time in the salon if they're going to be an apprentice, or more time in the school if they're not, I think it becomes kind of a medium win-win-win, where it's not stretching the time out too far, but it's giving them the additional time necessary to get them prepared to become a professional hairdresser. Look, as good as they are coming out of school today, they're only so good because they don't have the repetitions in. And we talked about repetition
that's
earlier. That's the piece that they got the knowledge, they just don't have the chops yet. So if we can get them to get another 500 hours, whether it be in school or on mannequins or on customers, salon clients, whatever the case is, I think that's going to really service them well to set them up to win. I've had this beef for years, and I guess maybe that's why we're here, is to try to do something about it.
And apprentice, just doing blowouts, just getting their hands
Touches.
to work.
They got to get touches.
It's not, a lot of schools do have the hands-on, but a lot of schools don't. You know?
Some have trouble getting customers too,
Yeah.
and it's just, then you're only doing so much on man. I think that helps the student become at least better equipped for when the time comes when they leave school, for me to be able to put them on the floor quicker.
And with that being said, I think the salon supervisors and all will dictate for the student different things to put their hands on, as where a school may, keep them in one repetition of a service, like you said, blowouts or whatever. They may be doing that at the school over and over again. But as a salon owner, you may do blowout, color, cuts, you know.
Or whatever they're preferring to do. That might be where it
that's
gets a little
right,
bit more
too.
specialized, and again, contributes to their future earning.
I definitely see the increase in hours for apprentices, because that was always my beef from the very beginning, that you're only getting half the hours. So I definitely see the advantage to raising the hours for apprentice. But you're saying even in a traditional cosmetology school, the hours need to be raised.
Yes.
So,
Yes.
hey, this is like win-win.
It's win-win.
We can do that.
Yeah, you can't raise, it has to be 50/50,
Right.
as the law states.
Oh,
So-
I know.
we've gotten
I
to
mean,
this
but if you
point.
raise the cosmetology, that automatically raises the 50%.
Are we looking at, as Frank suggested, 2,000 hours, or how do you feel about 2,250? Who would support?
I think
I
it's gonna be a
support
pinch.
Frank.
2,000.
I think
You
it's
don't
gonna
want
be
to
a
do too
pinch
much?
long. I think it's a
Too
little
much.
long. I'm
I
sorry.
support Frank with the 2,000.
2,000 hours?
The reason why I didn't go to 2250, and I liked the idea when I first heard it,
Right.
because to me, 3,000, I was joking, but I kind of really wasn't. I just know they fade at the end there. They get restless, as it is now with the 15, because I'm in the schools quite often with recruiting and whatnot. And I just think if we can stretch this, you're going to get pushback. But at the same time, I'd rather throw out, well, other states are 2250, we're 2,000. So we get the win, but at the same time, I don't think we're opening up a can of worms we can't handle.
Are we in agreement for 2,000 hours for the cosmetology program with the provision that it would spring into effect?
What do you think of effective January 1st, 2017? We need time for the people that are currently enrolled in it to get out.
Did you say 2016 or 17?
I said 17, but because it takes time for people to even realize that the law has changed, and there's people that are currently enrolled.
I think the preparation is probably out of consideration for those that have been wanting to start school and wanting to save the money and figure out how to pay for and get in the industry. The blow of, uh-oh, I could have done it at 1,500, now I have 2,000. And maybe you just, everybody that's in the system needs to finish, and we do have a cutoff. But taking into account that as soon as the rules go into effect, then the apprenticeship half-half is going to fall into whatever we dictate.
That's what I'm saying. When is the apprenticeship gonna?
It's part of these rules.
It's right here. So
all
when,
coming
they'll
right.
all be at the same time.
That doesn't mean, again, that your school would
Right.
decide to go live immediately. If
Right.
we did put a 2017 date, your school might decide to wait until the increase of the hours, if we set a date out there.
Because the apprentice program is elective, but this is not.
Yeah, the rest of these that we're doing today will be effective as soon as it's signed.
I don't know any hairdresser that's preparing 2 years out to get ready to go to beauty school. I mean, I get the preparation piece. I think a year would be ample.
Yeah, I'm thinking.
I think that's like more
16.
than, that's probably even more than what would be ample, but I think it
First
makes sense for
16.
preparation purposes, spread the word. Yeah, I would be good with a year.
Because one thing, if I was a student coming in on the 15, going straight through, and then, okay, if the hours are up, yeah, but I get more hours in the salon as an apprentice too, you know, as an option.
It's
So
up to
I
you,
don't,
but
I don't think that.
even though this rule is open and you can do this, the public, and it's not your fault, the public might not have been aware that you were going to discuss jacking the hours up. If so, we might have had other people here.
Kind of like the board wasn't aware the rules were going to get changed, right?
Yeah.
You do need to come to these
We
hearings.
figured out how to adjust so they can too.
Well, I'm not blaming you.
No,
They
I'm
know
not-
there's
I'm-
a rulemaking here. They need to show up, so.
Yeah.
But it doesn't affect anyone who's.
I think a year is good.
I think a year is good.
Me too.
That's fine.
So can I play devil's advocate? Who thinks this is gonna be bad?
I think you may have two people over here who have some concerns.
No, no offense to you, I'm thinking just within hair.
I feel torn a little bit. I feel like it's gonna be bad, and then I see that it can work too. But I feel that some people go, and not to knock our industry, but just to be candid here, some people come into the hair industry because that's their last option. They need something to do. They gotta do something, so they go for the shortest amount of, things that they have the choices between. And then when those hours are up, they're gonna be like, oh, okay, so how can I be a dental assistant instead?
I interview those people every day. I totally get it.
Yeah, but you don't hire them, do you?
No, I don't.
But you just making that statement, just putting it out there.
I've never met so many people who like to be in school so much. Yeah. I don't disagree with you.
Students.
Yes.
Folks, we're gonna need to make a decision.
Well, and I think what we were our concerns were is that if you increase the number of hours generally so that you know what the process is, number one, you'd be statutorily required to do an analysis of what the increase in cost is gonna be upon the student. And that has to be done today. So, because that's gonna be the number one thing that the legislature is gonna ask us, because once you make these rules effective, what you don't see is that this lady right here, Denise has to go up to the legislature and talk to all of the legislators' representatives, and we would go up there and we have to speak with everybody on the government ops committee and explain to them why the increase in 1,500 hours the increase of 500 hours is a good law to be passed, because government ops, when it goes up there, they can have the choice not to approve these rules, and they could drop them so that they basically do not effective after the first year. So they want to know what thought process has gone into choosing 2,000 as opposed to 1,500, as opposed to it's just more education. It's going to be better. The schools like it. I mean, their focus is going to be on my individual constituent, that individual person. What is the increase in their time and cost to do this?
And I apologize. I'm not here to speak out of turn, and I absolutely am not a cosmetologist or a barber, so I have no expertise in that area. But I do have to go to the legislature and for all of our boards and commissions and talk to them when we do rule changes. And the reason that this raised a bit of a flag to me is that one of the questions that we were asked repeatedly on all bills dealing with cosmetology is, why are the hours so extensive? It takes 1,200 hours to be a paramedic. So why does it take 1,500 hours to be a cosmetologist? I am sure there's a reason. And I just want to caution you all that we are, as Tony said, I mean, we're gonna have to do an analysis of how much more that would cost the student, and then have to be able to sell it to them. I think we're gonna have to come up with, I think it would be a good idea to come up with like programs. I know the gentleman spoke about the Department of Education, big DOE, considers 900 hours as one class, and I certainly don't disagree with that. But I know that was one of the only legislator who is familiar with hair is Representative Parkinson, and he's left for a few minutes. So that's my only concern. I mean, what we like to do is to have all of our ducks in a row, to have all of, I just want to share with you some of the questions that may be posed. You know, what other programs require that amount of hours of education, and what's the justification? And so I would just ask you to be mindful and think of that before you change something like that. I'm neither for it or against it. That's not my place. But I do know that there were lots and lots of questions about the number of hours involved in becoming a cosmetologist. How many hours are involved in becoming?
1,500.
For a barber as well?
Yes, ma'am.
Okay.
I guess my question to you, because I hear what you're saying, and I'm the data dork over here,
Right.
so I have to say that that if we're gonna do a comparison, I think I would like to know who those statistics are coming from. Do you have that data that we could do a data mine?
I'm sorry, which statistics?
The statistics on what other programs are of similar hours, what do they cost? I think on the flip side of that is what I'm hearing is, of those people who are graduating from those programs, how many of them are still in that field post-graduation? Because what I'm hearing the board say from established hairdressers is that 1,500 hours is not enough to come out of school and be financially successful. And therefore, I think we all know the data, is somewhere in 1 in 5 people who are graduating from hair school are cutting hair within 5 years. I mean, the statistics are very low that people are graduating and staying in this field. And there are a lot of reasons why that might be the case, but I think there's a lot of data that goes into this other than just what is the cost and what are the goals.
And I'm not suggesting that it's right or wrong, and I wish that I did have other programs. I'm gonna have to go back and look and see if I can come up with, at least in our whole arena of regulatory boards, what other professions we had that could compare to this. The one that immediately pops into my mind, because it was said over and over and over, was it only takes 1,250 hours to be an EMT, someone who's dealing with life and death every day.
How many hours does it take to be a legislator?
Not that many. That's over my pay grade.
For the same amount of hours for a cosmetologist, same amount of hours for an esthetician, I'm familiar with examining the files of these beauty schools and looking at what they're charging those students. There is nothing. There's a huge variance of a full cosmetology program costing a student $7,000 to much more, and then there's a huge variance of like an aesthetics program, same amount of hours. One school that I'm familiar with charges $9,000, same hours, to another school that charges $14,000. So I would think what you're asking us to do is a little bit of a moot point. How much does it cost? Because it's regulated by commerce and the business application anyway. Well, it's not gonna. They're figuring their own costs. If there was one cost associated per hour that we regulate, that would be an intelligent question, but I don't understand why we're answering something that is a business proposition.
Each school charges what they want to charge, is what you're
Exactly. So what difference would it make to a legislature?
I think they're going to say that's 500 additional hours that you're requiring someone to have when they could be out in the workforce. I'm trying to give you what I believe their arguments will be. I'm not saying this is my argument. Again, I don't know what it takes to be.
I really think that the 1,000 hours, we can teach them what they need through their basics in school, have them ready for their state boards, and then the other 1,000 they will be hands-on. And
I just want us to be prepared
because
to be able to answer those types of questions.
As a school, in 750 hours, you just really couldn't teach them everything they needed to know.
I guess I'm asking y'all, help me to be prepared.
I understand what you're saying, because it's going to come back at you, and it makes sense.
Right. I just need to know how to respond. Why that additional 500
My
hours?
response to that would be, we're asked to go through this line item by line item, and we're dealing with fleas, and yet we're ignoring the elephant in the room. Because that's really the premise of where the problem's starting, is that they're not getting set up to win on the front end. And then we're trying to fix it on the back end. So, we're trying to put Band-Aids on something that needs stitches. And so when the congressman spoke this morning in reference to they're not able to get jobs or sustainable jobs, when we look at the crux of all that, it could very well be coming from the fact that they're not being prepared properly on the very front end because of the amount of hours. I know the school owners. They're doing everything they can. But at the same time, you can only do so much in that short period of time.
Industries are evolving. I know in aesthetics, it's just like every morning you wake up, it's something new. So it appears that way in hairstylists and everything. There's more chemistry, there's more devices, there are applications that the consumer's demanding. And if they're not going to do it in the state of Tennessee, they can afford it and they can do it somewhere else. And we're just falling behind in technology. And I think that even the governor realizes that, or all of these discussions would not be coming up in a new board forum to move forward. So I think that you'll need to impress upon the legislatures that we're doing what we've been charged to do.
I would say to the legislatures, I would say, so we're presented with a law that reduces the amount of hours by 50%. As it was in place already, we didn't feel like it was enough hours to prepare students. Now, they're only getting half of those hours before they're being turned out to be apprentices. And so this way, if we increase the hours, we feel like it better prepares them. And to throw this 50% at us, I mean, that was my beef from the very beginning. How can you expect somebody to get half the hours and be prepared? I mean, I don't think they would take an EMT program and say, well, you can, just get half of your hours and then go be an apprentice. Good luck. I mean, this isn't life or death. I know that, but
A lot of women it is.
Well, yeah.
There's a lot of women
I
it
guess it
is.
could be. I did have a really bad haircut. But, we're trying to protect the public still, and that's where we come from. And so my shock and awe was when it came at me that they could take 50% of the hours that we already had in place.
Let's consider also, when you're talking about the cost for students, this could potentially save a lot of students money who just say, it's only 1,500 hours, I think I'll try cosmetology. And maybe people will think twice and make a better decision if it's something they have to invest more time in. Because I know a lot of people who thought, try that. It's only a
Failure
year.
has a cost associated as well. So
Okay, for clarification for myself, legislation want to know how it's going to benefit a person getting into the workforce better or quicker, right? They're going to want to know
I'm
that.
speculating that might be
They're going to
the question.
speculate they want to know. And we're more concerned about educating them well enough to stay in the workplace. So basically, I think that it can work. It's a matter of wording. We're going to stabilize and foundate the student a little bit longer, so once they get into the workforce, they can stay there, opposed to coming out as a cosmetologist and not having a clientele, which the apprenticeship will supply them that opportunity to create clientele as they're going through the education, and they'll be able to stay there, opposed to getting the education and schooling now, and they go out on their own as cosmetologists, and it take them 5 years to even get a halfway steady clientele. Is that what I'm hearing?
Well, and I think one thing that would, and I apologize, I've just sort of crashed into your rulemaking hearing.
Don't apologize. We appreciate you bringing this to our attention.
You're great.
I think when you mentioned data mining, it would be interesting to me, and I don't know, I'm happy to try to dig into this and see if I could find it. I know I did look at one time to see what the hour requirements were in many of the surrounding states, and I think Georgia's 3,000.
But that's apprenticeship. Georgia
Right.
is 1,500, just like us.
1,500. Okay, so are there other states that require more?
Kentucky's 1,800.
But that's with
Kentucky's-
apprenticeship. Oh, that's 1,800 with apprenticeship.
Okay.
I'd like to find the states that the congressman mentioned this morning, all them good ones that he was talking about. I'd go right after those states to begin with and see,
It would
because
just
I
be
know New York is
interesting to
more.
me to see.
Oh, New York
if-
actually, and I hate to correct you, but New York actually has now changed to where the schools decide the number of hours, which is really scary.
That's dangerous.
So, really, there aren't
It would
that
just
many.
be interesting to me to see the graduation rate of
Right.
those. And, I mean, to me, that would make a case,
Yeah.
If
I'd
you
like to
have a
recognize
state that
Nina.
requires more hours, then, if you can follow them and see these people, 80% of those graduates stayed in that workforce for 5+ years versus
Dropping out.
dropping out.
From our
wonder if Indiana
reciprocity
would-
numbers, 1,500 is a pretty average. More than half of the states have the 1,500. A lot
At
have
least.
fewer, at least.
At least 1,500 hours.
Not too many have more than.
National
to be
Beauty
honest with
Association has that on their website.
Yeah.
They have a great deal of data.
Can we not increase hours through the apprentice program?
It's one and the same.
So
Half
it's
and
one and
half.
the same.
keep it
Yep.
one and the same. So
It's the same. Yeah, there's no.
That's the problem.
There's the problem.
Let's say if we did decide that we wanted to increase the hours for cosmetology, you take it to the legislatures. I mean, if they approved it, great, we go forward, whatever. If they don't, what happens?
It won't be approved by them, and its effectiveness would run out at, I think, approximately the end of the year.
We'll be back where
Say
we're
it
at,
won't,
right?
or it might not.
So that it would
It
run
won't.
out. You wouldn't be an effective rule. Your
Oh.
rulemaking authority is basically given to you from the legislature, and they can pull that back.
They fire us.
That's kind of, well, they can override, is basically what it is. It's a check and balance system, so,
There-
and that's our concern,
I
is
get it.
that,
Right.
is that we
We don't
would
ever
not want
like
that
to
to
go
happen.
up. I cannot remember a time where I've been up there. I mean, we've had rules that are controversial, but I can't remember a time, knock on wood, in the recent past that I've gone up there and just been completely blindsided and have them throw it out. I mean, we've had controversial things that are not, no fault of our own or whichever board or program it might be. But I want to represent you guys to the best of my ability and this department to the best of my ability. And so I'm just saying, please arm me with information so that I can make that case. And I wanted to point out that those comments had been made in the past. One thing you never want to happen, and there's another board not attached to this department, where a bill passed and they hated it. And it was probably less popular than the apprenticeship bill. They absolutely hated it and were directed to promulgate rules, and so they just didn't. And that went on for almost 2 years. And the Government Operations Committee met and demanded the appearance of every single committee member at their hearing. And it was not, it wasn't pleasant. I mean, it just wasn't pretty. And, legislators, love them or hate them, they're there. And they're, it's just like you guys are the board. And, I mean, everybody's not gonna agree with what you do, but the best way, it's just better to be deferential than not. And I like to be armed with information, so, I have absolutely no problem with making the argument. I just want to be able to make it intelligently.
I think there'll be money to be saved on students in the failure categories because they're not going to be hopefully failing at such incredible rates. That success will in turn generate lifelong careers. That's the goal. Now, that's a hypothetical, folks. We can't look into our crystal balls. That is our hopes and desires. It takes hard work from everybody, but I think I'm really proud of the board here, you folks, for debating this well, and I think we've heard a lot of different sides to this. I appreciate your efforts, and I think we've got some kind of information.
The only other concern I had, the second thing I had, is that when we did this notice of rulemaking hearing back on November 3rd, 2014, the reason why we had to file it so early is it's required to be filed 45 days before the rulemaking hearing, and that gives notice to the public so that if anybody can read these, and if they want to comment or they don't like it, they can come show up, just like the people that are sitting behind me. What probably wasn't noticed was your all's potential intention to change the requirement hours from 1,500 to 2,000. So what we don't have are people from the public who were here who wanted to make comment about whether they would agree or disagree with the moving from 1,500 hours to more hours. So those persons were not here. So that notice requirement, that gives me some concern. That would be something that we would have to discuss with the Attorney General. I see that when we made the rule amendment, we actually opened up the entire rule was opened up. So you all can change whatever you want within that rule being opened up, but that's just a concern that I have with the Attorney General's office on that. I'm not trying to sway you to say absolutely not. I'm just trying to tell you what your potential issues may be going forward.
Yeah, but that could be the case on every single thing on here. that people didn't know we were going to make a change. It is open for change right now.
Right, the rule is, yes. So, and that's my only concern, is that when you change something like, there's some things that are called cleanup, which is just a little bit for clarification. It's not a big deal. It really doesn't change the substance of the rule. Those are absolutely fine. That's not a problem. So that's just the concern that I would have on that. I'm not saying that you can't do that. I'm just saying that
We'll never know
probably have to
unless we
explain
try.
it to 'em.
I mean, this apprenticeship's the biggest thing that's happened in 20 years. If they weren't concerned about that, then
No, it's just like you said, the paramedic thing. If they only did half of it, and then the other half they got to be an apprentice, I'm a paramedic, they wouldn't approve that.
Practice paramedic.
Did you do apprenticeship?
Yeah. I don't know that I'd let that person in my house.
There you go.
But no, I mean, and I'm laughing with you. I'm not laughing
Yeah,
at
I
you, but
know.
I think I think this is very
Very.
interesting. I think y'all are really defending what you do in
Well,
a
I
good
think
way.
the time to make the change is because the change is made that it's going to be half and half, and it's going to apprenticeship, and I think it's just in fine alignment that you would adjust hours accordingly based on making this whole thing work to the best of its ability. We want to set the thing up, not just tweak it to ram it in, and I feel like that was the whole issue with it to begin with, is let's just take the 1,500, cut it in half, send it out, and stamp it, and I would feel way more comfortable, and I think obviously it's going in that direction, that if we're going to split it half and half, let's set it up to win, and that's to extend both sides a little bit longer, so this way we get to a better end result.
And I think there's a great way to do a comparison across other states, because I agree with you. I think that if you looked at other states that were mentioned today, and that you've mentioned, that if you look at their apprentice programs are much longer than 750 hours. I haven't heard any person on this board say that they know of another cosmetology or barber apprentice program that is less or equal to 750
I don't
hours.
think
What
there
would
is
be
one.
a comparative sampling number, like 10 other states, what they're doing, 25 other states, what they're doing, to help
think-
you?
I think they'll probably be most interested in surrounding states, because obviously
That's a
that's what affects
no-brainer.
our economy. And I would just,
really
Tony and
is.
I were just kind of chattering off mic, and I would say it's going to be very important, assuming you guys move forward. I would encourage you to please come to the Government Operations Committee meeting, not just the chairman, but a couple of members if you can, because they really appreciate that. They want to see your interest. I know you guys drive 3 hours one way, and 3 hours back. And I
like to hear
think
from the-
sometimes they forget that, but
I'd like to hear from the gentleman in the back, please. Yes, sir. What's your name?
Could you come up so we've got you on record? Thank you. Make sure, yes, and if you push the speak, the red button will come on. Thank you.
Oh, it's already there. Thank you very much, Chairman. My name is Michael Martin. I'm the owner of Tennessee Career Institute and Georgia Career Institutes. We have 3 schools in Tennessee and in Georgia. So we're very interested in this, but I think it's important from your perspective, and going back to the legislature, to use Representative Parkinson's own words, that he wants Tennessee to be in the forefront among other states, like other states are in this very rapidly growing industry. And in those states that are surrounding, in Georgia, for example, the apprenticeship program is so discounted that it is 2 to 1 hours in school, and there is no reversal. If a student does not complete an apprenticeship program, we can't even accept 1 hour. They have to start all over again. So we're the only state that I have seen in record that gives equal value to an apprentice hour, to educational hour. In Kentucky, another bordering state to Tennessee, you have to have 1,800 hours in school, plus you are required to have a 6-month apprenticeship in a salon after you finish. And we as a school believe we don't have enough hours already. There's already not enough hours. And education for licensing teachers in Tennessee, we find almost a joke. In Georgia, it's twice the number of hours. And we insist that our teachers take the full curriculum in Tennessee as they do in Georgia, which gives them more. And they're not learning any more of the field things, they're learning the science of teaching. I'm not a cosmetologist, I'm not an esthetician, I'm not a manicurist. but I'm 35 years an educator, and my master's is in education administration. I understand the science, and I think that this whole piece of legislation completely undermines the value of the education that they get. And it scares me, because I think we're going to see a rise in litigation, because I don't think that we're going to have enough time to teach them what they need to know. And we have proof in our own schools, in the 1,000 students that we have among our schools, that just because someone's been in the field a long time, they might be a fabulous cosmetologist, but it does not make them a good teacher. It's a totally different science. It's a totally different thing. And I just don't see it. I want us to be able to help the people that we're going to be partnering with in the salons to show them how to help teach. And there's nothing in the law that lets us help do that. So I have those concerns. But thank you.
Thank you.
Next question, please. Would he be eligible to come to the meeting with us, the one that you're asking?
Absolutely. I mean, they always ask for public comment, and I mean, I absolutely appreciate your comments. It's very interesting to hear from someone who has schools in both Georgia and Tennessee. And I would also caution you, I completely understand where you're coming from. But I don't want us to get on that track of this apprenticeship thing is so stupid, we never should have done it. That's not going to get us anywhere.
No, well, I think it's a good thing. But I just think we shouldn't be discounting education in the process. That's why I love what you're recommending now.
Exactly.
I think the apprentices are good, because it happens right now. I mean, our schools have a very high pass rate on first time through. All of our schools do. But most of the students that go to work for the salons that we put them in end up being basically apprentices for the first year. That's what a good salon does anyway.
That's what we do.
That's what good salons do. So I love the notion of building the apprenticeship into the program. I just don't like discounting the education in the process.
And I don't think, I mean, I won't speak for Representative Parkinson, he's not here. I don't think it was ever his intention to discount the education at all. But they absolutely need to hear, that committee needs to hear from people in the field, because they're not, I mean, you know, some of them are cut trees, whatever that's called, arborists.
Tree cutters.
Yeah, tree cutters. A lot of them are lawyers. So, I mean, but they need to hear from real people in the profession and to truly understand, you know, what's going on. Anytime you talk about increasing anything that's adding more regulatory layers, that tends to turn them off. So, you know,
But if we talk about improving, we could probably get their attention, right?
Absolutely.
Michael, can we count on you at that meeting?
Sure.
Is the
Great.
meeting?
Sure.
I mean, we won't know yet. These rules, I mean, y'all are having the rulemaking hearing, and typically, Tony can correct me because I'm sure I'll say it wrong, but typically you'll have the rulemaking hearing, and then we'll do tweaking and back and forth, and then we submit them to the Secretary of State, and there is no specified time frame, is there, from which they have to look at them and sign off?
Oh, it'll be, it'll be 90 days after
Well, I
we
mean-
submit them. Is that right, Rob? These are regular? So,
But I
yeah,
mean, we
so
go
it's 90
back,
days.
what I'm saying is, we do a lot of back and forth with them
We'll do that
before
with
we
the-
actually do the filing, because they'll say, oh, no, you need to tweak this, and sometimes they're not.
Is this a Senate committee or a House committee?
Right now, the Government Operations Committee is a joint committee. So
Joint.
what I'm saying is they have to be filed, it's a very long and arduous process. They have to be filed with the Secretary of State. When they're actually filed with the Secretary of State, then that's when Government Operations will schedule to hear them. And I know Rob and Tony will keep Roxana, and I will try to keep Roxana as up to date as I can. This is all very frustrating because there's so many rules, but typically what happens is if this were, for example, filed with the Secretary of State today, Government Operations would hear this rule in March. They let them stay there for 2 months. So for January, for their January hearing, they're gonna be hearing rules that were filed in November. So it really just depends. I mean, at the earliest, it would be March.
And I want to say, just for the record, and I know you didn't call me out or anything, but there's so much emotion involved in this from the very beginning because I was blindsided from the very beginning about this law. But I never intended to indicate that I was against an apprenticeship program, because I think they are great. I'm very knowledgeable about our electrician's apprenticeship program in Chattanooga, and it is a great program that those guys go through for 5 years. What disturbed me from the very beginning was the discount of the education, that it was cut in half, and that was it.
And Nana, I apologize. That was not directed
No, I
at
said,
you.
I know you didn't.
It really
you
wasn't. I mean,
could've,
you have,
No, you didn't.
you have given me much more of an education than I think I ever wanted about cosmetology, and I mean, really,
Just that's scary.
no, I mean, we have like 24 different regulatory boards, and we have plumbers and electricians, and but I know a lot more about cosmetologists and not so much about barbers, but I'm learning. I did not mean it that way. I know I know it's very emotional, and I just don't want. I want to caution everybody from doing that, because I mean, we just submitted a report to the legislature that covered all of our programs on the feasibility of apprenticeships, because that's something that they feel strongly about.
And I think we're all in agreement apprenticeship is good.
Yeah.
But we just want to make sure they get what they need.
Thank you for speaking for us. And if you would please make sure that I get your contact information, we'll stay in touch with you and make sure we get you at that meeting.
Thank you very much.
Thank you.
Ladies and gentlemen, we've put a lot of time in on this individual one. Let's do we need a motion for this particular one, or is this just a change that we're and vote at one time?
Yeah, I envision going through the whole
Okay.
two
So-
chapters.
So I believe we're at 2,000 hours for the cosmetology, with a start date of January 1, 2016, and grandfather type period for the ones who are currently enrolled. And
Effective January 1, 2016.
while you're writing that down, if anyone needs to take a break, I would.
I
let
have
everyone be
one
excused.
comment. I'm a little uncomfortable with 2,000. I'll just have to. Just a little.
I am too.
I mean, 1,800, I'm good with. Only because of every other state, when I think about reciprocity stuff that's gonna come, and that's a big difference. You know, when we're looking at other states coming in. I just wanted to say that.
Yeah, and I want to make a statement too. I agree with upping the hours a little bit, but I am uncomfortable with 2,000.
So question is, ideally, we'd have all the information in front of us to say which states are where and where they are with apprentice to make a really, but it sounds like for sake of moving this along in any capacity, we have to throw something out there
vote on it.
to start the process.
Or,
Is that
or
correct?
leave this rule with the hours alone. The only other concern I have, and since Tony's here, I'm going to take advantage of him, and he's got the rule book. I just want to make sure that even though we've opened this rule, that nothing in the law stops us from doing this. If you'll peek at that.
No, I read the statute earlier, and
Okay.
the statute says it's no less than 1,500 hours.
No less, okay.
In practice and theory, and then it goes and it basically has 300 in
Okay.
theory of
For the
shampooing, you know,
rest.
and those are statutorily set as no
Gotcha.
minimums. Again,
Okay.
my chief concern is that I think we could probably defend it, you know, but these were not noticed that we were changing the requirements of hours, and that just really gets my blood pressure up about the nervousness of whether or not the Attorney General's office will say, no, we're not going to approve that, and then we're going to be back again. I mean, I think we could easily at the next meeting discuss just changing the hours and go and get data on what do 300 more hours cost per student on an average. You know, what are other states actually doing, and read that into the record. This is what Kentucky does. This is what Georgia. I mean, to me, that's a more that's a more clean-cut way of changing such a huge requirement is not doing it just on, just by throwing a number out there, but that's my concern. I think we could defend it doing it today, but I would really want to do this at another rulemaking time just on these hours would probably be easier to meet the statutory requirements of not just the notice, but also the assessment of what this will cost the potential licensee.
When would the next rulemaking hearing come up?
Here, is that correct?
Well, we can start one anytime.
Right.
We
can
have a
start one
lot
at the-
more work to do. There's a lot more rulemaking to do to combine these, what used to be two boards, the animals thing, and I mean, it's not like there's nothing left to do.
I mean, at the next, ideally, you could say at the next meeting, oh, let's have a subcommittee on rules, where you have your subcommittee, and you would say, you would have this discussion in your subcommittee at the next meeting, and then bringing it up to the full meeting of, hey, we make a recommendation of doing so many hours, and here's the data that we have, and here's the discussion, and then we could file another rulemaking hearing, and that would be, later on in the spring, where we could change the hours in the spring on that. That just goes through the whole process. Just, to me, sometimes important is the process.
Question, just because this has all come up because of this lovely apprentice program, love it or hate it, this is why this is being brought up. We are being charged with implementing this ASAP, correct? That's why we're here. So I don't disagree with you that another rulemaking hearing would be fantastic, because if we're gonna do this now for the cosmetologists and increase their hours, I would hope that we would get together and be on the same page for the barbers, because I think we are disincentivizing students to go to cosmetology school if they can go to a barber program for fewer hours, and those aren't going to be changed at the same time. We also know, to Mr. Finger's point, that the barber apprentice program is probably right on the heels of this.
We don't know what they're gonna do this year up there.
But we can,
might
I
get
mean,
another mandate to do something else.
If you recall, we put together our proposal, and it does, when we
Mimics
discuss
this.
it, it goes hand in hand with this. For the schools to be able to handle an apprenticeship program successfully, it'd be nice if they were the same. So that's how we wrote it.
I guess, I'm sorry, I'm so long-winded
Yeah.
right today. Is there a way that we can delay the apprentice program? Delay these rules until we have a better answer of what the plan is?
Well, these rules that you're looking at, and Tony can correct me or Rob, they've already been looked at by all the different offices, the Government Operations Office, the Attorney General, so they know that they're on the works. So us not finishing them, I don't think is an option. However, we decide to finish them, that's up to the board right now. But they do have to move through because they've been noticed to the public, and they're on their way. Something has to come out.
On how this apprentice program
As
is going
minor
to
of a
go
change or
into-
huge of a change, they have to come out from here. And then what Tony said is, yes, we know we're gonna be making rule adjustments possibly every year for a little while, until we really get the profession and the two boards lined up the way they need to be. But then that round of rules would take a little bit longer, obviously, if we left the hours piece alone.
These rules have been all over creation. They've even been to the Department of Health for approval. But the governor's office has seen them, and the Attorney General's already seen them once.
I just have to say, I've been up here working on cosmetology and estheticians for about 6 or 7 years. I think it's a good climate to do this, to say this is a new board, this is what we want. Maybe I'm a little bit too much of a gambler, but I mean, I've been talking to so many people, and there's a lot of power in each individual on this board. You have your own senator, your own representative that you can contact, and there's a lot of power in our passion for this. And I think of all the boards I've seen operate, I'm really proud to be on this board. We're having very good conversations, and I just think we're doing good things for the public. And I think it's a good climate. It's not an election year. They got big medical decisions to make up there. So, we are cosmetology, but we're trying to do something good. It's not like we're trying to unscrew everything.
What are you referring to exactly?
Well, I just think it's a good climate to get it through the channels without stopping it now and going back and addressing the hours at a different time. I think we should put these in place as we would recommend and all agree on and vote on, and go with our recommendations and get some,
The change of hours, is that what you mean?
yes,
Oh,
ma'am.
Oh,
I
okay.
think
And I'm sure as we
unfortunately,
go through these pages, there's going to be a few
Yeah.
other things.
I think unfortunately, the way we interpret and make rules for the apprenticeship program would be greatly impacted by the amount of hours there were to begin with. It's like the cart before the horse.
I think we could, there's one other thing that we could help address on that. I think Denise can.
And again, I apologize for butting into your meeting, but one of the things that I had asked Roxana to remind everybody about, and this is probably not very appropriate at a rulemaking hearing, is that Senator Bell has a bill that he asked for the board's input on. And I think that Roxana sent you a spreadsheet that had these different things. I think that is a perfect place to say, we think, the board feels strongly that you should include, I think the language is no less than 1,500 hours. If the board is in agreement on 2,000, then you make the change in that bill so that it's in statute. I only say, it doesn't matter to me one way or the other. I know these attorneys are absolutely stroking out because they have to deal with the Attorney General's office. Rules go through. A rulemaking hearing is truly an 18-month process. It is not pretty, and this bill passed in April of 2013, and it's January, and that's fast. That's fast.
What you're really telling us, though, is that if we want to have another one, you're discouraging us from trying to have another one. We want to get as much done now as we can.
I think what I meant to say is attack it from both avenues. I would say make those suggestions, and I mean you can either make the hour change in this one. I truly believe that Tony's concern is not so much whether they care or not, but whether or not the AG is going to say, that's a little outside of the scope. You didn't notice that appropriately. You know, you just said the rule change was going to be this, 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 and this, and now out of left field. I don't know. I don't know what the AG's office is going to say. I don't deal with them all the time like they do. I'm just saying attack it from both avenues.
I have a question, Rob. Would the notice, say if we did a notice where we were going to amend some of these rules, would it be a different type notice than what we noticed 45 days ago?
Well, no, actually, because we did open the rule up. There is some documentation where I've written some summaries that are public record that weren't published to the public, but it doesn't say in there in our synopsis that we were intending to do this. So some enterprising person could possibly build a case. If they didn't like what we were doing, they could probably dig around and find a way to make it look like we didn't properly notice it. The danger's always there. The AG would definitely notice because they get a hold of those bullet points that I wrote.
And I don't know what their concerns are. Again, I'm not the rulemaking guru, but I know these guys put a lot of time and energy into the rules, and I think what they're saying, and they can correct me if I'm wrong, is that they don't want to throw out the baby with the bathwater. I mean, if it's just if they think that the hour change is going to be that problematic, there is nothing preventing you guys from, I would suggest, really looking at that spreadsheet and saying, here are some more things that we would like to do. We agree with this, we don't agree with that, we agree with this, and here's some more things we would like to do, namely increase the number of hours. And at the same time, you could notice another rulemaking hearing, a separate rulemaking hearing to have as a backup. Now, I don't know how that works. I don't know how long you have to give the AG and all of those people heads up about that you're going to do a rulemaking hearing.
Attorney General, they usually don't say anything because you are the regulatory body for these professions. That's what you're charged with. That's the power you've been given. Unless you wildly act outside the scope of your authority, they may get hung up on a technicality. Sometimes it depends on who gets it to review.
They're not going to have a problem. They would not have a problem with changing it from 1,500 to 2,000. That is not the problem that they would have. The problem they would have is a separate statute, not in Cosmo statute, that these rules, this hearing we're doing right now is all governed by Tennessee law, and one of those things was to provide notice to the public of the potential rule changes. And the hours was not noticed as a potential rule that we were changing to the public, and that's my only major concern about that.
Was that the only thing that's not noticed that we've specifically noticed?
So that's the only thing that I would have real concern about. The whole specialty schools, about the 5 hours for the minimum of 5 hours. I'm not necessarily so concerned about that. The other changes were just really some minor changes so far that were kind of within the scope of what we were talking about. So of what was already being changed. But the concern that I had was that the hours, we didn't change anything within these hours on the rulemaking hearing notice.
Yeah, but still, I mean, here's the rulemaking notice hearing, and it says there's going to be amendments and new. And that would, I mean, we're looking at, and it was listed there. It was listed for anybody to read.
Right, but what this rule right here is the proposed rule that you all were intending to adopt. And the rule as it's intending to adopt says 1,500 hours.
For example.
And then we walked in here and now we have something other than 1,500 hours. So that's really my only issue. That breaks it down.
Can I ask you, is there a disadvantage by coming back later because of it? Because one of our kind of positions is the fact that because of the half and half time being split and tying it to apprenticeship, some of the reasoning why we're looking at extending it is to make both halves be stronger. Is there a disadvantage to us passing that through today under 1,500 and then coming back later and trying to change the hours?
No, there's no disadvantage in that I can see, really. You're just, I don't think 15 to 2,000 hours has anything to do with the apprentice program with the 50% split. I don't think it has anything to do with that. I think you can easily track it. And you guys did say January 1, 2016, so, I mean, it wasn't going to be effective for a year anyways, potentially, so, I mean, we could do another rulemaking here. Wouldn't be too far off from that mark. So it's not like you would have to say January 1, 2017. You may just be, February 1, 2016, March 1, 2016. I know your anticipation may be that we're here, let's do it now, let's get it done. I understand that.
At this time, I'm going to go ahead and ask if we will have a motion on this particular item.
Oh, if you'll note, on the regulatory flexibility thing that y'all have, this is an example of, I've prepared description of proposed rule, and then this is where I'm discussing what we were going to do at this hearing. All these bullet points. Rule so-and-so is amended by this and that. And of course, then there's the economic impact statement. But changing the hours is, of course, nowhere in here because I didn't think we were going to do that. But this is one of those, the Government Operations Committee is going to see some of this stuff, and the Attorney General will see it, and they're going to say, why I don't see it in here. I mean, it's always better to be a lot right than a little right, I guess.
So is
On
your
you called for a motion?
I'm going to ask for a motion on this item.
I make a motion that we move forward with changing the hours to 2,000 with the other provisions.
Effective January 1st, 2016.
That would be correct.
Do I have a second?
I'll second.
We have a motion that's properly seconded. All those in favor say aye.
Aye.
Those opposed say no.
No.
We'll need to take a roll call vote. Ms. Coppinger?
Yes.
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 No. No.
Yes.
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 No, and because of the reasons that you said, because of the way you did the notice.
Yes.
No.
No.
We have 5 noes out of 12, 7 yeses.
I was kind of envisioning getting through the whole thing without having a vote, but we can set this aside.
Now we've got that one down, we can look at the others and move on.
We are on page 5.
Still.
If I could bring us back to that, we've got it at 2,000. We probably need to put in the breakdown of those hours. And the schools would know the percentages, so you'd be able to give me those, pretty much. We've added 500 hours. So is that,
But it,
General hours.
divided out by 3, 500.
That would be 166 general hours, 166 physical hours.
we're just dividing them into
Yeah,
the
just
three?
divide it out.
Okay.
Just divided by 3.
I mean, in addition, is that what you mean?
Well, broken down like 600 hours for,
Right. It's 600, 600, and 300 general, just so we have it in each category.
Right.
Okay. Okay, we're on section B then, and this is regarding the 600 hours for manicuring.
We have just added hours for the cosmetology, which covers all of those additional programs. So for the manicure program, how many hours is required for that? 600 currently.
Yes, and I brought it up a while back, that when we first went over this, that these hours added up to 850 instead of 600, and so we,
Equals 350.
the physical is 350? Okay. That's still 650, or, no, never mind. I had added one, okay. Sorry.
So just to clarify, the specialty hours that we're gonna discuss are also game for the apprenticeship 50-50, correct?
Every program is a
Every
50-50.
program within cosmetology is a 50-50 split.
Correct.
Okay, thank you.
You're welcome.
Suggestion was to add 300 hours to the manicurist program for just the individual manicurist program.
450 in school and 450 apprentice.
Keep in mind, just as a side note, not to stop us from where you are, but remember 240 is what Florida has, so that's the way extreme low, obviously. A lot of the states are between 525 is what Georgia has, and then they have 1,050 something for apprenticeship if you do the manicuring. The 600 that we have is pretty standard or on the higher side, actually. California has 400.
I would like to ask our manicurist, what your opinion?
Well, when I went to school, it was 250 hours. So that was 26 years ago. And I definitely didn't have enough education, but 600 is quite a bit of education. I think that the content of that education is what needs to be looked at. Like estheticians, as far as the antiquated things that need to be, that type of thing to me needs to be more on the forefront versus adding more hours.
How to utilize the 600 is more your concern.
Exactly. I think 600 is good, 700 max. To me.
Only 6? It's, I mean, if cosmetology was 1,500 and a single division of nails being 600, sounds like it doesn't really need changing.
You're getting a lot of, that's a lot of hours.
Cosmetology was the bad one.
Yeah.
The rest of them are probably.
And I did all of my, I did tons of seminars, and that's how I got all of my expertise and knowledge. So
Quality of
the
the-
experience,
But if
yeah.
you had had an internship, you would have learned a lot.
Exactly,
Right.
yeah, if I would have been an apprentice of some sort. But I think 600 is ample if the quality of what they're getting is what it needs to be.
It appears that those hours were right-sized because they came after the fact anyway. Once that rule was made, that it was probably right-sized to begin with. Is that the same with the others? Same with facial, same with aesthetics?
No, she's ready for you.
Well, you're gonna add 9,000 hours, Mona,
12-year program.
in 3 countries.
Well, we are going to add some hours. The National Coalition of Estheticians and Cosmetic Manufacturers did a 1,600-hour work-study course, and that is available as an apprentice work course to licensed estheticians now. And it has been applied to the District of Columbia, the state of Washington, as a master's esthetician attached to their current curriculum. I am a NCA and a CEDESCO certified esthetician, but to bring CEDESCO into it just for a national standard to help Tennessee understand what the needs really are, the CEDESCO work-study course is 2,000 hours. There's an additional 500 hours, and that's for them to get their diploma, and then for them to actually get the international standard diploma. They take a 500-hour apprenticeship, and then they take a 40-hour work-study course. So there's a lot of hours that are implied and applied to aesthetics that are missing in the state of Tennessee's program. So I would propose that we bring it to 1,600 hours from the 750, put 800 hours in the school and 800 in the apprentice program. Currently, Alabama's program is 1,500 hours. Mississippi's is, I think it's 1,100. Louisiana's 1,200. Arizona is 2,500. So estheticians are getting quite the education in other states that's actually lacking here.
I kind of feel like we don't probably need to go over what we did with Cosmo, maybe 500 hours to start with. That would bring it up to what?
1,250.
Is it good?
I'll go with that.
You go with that?
Mhm.
I wouldn't done no more than what we did for the Cosmo.
I'm viewing as more of a percentage increase that I think might have an issue. You know, we stretched Cosmo to 25%, right? And I think
Increase would be 1,000 hours.
yeah, I think to keep it in line with the percentage increase, it sort of gives alignment with reasoning. And yet, I don't know enough about esthetician. I'm just kind of looking at it numerically.
I just think there's a very impressive 1,600-hour work-study course that applies to modern standards of how estheticians are practicing. And so we do have that data and that curriculum that it has set a national standard that other states are moving towards. So if we do somewhere in the middle, I think 500 hours is good to increase. But I just think it's been something that has not had any attention paid to it for a long time. And I had just sent Roxana a report where the aesthetics industry is actually in 2017 rising to a $9.9 billion business. And there's only 2 esthetician schools in East Tennessee. I just think and every school keeps telling me the reason why they don't have a strong estheticians program or any esthetician program is because these students are not getting jobs. And our concern is that they haven't been served well in education. And if it takes a national program of 1,600 hours to give them the education to bring them to the other states, I can argue it. I can present it. It's really important that so many things are not overlooked, because that $9.9 billion is being fueled by certified manufacturer reps, by nurses and physicians entering our business, just because estheticians are not being served well in the education section.
Well, obviously, you feel like there are things missing in the aesthetic instruction.
Mm-hmm.
So how can, just increasing the hours, how can you be assured that they're going to still get what they need?
Well, actually, it's always been a little bit of a mystery and concern to me that there's like so much difference in, like, when 10 years ago the Standard Book of Aesthetics was accepted, and then there was another standard that was accepted as the textbook in the schools. Now we have a standard of acceptance in the schools that PCI has adapted and everything. And there are just chapters and chapters in there of devices that are available in the field, and they are things that are used in practice, but they're taught postgraduate completely, because the esthetician is not really, that's been in school, has really seen these things, but they are required by the consumer.
How tough of a sale would that be with that kind of increase?
Are you saying if we stay with 25% across the board and
Oh,
make it 1,000?
because it's much greater than 25, what she's asking for. She's asking for almost double, right?
A little more, I think
Yeah,
it's 16.
They're going to ask the why, and they're going to want very specifics. You know, keeping up with others. Why you would do it? They would probably, because they don't like to raise things. Generally, they don't like requirements to be more difficult because it's on their constituents or whatever. They would say, well, shouldn't Tennessee be getting more students if it only takes 750 hours, not 1,600 hours?
Exactly.
But it's going to be they'll look at the cost. The most important question they'll say is, what does it currently cost to do 750 hours? And then whatever number you say, they say if you raise it to 1,500, they'll just in their mind say, well, then it's going to be double, isn't it? You've just increased the cost twice as much. And they're going to wonder, you know, is it to increase business in the state of Tennessee? Is it to help protect the consumers, the people who are?
Well, there are some things missing in the state as far as where the hotel industry has a very high demand for estheticians, and they're just not here.
Quality.
They don't, exactly, and that's what you hear is you just don't have the quality. There are opportunities in resort management. You know, Graceland is building a big hotel. They're not going to do the spa because they just don't have the estheticians. They don't have the workforce to do it. I've been consulted with Weston Properties on 3 properties in Tennessee. They do not have an application even. They don't understand why in Tennessee they can't actually offer. And actually the Peabody Hotel, beautiful property in Memphis, Tennessee, has 4 stars, not 5, because they're not able to offer the spa.
Find somebody who's a licensed esthetician, or is it because they can't find a quality?
It's the licensing and the quality. They just don't have the applications.
Mr. Martin.
Esthetician in 750 hours.
But you're affiliated with the Sedesco schools as well, aren't you?
And we were approved for Sedesco several years ago, and the minimum there is 1,200 hours for a Sedesco school. Our teachers are also all NCA certified.
Mm-hmm.
But 1,000 hours, we could pretty much do the basics, but what we've had to resort to, and we've got a couple applied here, we've done additional courses beyond their state license requirements. So we have a specialty beyond their license in advanced makeup, for example, an additional 200 hours, and a specialty in medical assisting or medical aesthetics. for an additional 200 hours, and we're working on a new curriculum right now in advanced body treatments. So that's one way that schools could accommodate that without having to double the number of hours. But I would
In Georgia, do they call it like a master's or an advanced aesthetics?
Georgia
or-
has, Georgia has different names for their licensing, but the state of Georgia's board basically said you can do anything you want to do, it's just not covered by the license. So we do that through our accrediting agency, where we get approval for the course offerings, and we offer the 1,000 hours that's required by Georgia. And I think we could do 1,000, but I certainly wouldn't balk if you did the 1,200, for example. But 1,000 hours, we could give the basics that are required, that would be required.
Well,
But I
1,200
have to
would be a
agree-
giant leap from 750. And I
it would
think it
be.
would satisfy that
But I would have to agree-
apprenticeship
I
part.
would have to agree with Ms. Sappenfield that we don't have enough graduates to fill the need. So it is a very rapidly growing field, and it could use it, but I think it's a separate issue as to, how many hours are in the curriculum. We could go with 1,000 certainly, or 1,200, and be very happy with that. So.
Thank you.
Any consensus on the amount of hours?
My opinion is to ask for the 1,000 and then offer the 200 as an additional course. And I think asking for 25% of anything is seen as a lot. And I'm not saying it don't need more, but I'm thinking maybe because it's as antiquated as it is, I'd rather win part of this than try to lose the whole thing.
I agree. I don't want to be, like, oh, dear, we can't do that. What's the consensus? 1,000?
I agree that maybe baby steps.
This again?
I make a motion for 1,000 hours.
A second.
Same stipulations as the previous motion. We have a motion and a second. All in favor say aye.
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 Those opposed say no.
No.
And one no.
Anyone else?
Ayes have it. I don't think we're going to have to vote on each one of these things individually as we go through all this, but some of these are big enough that probably warrants it. Thank you all for your patience, too.
Effective January 1st, 2016.
Yes.
I'm dividing it. Could we do like 250 and
Just divide out your.
250? Because this,
If we're going to divide them evenly, then that's
just
fine.
so-
I can get
yeah.
that done. I just wanted to make sure the school,
Right.
thought that through. Okay.
perfect.
So we're on D. This is 300 hours currently required for instructors. I know we've touched on this. So.
D?
E, yes.
I thought that was shampooing. Am I lost?
We are on page 6, D.
shampooing.
Oh, shampoo, I'm sorry. I'm thinking instructors. I'm sorry. Shampooing. I will caution the board, again, just to give you all the information as you then run with it. We have very few shampooists licensed left. Probably under 50, if I'm remembering my last set of numbers. So I don't know that we want to even touch this. Thank you. Meaning most of the schools, I don't believe even the private schools offer that license at all. I think way back, some of the public schools maybe allowed you to come out, and if you didn't finish the curriculum, you could at least get the shampooing. And then the Board of Education made it, kind of discussed it with the board, and that's not allowed anymore either. So we have very few that are just the shampoo licenses.
Oh, so they're grandfathered in, and
Right.
as they go away,
And they
it goes
maintain as
away.
they go away, they're going away. That's not to say that you couldn't. I mean, PSI even has the exam for just shampooing. But if the curriculum isn't being offered as a sole license type in the schools, then eventually, yeah, it'll go away.
Is there any school that does offer it?
Not that I know of. I know the technical schools do not, and the public schools can't. You just come in as a full esthetician or manicurist. Okay, so that is D. E is the 300 hours for instruction in natural hairstyling. Regarding the natural hairstyling, a lot of the states don't have that license type, one thing to keep in mind. The other thing to keep in mind is Florida does, that's where a lot of our reciprocity comes from. It's only a 2-day class, it's 16 hours.
16?
Mm-hmm. So of course then we asked, past board had them always test, and now we haven't had one in quite a while. We would be either asking for more hours. So right now it's at 300 hours. Our schools now are actually, we have calls in the office asking for what schools teach that. So there's an interest and a need sometimes, and maybe not enough of the schools teaching it. It's something to think about.
Question? Can you come up to the podium, please, and just give us your name?
Make sure that the red light comes on for you. Thank you.
One of the reasons I'm here today is natural hair care, and it's a big business in Memphis as well as a lot of other places. I was told that it would be housed as its own entity, or where you can, I guess, offer that program, and I just wanted that program to be included if I could request under the barbering license also, because everything is taught there. I teach cosmetology and barbering right now. I teach barbering now. And I was just wanting to address that. It's a very lucrative business as far as concerned across different states. And I just wanted that to be offered in barbering versus having to go through the cosmetology to get it. The only thing that's not taught from the barber's perspective is hair extensions, and you just get whatever curriculum or textbook and include that in. And I was just wanting to address that one thing also.
Can I ask you, how do you feel about the number of hours of training for natural hair?
Should be increased to 600, just for the practical sake. Like it says 300 theory, 300 practical, so they can get out and practice, so you can learn, because depending on the type of natural hair you do, you need the experience.
As a natural hair salon owner, I do agree with upping the hours a bit, because you, as full service cosmetologist, you deal with scalp, you deal with analysis of the hair texture and different things of that nature. And considering that this is something new to a lot of stylists that want to go into this, I think the training will be adequate, and just not many more, but it should be up just a bit. And my suggestion is 500.
Yeah, I don't know all the categories, but I can't imagine why the hours would be less than manicure, or not more than manicure, actually.
Explain yourself a little bit more.
As far as what you would need to know to become a natural hair expert, right?
Because we're adding the extensions and the different types of hair that go with the extensions. Some of this hair that is put on the head, people have an allergic reaction to kind of, know what to look for, know what they can deal with, know when it's time to advise them to go to the dermatologist. We got so many different techniques of braiding the hair in and twisting it out in the process of actually locking the hair.
Yeah, we have a natural hair expert on staff who's busy as can be. So when you talk about being lucrative, she's got a waiting list.
Right.
So I highly agree with you. She's a full-blown cosmetologist, like 12 years experience, choosing to do natural hair now. But I'm thinking if a nail technician is 600 hours, and I see the kind of work she does with scalp and having to identify scalp disorders and things like that, that I can't imagine it being less hours than a manicurist. I actually think it would be more than what we're requiring for a manicurist.
Okay, I misunderstood what you were saying. I thought you was suggesting less hours.
Oh, no, I'm thinking it should be like half of a cosmetologist. I mean, when I think of all the things she's doing, especially, you know, with scalp, you know, I would think if we're at 2,000 for hair, I would think 1,000 for natural hair. And again, I'm not an expert, but I'm just looking at it from a, we're talking about getting an educated properly before we send people out in these categories of nails and aesthetics and hair. And when I heard 3 hours a minute ago, I didn't know it was 300. And I'm thinking, are you kidding me? 300.
And if I could add, I think one of the big differences as far as the grouping with the manicures, there's no chemical hours at all involved with the natural hairstyling, whereas in manicuring you do with the gels and the pedicuring and the different things. In the natural hair, it's general and physical hours only, so the chemical cuts back a little bit because of that.
Yeah,
that helps.
Actually, a little bit of chemical is there when you color the hair, and that's should they.
Well, actually, the coloring of the hair does not fall under a natural hairstylist.
At all.
She should not be doing that, which brings up a topic that I would, you know, like to have chemical fall under that. And that's the truth. So if someone is practicing color under a natural hair license, I advise them to stop.
Okay, I'm just saying, you know, I've seen you go.
There's no chemical.
And if we're going to increase the hours, I don't know.
Yeah, but I would love to see the chemical coloring added into the natural hair because that is something that the clients ask for all the time.
It's being done. I mean, fortunately, my girl's got a full-blown Cosmo license, but it's being done with people that don't. So I think we need to address it.
I got a full cos girl in my shop that does it, but I don't touch it. I don't mess with it. So.
We have a consensus on hours.
I would like to raise the hours and possibly add the coloring chemical service training.
Tony, I don't
If I
know
could
that we
do that.
can add a component to the curriculum that currently the license type doesn't allow chemical.
When you were talking
Sure,
about that,
sure.
So I'm reading the definition of natural
Thank you.
hairstylist, and it gets techniques regarding twisting, wrapping, weaving, extending, which does not include the application of dyes, reactive chemicals,
That's in the
or
law.
other preparations. So the definition of natural hairstyling has pretty much closed the door on a natural hairstylist doing those acts of. That does not include application of dyes, reactive chemicals, or other preparation and alter. So to do that, they'd have to. I believe that's the full-blown license.
That's exactly right. And I do want to caution us as we think about this. This is a fairly new license, but I know that if we wanted to do something to that level to add it, we probably would need to really look at the full spectrum, because when it was introduced, I think its sole purpose was really to keep it at that level, to keep it outside of the chemical and keep it very natural. So that was my reason for the concern.
Make a motion to.
Let me just add,
Go ahead.
so when it was introduced and accepted at 300 hours, it was equivalent to shampoo, even doing. Yeah, I think we should still deal with the hours piece,
Oh, yeah,
though.
yeah. I'm just saying the chemical piece can't
Right,
be added
right,
because of the
right,
law. Yeah,
right.
yeah.
Bobby, did you have
Are we
something?
still dealing with her suggestion, putting it under barbers, or?
We
No,
can't.
we can't
We can't do that,
we can't
okay.
deal with the barbers.
Meeting you could, right?
Oh, on ours, we can add that, yeah. Where we're at here, we can change the rule for the number of hours.
I suggest 300 out, go from 300 to 600 to start with.
I can second that.
We have I guess, a motion and a second to increase this field to 600 hours under the, with the other stipulations. Is that correct? All those in favor say aye.
Aye.
Opposed, say no.
No, sorry.
Thank you, Kelly.
I think it'd be nice to have representation from that field to that meeting.
Yes.
I know Pearl Walker, that used to be on this board, she preached and preached and preached that they needed more hours in this, and I guess she would come, and you could come, and because I don't know anything about it, but when they see that we've doubled those hours, they need to know why. And I think that field has just exploded. I think years ago, there,
Yes, I can comment on that. And within the last few years, it have exploded to the point where there are natural hair salons standing alone with no other service besides natural hair.
right, and 20 years ago, were there any?
No, not at all.
Okay.
Thank you very much. We appreciate your input.
Thank you.
Letter F now is 300 hours for instruction in the application of an instructor's license.
Are there any other instructors in here besides myself? Oh, Bobby, thank you. Oh, thank you, Diane. Folks, I hate to keep making these recommendations of increases in hours. I will say I certainly don't feel like the number of hours for an instructor training is anywhere near sufficient. What is it, 300 and?
300.
I believe it's 340 on the barber side.
450 on the barber
450
side.
on the barber side. So the barber is actually more hours than the cosmetologist right now. Have a recommendation? Do you folks have recommendations?
Got you.
If I could correct you, within the cosmetology, the junior instructors don't actually have to do the program. They can instruct under a supervisor for a full year minimum and then test. Not take any? No. The trainees, the instructor trainees are in school for 6 months, take the exams, and are in school. The junior instructors don't have to be. So there's both of those areas in the cosmetology law, and they're a little bit tricky. An instructor assistant. It's a different. Yeah, they're slightly differently, but
I'd like to remind people, if they make comments, to come up and say who they are and speak into the mic, please.
We have someone in the back.
yes, please, if you could.
And let us know who you are.
There's a sign-in sheet right there.
Yes, before she gets over there, I'd like to thank Mrs. Tolliver for coming up from Memphis, being my guest today.
Hello, I'm Tasha Parham. I am a licensed cosmetologist, licensed instructor, and placement manager. So I can kind of see things from all aspects. From the instructor, I've also taught the instructors. So from the instructor's end, it is detrimental that we actually up the program hours, being that by me being an educator, I've been able to get my educators placed and of course licensed, but that comes with me doing extra time outside of those 300 hours that I don't necessarily get paid for. and everybody's not going to do that. And one of the things that they talked about earlier is the suffering of our students possibly being in part of the suffering of lack of education on the instructor's part. And depending on what school you go to, sometimes there's no education at all. So with that being said, if you increase the hours as well as put a requirement on what's going to be necessary for a cosmetologist to apply for an instructor's program, I think that would help us all greatly.
It's not just the hours, you would say it's also
The cosmetologist being able to go right into an instructor program. There should be a
Or wait or
time
something.
requirement, an actual placement requirement before they even get to apply for an instructor's program. And with the junior program, I mean, once again, that's something that's optional for those schools. So most schools don't choose to do a junior program because they want to go ahead and get an instructor in a program and get them hired ASAP, and that's not good for anyone.
May I ask you a question?
Yes.
What would your personal recommendation be of how many hours it should take for someone to apply for an instructor's license?
Well, how many hours
Yeah,
of experience?
currently it's 300. No, not the
Oh.
experience side, which I also agree with, by the way.
Okay.
But as far as how many hours that you think they should
At least
study,
5. I think 6 would be better.
500?
500.
So from 350 to 500 or 600?
No, it's actually 300 right now.
Oh, it's 300. Okay,
Mhm.
yeah.
Mhm.
So you're saying to up it
At
to either
least
5
5.
or 600?
Yes.
Thank you.
Okay.
Yes, ma'am, please come up. Please.
To piggyback on what she was saying, in Mississippi, you have to have 12 college hours in education to teach. So like she was saying, it is lacking. And some schools, you don't get that. When I went for my cosmetology, and I hate to say this, but the truth of the matter is I was told upon enrolling that I would be a junior instructor, this, that, and another. But when I got there, I had a roster, and I was thrown right into the fire. And so, yes, they need to have the educational component put into place. Whereas, like they said, with either one, you can go in and just do a couple of years, 3 years. But my complaint was that there's no educational background. Barbering background, like they said, is one thing, and education is another. And that do need to be addressed. Okay.
Do we have any recommendations?
I like what Michael had to say. I mean, it's not my field of expertise, but to me, logic would just set in that half the amount of hours probably wouldn't be asking too much. Now, it's kind of a stretch from where it's at, though. I mean, that's my only reservation.
One other thing I do want to caution us is we have calls often with people wanting the instructor program, and it's not being offered at the schools. They have a hard time finding the school that offers it.
You know why? Because 300 hours does not get them Pell Grants, and the bigger schools, well, the
What
money.
does?
You're probably very right.
Yeah,
What does get it? Well, how many hours would get him a Pell Grant?
600.
So that's minimum.
Yeah, I mean,
Right.
600 will help the students get any kind of Pell Grants if they're qualified for it. That's their number by the
That
government.
does consider the cost to the students in each one of these programs.
Otherwise, they're paying for it out of their pocket.
Yes, ma'am.
We offer, I'm with Empire
Can
Beauty School.
can we get your name?
Michelle Dietrich. We have 5 schools in Tennessee, and we actually offer the instructors program in Memphis. And to get instructors for our own schools that we've seen go through our COS program who are passionate about teaching, we actually have to scholarship their program just to be able to let them in because they can't afford to pay for the program out of pocket.
That's probably
So-
why you don't see all the schools offering it.
Yeah, because it is 100% out of pocket unless we have scholarship opportunities. So we find the students that are passionate about teaching that we know we want to come teach for us, and we actually scholarship there.
And I think that if you up the hours and it becomes more affordable to the student instructor where they can get Pell Grant, I think it's a win-win for the student and the school and for the student because you'll actually have someone that's knowledgeable to teach, and maybe we won't run into those issues where they come out of school without knowing a lot.
And I'm in agreement with like giving some time before they're eligible to become an instructor, like having to work for at least a year or something before they can come back or two.
The Pell Grant situation, I mean, what are the other requirements? Is that just purely a financial?
It's the government Department of Education.
They don't require any experience in order to
Do it? No. They just require each program have 600 hours, and your students are qualified for a Pell Grant based on their income. Mm-hmm.
So, Frank, what was your recommendation again?
Well, I like the idea that it was 750 based on it half. I'm not saying half 1,000 on 2,000, but I would think at least a third if we were going to use a formula, because that would double. That would at least double what we currently have, right? So we're looking at what, 660 some odd hours. So maybe 650 is the number. If it was a entrepreneur business, I'd say half, but I mean, we got to see what we can maybe get through here. And again, 600 seems to be numbers in other things. I don't know if that really matters here, but it seems to be a number that's out there, and that would double the amount of current hours. I guess 600 would be my recommendation.
plus some length of experience, or just increasing the hours?
I think
No, length of,
I just checked with Tony on exactly that, because I think I've heard that across, and that we would like to do that. As we discussed, the particular section here doesn't allow us to add anything regarding experience without it really having changed completely, if you will. So I think if the board is comfortable, and the inclination's been to look at the hours and change them where needed, the experience portion we may want to add when we do the next round of rulemaking, and maybe look in depth on the breakdown of curriculum, whatever else, and go further with that, but not here.
The opportunity to increase the hours, at least.
Because the
keep in
rule
line with what
is
we're
open
doing.
touched, right.
Fair enough. Okay, thank you.
You're welcome.
Did you make a motion, Frank?
I'll make a motion to increase to be instructed from 300 hours to 600 hours.
Second.
with the previous stipulations
Yes.
for starting in January and.
Oh, with January, yeah,
Yes.
yeah.
Okay. All those in favor say aye.
Aye.
Opposed, say no. No. We had one no.
Could I ask who seconded it, please?
I did.
Patricia, thank you. I'll let you get back on track. So we are on letter G. To the extent that the prescribed curricula of courses of instruction are substantially similar, the board may allow the general hours of credit accumulated by a student to be transferred from one course of instruction to another. That hasn't changed at all. That's kind of what we do now. H, any person holding a Tennessee Barber license will be given credit for 750 hours. This, I don't believe, has changed at all. Am I correct? Okay. So in order to be eligible for the above credit, a barber must be enrolled in a cosmetology school full-time, minimum of 25 hours a week. Everybody's got that in front of them, so I'm not going to continue to read it. If there's any questions, concerns, points at which we want to stop, please let me know. We're on I. Notwithstanding the provisions to the contrary, any school operated under the Tennessee Cosmetology Act of 1986 may develop courses of instruction and practice incorporating an apprentice curricula, which allows an applicant to obtain 50% of the required hours for a specific license through classroom instruction and 50% of the required hours under the direct supervision and responsible charge of a licensed professional who meets the requirements set forth in this rule. Supervision hours received may not be used for credit for more than the 50% of the required hours in any instruction category. And that means general, physical, or chemical. Okay, so as we go through these, you all may want to stop me when something that's been questioned or asked or brought up needs to change here. Number one, for the purpose of this rule, responsible charge shall identify the licensed professional in supervision of a student enrolled in an apprentice program curriculum, approved by the board and responsible for all aspects of that student's apprenticeship instruction. Number 2, any school offering an apprenticeship curriculum shall maintain a record of all hours completed under the apprenticeship program, including classroom hours, for which credit is awarded in a student's academic file. This record shall include the number of hours completed under direct supervision and responsible charge, the dates these hours were earned, the license number of the professional in responsible charge of instruction who directly supervised the student, and the signatures of both the student and the supervising professional in responsible charge.
I think we gotta back up page 6. Name H, about the barber. We changed it to 2,000 hours.
Barber did not change.
Well, in paragraph 1, it says, after the student has
half.
completed the first 750 clock hours in a cosmetology school, the board may apply the second 150 hours. I guess that needs to be changed somehow.
Well, first paragraph, any person holding a valid Tennessee barber's license will be given credit for, do you want to still give 750 or 2,000?
Well, they can't give 2,000, you mean half, 1,000.
The barber wouldn't be able, would
Right.
never be able to achieve,
I don't think we changed that. But I'm just saying that we have to change this down here where it says first 750. So it has to be,
The remaining, whatever, yeah.
yeah. Still keeping the 750 could transfer from barbers. And
So
then,
we're transferring about half of it to Cosmo, so would you not transfer the other half? Like to 1,000?
I wouldn't change the barber. I don't think we
Yeah.
can.
No, we
Can't change the
We can't.
barber yet. When we do change the barber, could we
Oh,
come
but
back to
unless
it
I'm
then?
missing something, it doesn't say anything about the remaining, because all that's gonna happen is they're gonna have more left to take instead of just 750. Am I right?
Yeah, because the difference just changed.
Yeah.
so then that barber would end up needing to take an additional 500 hours
Absolutely.
in the Cosmo program, which would cover cosmetology items perhaps that they'd be
Okay.
missed.
We're good? I'll let you get back to reading. So we're on letter I? You want me to?
Okay, the required records should be maintained in the student's file and made available for inspection during the student's academic career. Should be maintained for a period of not less than 7 years after a student is no longer attending the providing school, and shall be made available to the board immediately upon request during this time. And a daily log accounting for all apprenticeship hours awarded under this chapter by any school offering an apprenticeship curriculum should be maintained by the school and updated monthly. This log should be made available for inspection at any time. Move to 3. Any supervising licensed professional in responsible charge as provided in this rule shall have at least 10 consecutive years of experience as a licensed professional in the field of study in which the supervision is provided, and hold a current valid Tennessee license issued by the board in the field in which supervision is provided. The supervising licensed professional's license must be current at all times while providing supervision. Now, the word consecutive is not in the statute. but
Like
it's
to
in
strike,
here.
yeah, I'd like to strike consecutive.
That's what I was thinking.
Yeah.
Remembered. No. Do y'all wanna strike out consecutive? Okay. It's not in the law. We put it in the rule.
Law just says 10.
Rob, we may need to back up to the previous one, number 2, or I, a daily log accounting for all apprenticeships. At that point, it says it shall be maintained by the school and updated monthly. Okay, this is dealing with the school. When we're dealing with the shop, or does it need to go here, the supervising professional or the establishment would need to submit some type of report probably to the school.
Will they do a weekly report, or or you want them to do every day?
My question is, does that go here, or would it, in another place.
Wording should go here.
Yeah, I do too.
I guess the way I would read this, Ron, is if you and I were partnered up and your students were at my shop, that I would owe you a monthly report of their hours in a log, but it would
Exactly.
live at in your student file.
You would do it on a daily basis.
Yes. Somehow.
Somehow.
We put our hours in every week.
Okay.
So, I mean-
And that will be submitted to the school. There's a rule that requires the school to submit a report to the state by the 10th of the month. So
that would be
getting it into the hands of the school in some way.
Did I not
is
read in
important.
here somewhere that the shops would be required to give it to us by the first of the month?
That was in some recommendations that were made.
Okay.
And not to interrupt, but two and then 3 right below it is talking about the supervising licensed professional. So I'm not sure if we want to put, then it really doesn't matter. But if we want to put whatever it is that supervising professional has to do somewhere down here, and you're right, the school's going to need it at least by the 1st, because we would love to get those hours before the 10th being the latest.
Or they could send them in every 2 weeks.
Right.
To the school, and that way we can stay on top of it. If they're not on top of
It's
that,
a good
we
way to
can
audit it, right.
we
And
can kick
you
it
have
back
to
to
just,
'em.
each school can work some of those details out. We have to make sure that the rule has the minimum of what has to happen, so that a school doesn't at the end of the year go, oh, well, I was never sent anything and now I don't know, and that the student suffers. That's what we don't want. But we don't also want them to have to report to you every week, because those professionals that have a full clientele, they may not want to every week have to turn in things. Hopefully they're keeping it and have it, but
The last sentence on one of the suggestions I had from this morning was, this log shall be submitted to the approving school no later than the close of business on the first day of each month for the previous month.
that's good.
You have to say the first business day of the month.
Yes.
That'll go under I. No.
Do you want to include that in number 2 or number 3 is my first question.
I would think I would put that at number 2.
2, okay. So it's number 3.
Thank you.
What number is it on your sheet, Mr. Gillihan?
It's the last sentence of, under apprentice records, number 1. Probably the second page.
And what was the decision, no later than when?
The close of business on the first business day
First business.
of each month for the previous month. And I think we have another one that would go under the records as well. Should an apprentice change, it's number 3 on that same page. Should an apprentice change salon or shops or supervising professional, a notarized transcript of total hours accumulated shall be signed by both the salon or shop owner or manager and the supervising professional, and submitted to the approving school within 10 days of the change. Typos in there, I apologize.
Why are we bent on the notarized? Just because we've been eliminating that elsewhere?
It would be fine to not notarize that with me. It was, just seemed like the correct person would be signing them.
I don't disagree with you. I just,
Yeah.
we've kind of moved away from all other notarizing.
Well, that was
I'm from another school.
cool, but what about a shop?
Yeah, a shop. I'd rather have it notarized from my backup.
Shop owner may, if
From my
there's ever a
paperwork.
script, might not be there.
From the shop.
We'll leave notarized there if that's how the school is more comfortable. This isn't a document, at least at this point, that's coming to the board, am I correct?
Correct.
The
Just for
goal
our
is-
records.
Correct.
With NACA and stuff.
Oh.
Did you want notarized or not?
Yes, they want. Wilhelm, did we want to say it's, and submit to the approving school within 30 days or 10 days?
10 days.
10 days.
10 days. If that school has to process a student rapidly to get them back into another situation.
Okay.
Alrighty. Number 3, supervising licensed professional and responsible charge is provided in this rule should have at least 10 years of experience. Okay, we went through that. Number 5, participating school should be responsible for confirming a supervising professional's qualifications to be placed in responsible charge of an apprenticeship student provided by this rule. Okay. 2, participating school providing hours for supervised apprenticeship credit shall maintain documented proof of a supervising professional's experience and a copy of the supervising professional's current valid Tennessee license. This documentation should be maintained for a minimum of 7 years following the date that the supervising professional last provided supervision for that school. Apprenticeship experience earned in any jurisdiction other than Tennessee be considered for purposes of complying with this rule, provided that the supervising professional in that other jurisdiction was appropriately licensed at all times when responsible charge was provided for the purpose of earning credit. Proof of the supervising professional's credentials must be provided by the transferring student candidate.
I have a question about that one. So do we look to see if that supervisor had 10 years of experience?
Well, the transferring student needs to be familiar with our rules enough to provide the credentials of the
Well, this says just
supervising
was
professional.
appropriately licensed at the time.
I think it would be interesting to see what other states, what their rules are for. I have no idea.
Well, they're going to submit X hours for apprenticeship, and during those X hours, they were supervised by so-and-so. So they need to provide proof that during all those hours, so-and-so is licensed the whole time. Shouldn't be that.
Any of the states that do the apprenticeship, if the student ends up not getting licensed in that state, because what we see now through is reciprocity. They actually get licensed and come through, so that's a no-brainer. But if they don't get licensed and they just get the permit as apprentice, then they do similar to what we're doing where the shop has to approve or do a log of hours, so they'd probably have to submit something along those lines.
But as this is written, they could be in another state doing an apprenticeship program and be supervised by someone who has just been out of school for 2 years and has their...
They most likely wouldn't have the 10 years, so
Right.
whatever they present, the board would need to review to decide
Okay.
if it's appropriate, or if it goes like this, the school would have to review it and say, okay, Is this enough?
Okay.
Qualified to be a supervisor. No participating school shall allow any person not appropriately licensed to provide any supervision for purposes of this rule, nor shall any participating school allow credit for hours under the supervision of unlicensed, that's supposed to be persons, not purposes. Next rule. Okay, that was our apprenticeship rule, that long rule was. So what else needs to be, do you feel needs to be in that rule? Based on what comments we've heard and the ones that have been submitted. That covers it for now.
Well, on my suggestion for the being able to take the state board theory part after 750, could we add the 1,000 to it? Since we changed Cosmo to 1,000 and then half of the other ones in each field. After 1,000 hours, they can take the theory test. That way,
Regardless of how they break up the apprenticeship, so.
right.
But they would just be eligible.
Way if they decide to go on to apprentice in the shop for the other 1,000, then it's still fresh on their mind. So they're not just.
We have to think about, in the following rule, 0440-01-.05. On number 5, it says that each school is to teach a minimum of 10% of theory hours each week. So is that gonna mess up? Like if they've done all their theory? Test it.
Well, I don't think that applies to a particular person.
It's what the school's teaching, whether
They
you're
teach
there or not.
10% of theory hours each week in each curriculum.
Okay.
Most of my students get through with their books probably around 1,200 hours. So they could really double up some if they wanted to, because we do the pivot point with the online stuff too.
Each student is on their own schedule because they all start at different times and finish at different times. So I would say that
Well, but if it's just what the school has to provide, then it doesn't mean each student has to get 10%. Okay.
I think it does.
It does.
I think it means each student has to get 10%.
on the Barber side of it, a student is required to receive 1 hour of theory classroom each day of attendance.
Okay. So, but like if
Probably
they're
need to
gonna-
put that in there then.
10%.
Oh, but, okay, so maybe we get into the discussion now, is if they have passed their theory in their apprenticing, do they come back to the school 1 day a week, 2 days a
They-
week?
They would have to
But
work.
we haven't said anything that says you have to be done with a certain amount of hours at school, right? I mean,
I think
'cause
that's what she had proposed with,
Getting them to take their theory when they hit their 1,000 hour compared to their 750.
Just keep in mind, well, if the hours get approved and we're at 1,000 hours, the exam, the theory exam is on the whole book. It's on everything. And so.
So
if-
they've got to cover the whole
Right,
book.
as long as it's all covered in the book and they're done, then they should be. Okay.
point was, before they apprentice, they should pass the theory portion.
Right,
So
that
we
way
can
they
put that
know.
at 50%, whether it gets
Right.
approved or not. Okay.
Right.
It's gonna be up to each individual school at how they do the program, right?
Not
Whether
if
they
it's in the
do-
rule. Whatever's in the rule isn't
So-
flexible.
So your rule, what you're proposing is they do the 1,000 in the school and then go do.
Or whatever. I mean, they've just got to they've got to cover their whole book before they take their test, whether it's 1,000 or 1,500 or whatever. But if they're going to go out of the school at 1,000 and go into a salon, they need to have covered their whole book and take their test before they go out into the salon they're apprenticed.
But you'd have to reserve 10% each week of that remaining 1,000 hours in order for them to meet the rule.
And they should probably come back anyway to, like I mentioned before, maybe check in and maybe give report of the things they've been practicing, like as
Because
if they
that's
were
more
on
like
the
your-
clinic.
Your theory is more in your general, and then you have your.
What did you have there on that one, Rob?
But one of the things to consider regarding the 10% that Ms. Barker is talking about, that number 5, does it have to be there? I mean, does that teach a minimum of 10% of theory hours each week in the curriculum offered by a school? If the board is proposing that the theory exam be taken fairly early on and then all the practical learned, I think that 10% might be there so that the student is still current with everything. And one of my thoughts was a school could actually go back and forth with the apprentice students. That's not, from what I'm seeing, what the board would rather see. You all would rather see them finish the theory and test. I just, are they going to forget the theory? I don't know. But that's the reason, I think, for that 10% to be there. So until the end, they're still learning the theory and staying with everything. But if we're wanting them to take the exam first, then that 10% may be able to come out.
Or if they're not participating in the apprenticeship program, it would need to probably stay. I mean, each, because you probably have
we can add that.
students- Yeah.
Just need to add a sentence.
Just add a sentence.
Yeah.
Doesn't apply to apprenticeship.
This does not apply to apprenticeship, to a school or student under the apprenticeship program.
That would be better.
That lead us down a dark road on the early side of that program where the schools aren't. I think it would work out okay, but I can see that could happen. I think the rule originally came into play because they wanted to ensure that students were receiving some instruction daily or on a regular basis to guarantee that they were actually in a theory book and learning that portion and not just being placed on a clinic floor and being used as unpaid labor. So,
I have a question. Just one big question. So as the law is written now about the apprenticeship program, it doesn't state that you have to do the apprenticeship hours or the school hours first. It doesn't state that, which, I mean, as it's written, a student could go out and apprentice day one.
There's that minimum of 200 hours because it does say it can't violate any other law. And the law says 200 hours must have been covered in a school before they can hit the salon floor. So that still would trump.
Okay, so 200 hours, but if we did this, they would have 1,000 hours, and they have to, we could say they have to pass the theory portion of the exam before they can go to apprentice.
Yeah, there'll be some guidelines for
You're
them.
putting a lot more structure in the timeline on how that works.
I know.
I like.
Well, that's what she was intending to say, right?
Uh-huh. That way they're not just going to apprentice and not know what they should cover in the book.
Well, I'm just thinking of the handoff, right? Your students come from you and they go to Frank's hobby shop or wherever, and at what point is there sort of a
Well, there won't be.
handoff?
She'll still be responsible for them all the way up till they take their practical exam. She'll have to go to the school.
Yeah, make sure
need
your
to speak
volume
up
is
or
on.
She'll
get
have
to
to
my-
go to the school and check on them regardless, right? Is that what you're saying?
Yeah, I mean, it's gonna be the school's responsibility to go
Right.
check on them
All the way up to
to
graduation?
graduation, yes. To make sure they're not just sweeping the floors and washing towels.
I don't think there's anything written that says they have to. There's nothing written that says, I mean, they should, yeah. They should check on them, I don't know, once a week, twice a week, I don't know, while they're doing that apprenticeship part of the program. But there's nothing written that says they have to, and theoretically, they could not see them again until the supervisor signs off on the rest of their hours, and
I think that's one of the suggestions that I had in here too. Was school owner or employee of the school can check in on a student to make sure they're in person or by phone, either one, and to see what their statute is.
well, and that still leaves it open, can check in, I mean, sure. But must check in once a week, twice a week. I don't know, we have to say what this, what the school has to do when you've turned this student loose to apprentice, and you're still responsible for that student. I mean, most people would do the right thing and check on them, but as it's written right now, you could not see them again.
Yeah. So I think the school has to step up, and if they're going to offer the apprenticeship, they've got to follow through with it.
We got to state what they have to do, though, during that apprenticeship program.
Right, and they must
Can we not
check in
make
on them.
that, can we not make that a stipulation that they have to be checked on they have to be supervised?
And whether it's me or my instructors or whoever, one of my employees or whatever, you can send somebody over at least, every 2 weeks or once a week or whatever to make sure they're there.
That might be difficult if you had 50 apprentice students at 50 different salons. It might be easier to have them come back to the school.
Having them to come back to the school doesn't mean they were at that shop
I know, but to
working.
give report or something.
Ryan?
Ryan Hurt. If you give us as a school the option to be able to regulate, do they go to me 2 days a week and then salon 3 days a week? And that's going to be real tough to make that rule, first of all, feasible, because they're coming to me so often. And then on top of that, how does the board regulate that we're even following that rule in the first place? Just allowing yourself that leeway that you're hopefully going to give us as schools to decide to or not to. Being able to know that I can get my kid back in class for a couple days a week is more appealing to me and what I would want my apprenticeship program to be than to say 750 hours with me, take a test, and then 750 hours with somebody else. I'm a little controlling, so I want to be able to know that I've got my finger on that student as often as possible, whether once a week, once a month, whatever the case may be. So that was thrown around earlier, so I wanted to bring that back up. That will completely contradict what you're trying to do if you allow them to space out the hours in per week as opposed to completed hours.
Leapt ahead a page.
Okay.
We need to go back to page 8, high school equivalents. I'm not going to really bother reading it. What we did is we changed it to a general educational development test because there's more than one out there. Before we were, I think.
It just said the GED
Yeah.
specifically. This allows for the high set exam and anything else that through time comes in, so.
That's all we did there. Requirements for schools. What do we do here? Every school of cosmetology, including any school solely licensed to teach natural hairstyling, manicuring, or aesthetics, shall publish readily available and clearly expressed admission policies and requirements. This is actually establishing the separate schools. Cosmetology. And it's pretty much identical to. And we come down to 5 about the teach a minimum 10% of theory hours. What do we want to do with that? Want to leave it as is and say it doesn't apply to apprenticeship students, or I'm not sure how we left it.
I don't know, he's got a good point about having them come back in and,
Well, let me ask you something about the schools and the testing. Don't you right now test your students periodically, not only on the theory, but on the practical?
Yes, we
And
do.
so your testing would still continue
Right.
for someone that signed up for an apprenticeship program.
Right.
That's how you know, I think that's how you know that if they're in the shop and they were supposed to cover coloring this entire week, if you're testing on what they were supposed to cover and it went terrible, you know something.
Kind of gives
It's
us a
pretty
guideline
Yeah.
of the curriculum that we
Right,
talked about earlier, and
exactly.
keeps people on pace.
Mm-hmm. Mm-hmm.
What do we want to add here?
We have a question, Mike?
Suggested, wouldn't we be out of line with the legislation because they would end up with an additional 100 hours of theory, so there would no longer be 50 and 50. So we really have to have the language you suggested to exclude the apprenticeship program from that 10% theory. If they get 1,000 hours in school and then they get an additional 100 hours beyond that.
Yeah, we either need to delete it or add that. It's pretty much our choice. Sir, do you mind to put, have you signed in your sheet yet? Your name and address. So do you want to,
We had a couple of recommendations to add.
okay. It doesn't apply to apprenticeship. Requirement does not apply to students enrolled in an apprenticeship program authorized by this rule, or authorized by this chapter. At Rule 6, enrollment of students. Every school of cosmetology shall maintain. Now, when it says every school of cosmetology, do we want to, are we going to say that that's a generic term?
For the specific schools, do we need to go through one by one?
Every, are we going to say every school of cosmetology means every licensed school?
Maybe we put that, every licensed school.
Every licensed school.
Yeah, I like that,
Sounds good.
because otherwise,
Every licensed school and then take out of cosmetology.
In other jurisdictions, I've seen it written out, long form.
Okay, every enrollment of a student in a licensed school be evidenced by written enrollment agreement that clearly details the rights and obligations of both parties. This school shall furnish the student enrollment agreement, a copy of the agreement as it goes in the student's file, and I don't think we changed this.
no, I don't think so.
All right, next rule, number 9, examination passing scores and school attendance ratio. The minimum passing scores on all exams held by the board shall be 70%. The school a student attends for 60% or the greatest percentage of all hours, including hours obtained through an apprenticeship program, will be the school responsible for the pass-fail ratio. And number 3, we changed a little bit. A student who graduates from a licensed school must pass all examinations no more than 3 years after passing the initial theory examination. All scores of any past examinations after that date will be vacated and the graduate must retake and pass the initial theory examination.
Rob, I have something, I'm not quite sure where it will go in here. A student must be actively enrolled in a licensed school to participate in the apprentice program. Where would we need to put something like that? Those in our notes from the morning.
Under it, the enrollment of students, I mean, I think that's where it
probably a
would
better
fit,
place.
don't you? Yeah.
Okay.
So we've got 1, 2, 3, 4, 5, so maybe number 6. And what number is that on your list?
This is not on my list. It was
Okay.
on, I believe, Mike's
Okay.
list.
Okay, what do we need to say?
A student must be actively enrolled in a licensed school to participate in an apprentice program.
Okay. The student must be enrolled.
He said actively
Actively
enrolled?
enrolled.
Yeah.
A licensed school. In order to participate.
Should that be must or shall?
You can use shall if you want. They're both mandatory. I like shall, we'll use shall. Students shall be actively enrolled in a licensed school in order to participate approved apprenticeship program.
Before we leave this page, where it was at the top of the page, it was talking about the signed agreements and all that. Do we accept the where they sign electronically?
You mean just the school, the agreement itself?
I mean, or anything that comes. We had that come up sometime. It was an issue, and
Their contract, I would imagine that the schools go over it with the students and
Okay.
get a signature.
And they sign in person.
Yeah, in person. And then put it in their file and give them a copy.
okay.
Okay, so now, under the examination, Rob read 3, so here's where we would add at which point you want them to take the theory exam, under this examination piece.
That's number 4.
That'll be 4.
So when do you want them to take the theory?
Of 50%.
They must have completed all tests required by the school.
Not all tests, because you're still going to test them till the very end
Yeah.
on practical, I would hope.
We'll probably redo, but I would want mine to go through and take the test and then keep taking the test to refresh. I mean, if they're gonna take their theory exam, they need to have covered everything.
And we're talking about the
theory.
exam that's going to count, that's with
Right.
PSI, am I correct?
Right,
Okay.
Well, but, I mean, just for apprenticeship students.
I don't know. That's something that,
Or
We're leaving 3.
everybody to.
Ryan heard, you can't, if, for a traditional student in the traditional setting, it'd be virtually impossible for us to get them at 750 hours or halfway through whatever, and have them test on the theory and they pass. It's impossible. In the practical, in the apprenticeship standpoint, all we're focusing on for 750 hours is a book. And when they're in traditional curriculum setting, this is just impossible. Because we're using that book all the way till 1350, basically. So it'd have to be specific to apprenticeship for a traditional school or a traditional student to continue through a regular curriculum.
And isn't it already written that in a traditional school you have to have 1,500 hours completed to even test? Okay.
Yes, ma'am.
This is just what I was thinking, if they were leaving and going the last 1,000 or 752 a salon.
So it would be specifically for the apprenticeship program?
It's for the apprenticeship program.
Start with apprenticeship students. Fit out here. Shall complete and pass
Shall complete 50% of the hours required and pass the theory exam.
Could it be at least 50% or before they begin apprenticing? Like if,
I think your intent is one and the same, am I right?
Yes.
But you don't want to release them out to apprentice before pass their theory.
So apprenticeship students shall complete 50% of instructional hours.
That then would only be 500 if we're stating it this way, because 50% of the instruction of 1,000 is only 500. So it's all, you're wanting them to complete all their theory instruction, 100% of their theory instruction.
1,000 hours if it gets passed.
Apprenticeship students shall complete 50% of instructional hours and
All of their instructional curriculum.
On completion of 1,000
All
hours of instruction, of theory
all
instruction.
instructional hours.
Right. Because
Theory.
it'll apply to each of the license types. So if we don't spell out the 1,000, but it's all of the instructional hours you're wanting.
And that's it, or they pass it?
They must pass. So the question is, if they don't pass, then they can't go and apprentice. They're staying in the school.
Till they pass.
Yeah, they can try again.
Which means what? That's more theory hours that the school's gonna charge them?
Oh, they've already paid for their tuition.
But no,
Passed it, and
they've
failed
passed
at
the
that point.
1,000 hours, and they've now failed the theory exam. What is the student to do? They can't start the apprenticeship, and now they're out of money for their theory. Or in essence, they've finished learning the theory, they just haven't passed it. And maybe those that are hands-on learners, I'm being the advocate, learn more by cutting the hair than by reading in the book how to cut the hair. You've now cost those, we've cost those students potentially to not pass that theory exam.
So they've elected to pursue the apprenticeship program, and then they're prevented from participating in the apprenticeship
They would stay in school and do the hands-on in school with the school has, we have lots of clients.
During
and
the,
stuff.
right, okay,
You know what
during
I'm
the
saying?
1,000, they would still
Yeah.
be doing the
They could
in-shop.
still do, they'll still be doing hands-on too.
how soon can you retake the test if you fail?
Immediately. There's no delay.
Okay.
It's a fee, it's $70, but there's no.
They're not like, not getting their hours, they could still come, whatever, till they take it again, till they pass it. Is that right?
What if, well, I can see Roxana's point about the exam, but at a very minimum, I would say that an apprentice student would need to complete all of their instructional hours before they do apprentice, which means you couldn't do like half and half, and I'm coming here, and so, I don't know. That was my question earlier about what if they don't pass the exam? I was thinking, ooh.
They can retake, or they can just say, well, I'm just gonna keep on going to school and finish out my other hours here.
So we're gonna mandate what they have to do before they can start apprenticing? Or are we gonna leave that with the relationship between the school and the salon shop? As long as it's 50-50. I mean, are we gonna mandate that they have to do half of it first?
As an owner, if they don't understand the theory part on the front end, that's probably not a
Not many options to know that unless they pass a test.
right.
Unless there's another test they can pass.
Currently, we get them licensed, and we know they passed.
Right. You're right.
That's what licensure is all about. I don't know if we want to reach in that deep.
What if there was pieces of it along the way, and that's what they can and can't do in the salon as an apprentice?
I don't like the idea that they could possibly go out the day they enroll and start apprenticing.
Yeah.
But what school would really do
She
that?
said they have to have 200 hours.
They have to have 200.
Yeah, okay,
And
you get 200 hours, that's still
That's
not very
still not-
much.
It's gonna be
10%.
impossible to micromanage this whole program, so, I mean, you gotta.
The more we try, the more it won't, we can't get a hold of.
So
Leave it up to the
maybe the
school.
health piece for the 200 or something, maybe there's one there. Maybe there's a partial test at the 200, and then an additional testing at the 100% of the instructional part.
About something like this. Prior to beginning the shop apprentice portion, you must pass the theory.
Leaving the number up to each school.
Responsible school would want them to show some kind of evidence before they're unleashed on the public in the school's name. It
So-
seems like they'd want to give them some kind of test.
Yeah, let's explore the apprenticeship and the instructional, whatever, going hand in hand, not just one at the beginning and one at the end. Because now, what do? You do the, it's been a while since I've been in school. You learn the theory or whatever, but then you go back and forth from clinic to theory to clinic to theory. So could the clinic at a certain point transfer over to in-salon apprentice? I mean, I'm just thinking out loud.
Or maybe the testing throughout the theory section as a whole serve as some percentage towards the theory testing at the end. Are we talking about, I'm getting a little tired too, so excuse me. Okay, are we talking about the PSI test or?
Yes, the
okay.
PSI exam, not,
So,
the
no.
school
What-
should
what,
continue to test them,
Okay,
like they normally do.
well,
Just-
that doesn't apply, what I'm saying, no.
I don't want to stifle business models too much, because I think the whole point of apprenticeship was to expand it, and then we stifle it.
I know as far as the, I can't speak for the governor, but as far as people that made this law, they were concerned about getting people to work sooner. I mean, they're thinking an apprentice is going to go and earn money in a salon. That's
That's the understanding I have too.
But then we got to get rid of that janitorial piece, because that's about the only way I'm willing to pay them that early on until they pass tests.
I know.
Yeah, I was looking at that piece too, because they'll come in and, just
Or
sit
maybe,
around.
yeah, like
I heard.
instead of
I hear the sweet
accepting
no-
requests on the clinic floor, they accept requests in a salon and therefore get to.
I don't know with the law, the way it was written at 50%, how much time the student would have still had in the clinic floor. I really think the student's practice would have, in large part, been at this apprentice relationship with the supervising professional for the hours to really fit.
The way I see the practical portion in the salon is more of demonstration view only than it's going to be letting them do haircuts on a client even at a reduced rate under the roof with your name on it. I mean, that's more detrimental, because what happens is they don't say, if you had a bad meal at a restaurant, they don't say Johnny was the cook. They say Ruby Tuesdays gave me bad fish. So as an owner, it isn't going to be Johnny the apprentice who's new screwed me up. I mean, I'd be very reluctant to say, go Johnny, go.
A lot of, no, you wouldn't, but a lot of people would be like, come on in.
Right, Kelly.
See, the
There will be
difference
some
what you were
salons.
saying, but Kel, what you were saying before about the clinic time being on the salon floor, well, back to this morning, it's like when they're walking into school saying, it's an unlicensed person doing it. I mean, you know what you signed up for.
Oh, yeah.
But my daughter is 17 years old. She could probably get 12 of her friends a day. She's trimming her hair on the back porch all the time. All right? I know she's supposed to. But
She's not
the
charging.
thing is, she can grow a clientele quicker than anybody, and she really don't know what she's doing yet. So if we allowed that to be legal, I mean, somebody could be popular and have a ton of people in there doing their hair, not knowing what they're doing.
I know that was
This gets
the
more dangerous the
initial
deeper we
point, was
get.
to get people in the workforce sooner.
Yeah, that's why I didn't want to roll too many rocks in the path.
But if you put
Taking
off
it-
theory first,
Yeah,
then
they should have
you're
a-
looking at them even learning how to do their first pin curl in the in
Does
a
it
shop.
have to be the theory test, though? Can there be another kind of test that the school can give,
They do. Schools give tests, right, after each
Yeah.
chapter?
that they'd have to pass to get out into the?
Said that you can get through the book in 600 hours. Someone said that today.
I think that was Parkinson referring to Gould's book
Okay.
theory hours.
I just think they need to at least show they've learned their theory before they go apprentice in somebody's shop. At least they have a piece of paper showing one part of it's passed.
Before they.
We book it all day long on the floor.
I think the definition of apprentice is really what's great, because what somebody's going to be an apprentice in Bobby's or mine or your salon's going to be dramatically different. And I mean, we get them fully licensed now, and it's a year before they can touch a client. I mean, they could shampoo hair, but it's a 50-week program. They have to graduate technically before they can touch a client.
Well, this would be really good for your salon because they would be putting in their 1,000 hours there.
Yeah, I mean, I'm certainly a proponent of it, but because it's formalized is why, you know, and again, that's just my opinion, but to be looking at salons that aren't going to be formalized and they just let
scary.
somebody, that's where the concern's really going to, they'll be working quicker, but
Scary.
they might not be working for a long time.
I'm going to interrupt us and welcome Bill and introduce Deputy Commissioner Bill Giannini, if he could go ahead and speak for a moment.
Thank you, Director. Board Chairman, thank you for letting me interrupt your meeting. I wanted to go on record. I understand that we've had a series of increases in hours through this rulemaking process. Also understand that our two senior legal counsels have advised against that and have instructed the board that it's probably not in the best interest of the board or Tennesseans. I cannot say it strongly enough, encourage you to listen to your legal counsel. You could be running the risk of jeopardizing the entire rulemaking process here, derailing it. I think that anytime you're going to increase regulation on Tennesseans, you should do intense analysis and study, not over a 2-hour or a 6-hour board meeting without any analysis or proper notice. Questions?
I agree with you.
Thank you.
So basically, as a board, you just want us to give our opinions, and if they're not at a level that's either satisfactory or recommended, we shouldn't go forward with it?
No, I think this rulemaking process that you're currently undergoing was noticed properly. It was not noticed properly that you were intended to increase hours. There's no study been done of which programs, if any or all, that hours should be increased. I think it's a disservice to Tennesseans to increase without empirical data the hour and the regulatory burden on students. You're going to jeopardize this entire process. You're going to jeopardize apprenticeships. We're probably going to punt by 18 months at least the apprenticeship rulemaking process by doing that.
Could we bring this up, like what you said, at next month's meeting or something?
We would have to, like he said, brand new rules.
I think your legal counsel, which you guys pay for, has given you great advice. They've instructed you how to do both. They've instructed you how to continue with the process that you're currently undertaking, and also to initiate a separate rulemaking process if you want to discuss the possibility of increasing hours. And this is a scheme that works across state government. It's a scheme that works for the best interest of the board, for the best interest of your licensees, for the best interest of Tennesseans. It's open and transparent.
I think today we have really discussed, and I think as a board in general, all of us who participate and practice as business owners in the businesses, that we're talking about Oliver, Tennessee, we do feel strongly about more education for and hours. I think maybe, I mean, we have, as Ron said, we could change the rules, we could change the hours. Maybe we've stepped out a little bit of what we were actually supposed to be, well, what we're supposed to be doing today. We may have overloaded the package, meaning when it shows up at where it goes, it's been all over, so they know it as it is. If it shows up really extremely different, we may risk a lot. And I have to say that the legislatures and Bill Giannini, everybody worked on this to get this so far. And I think I heard today someone say throw the baby out with the bathwater. And I'm just sitting here having a tremendous amount of angst as we completely went through the process, even though it does have a lot of gain with what we've recommended, a lot of really good points. I think maybe the hours that we would like to mandate should be set aside, and we would stick with the current hours that the schools actually offer now. Give it a running board chance with our recommendations and rules that we've done a lot of work with, and address it at another time when the Attorney General's ready for that kind of change. It's big. I mean, we've spent hours today, but the paper that was brought to the table today, there was years spent on that. It was more than 18 months. And I'm not sure I'm really willing to risk what we got as estheticians and what Tennesseans got in the paper that, we're making rules for today. I don't know, can we vote on that? Is that something that we can bring back to vote? Are we too far down the road, or what do you think?
And I would like to add a statement onto that too. All my previous comments on, being adamant about more education and all that, I still stand by that. But as Mona said, what we have in front of us today have been worked on for quite some time. I mean, and so I would rather take a back seat and do it the more proper way that our legal counsels has advised us to do, instead of just saying, oh, we're going to do this today, and kind of, stepping out a little bit too far than what we're trying to do, because I'm getting the feeling that this can all backfire in our faces.
I don't know how many of you sat in courts. I haven't, thank God, done it a lot, but there's about 4 attorneys in here, and I just don't like the way they're looking at us. It's just, I just don't think we're clearly moving forward with the process that could really help everybody. We may just lose it all.
I do agree with you, Mona.
It would be a travesty to watch this entire rulemaking process, which a lot of hard work has gone into to get to this point. And many legislators who passed the bill last year to merge the boards are expecting this board to act, and for this entire process to be derailed for not following the proper rulemaking process would be unfortunate, and I think a disservice to your licensees, certainly a disservice to the folks who've worked hard on it. Again, I don't always agree with the attorneys, but I always take their advice.
I think we have so much more work to do. I think we go to them 4 more hours and 4 other things. We have a slot in with Senator Bell's bill to put the new hours in there. That's an open window for us at a more immediate place. But as we move forward and want other things, if we've just derailed the process, they're not really going to listen to us. And I've been in that situation. I don't think it's a good seat to be sitting in.
I can't tell you guys what to do. You're the board. All I can do is tell you when I think you're about to step in a hole, and I'm telling you you're about to step in a hole. What you do from there is just like my 8-year-old. I tell him, don't go over there. You're going to get stung. He'll go over there and he gets stung. You guys got to do what you got to do. I think you've gotten good advice from your attorneys, and I would ask you graciously to take their advice. I can't make you, but I can sure ask, and that's why I came down here.
Bill, help me understand by what you mean by derail the whole process.
Well, because the AG is likely, and I'll let Tony speak to this. I think he's far more articulate at that than I am, explaining why this is likely to happen.
Well, what they generally could say is easily saying that this wasn't noticed properly. These provisions in here that we're making amendments to regarding specifically the hours were not part of that original notice of rulemaking hearing that was going. And they could come back and say they don't have the authority to do that. And in worst case scenario, best case scenario, they say just strike those out. Worst case scenario, they say you need to do the process over again, which would put us, it's going to put us 9-10 months behind of redoing the entire thing just on those provisions.
And the reason for that would be because the proper notice of this is that anybody who has an interest in the deliberations can be here and be prepared to deliberate their position. If you're planning to increase hours, and then if that had been properly noticed, I suspect we'd have had a lot more people in this room than we've got today. And that's the reason this process is set up the way that it is, so that it's fair for everybody, that the board and your licensees and interested Tennesseans have an opportunity to come in here and talk about and discuss empirical data and discuss positions and opinions and deliberate. That is the process, and it's a good process.
Yeah, so don't take this the wrong way, but I'm glad we've gone there. And I hope that this discussion that we've had today, which I think has been really powerful from both the folks in the audience who've stood up and for the majority have defended everything that this board has said today in terms of our requirements, in terms of better education, in terms of really representing all of the licensees under this board's governance. So I'm hopeful, absolutely, that this does lead to a larger discussion. But if we ignore what we've said today, I personally don't think that that's okay for us just to retract everything that we've talked about today. Because I think we've started the discussion. So my question to you is, how do you continue that without just saying, forget it, we accept it as is, and we'll readdress this a year from now?
Well, no, I think we're not asking you to scrap the whole entire thing. And anything that you notice properly in sections that you notice that were going to be discussed in this rulemaking process, you absolutely should. That's what you're here to do today. But if you want to talk about sections that expand the discussion beyond what was noticed, that's where you're going to get in trouble with the AG's office, and they're liable to scrap the whole entire process. That's the point. You can start a new rulemaking process. You can start that tomorrow.
So we can take what we've done today and not scrap it all, but use what we've put together, because I think everybody's contributed to that, both positively and agreed and not agreed, to start that next steps.
Having not witnessed the entire meeting, I'm going to turn that over and let Tony answer that question.
Tony,
'cause I don't know what
think
you've all
we're
done,
really
and I'm not
out
going
of the boxes with the expansion of the school hours? That's where we're really out of the box, is the expansion of the school hours.
The expansion of the school hours is what concerns me the absolute most.
Is there anything else?
No, most everything else is pretty much within all of that scope about the daily logs and providing those logs and things like that. Those aren't real issues. But the step that you can take forward that I was talking about earlier is you can just for the next meeting schedule your rules subcommittee to meet and then talk about what other changes you would want to do, and that's how you start the process. You've already got the ideas of what you want to do, but you just have to go through that subcommittee rulemaking. They say, hey, we want to increase the hours or whatnot. We'll say you have to statutorily provide some kind of analysis on what is the cost of that. And we look at certain things of what is the current cost within the school's average cost, what is the increase going to be, and then other states, surrounding states, what hours do they have? So, because we're required to put down on the record, what is that impact going to be? So that's part of my concern today, is that you're not going to have the right, I said earlier, you're not going to have the right notice, and you're not going to have the right analysis for the AG's office to look at. But we can start just at a different meeting, just not at this meeting.
Now, I have a question. Like I was saying earlier, the NACAS is not going to accept the 750. They're not going to accept that. So these students that are depending on their grants and stuff won't be able to get them because the Department of Ed won't give them to them because NACAS don't authorize it. So they're just kind of stuck.
Unless you raise the hours, is what you're saying.
No, I ain't talking about raising the hours. I'm just saying, I think I talked to him back there. Did you talk to Tony over the NACAS? Mm-hmm. Dan? Come up here.
And I want to be careful that we don't get too far off course here, because we can't. This is not the proper place for us to get into a debate about what NACAS is going to do or might do, or who NACAS even is. Frankly, this is a discussion about your rulemaking process that you guys noticed many months ago, and that's the point. And when this transparent, very, very clear scheme that's laid out in state law is followed properly, you don't have a problem when you get up to the AG's office. When you get outside of that, praise the Lord, we live in a great state of Tennessee where you are supposed to stay within the confines of your properly noticed meeting. When you get outside of that, you're going to get sent back to the principal's office. And they're going to say, no, that's not what you said. And it's a good process, and it's a fair process for these folks out here, for these folks here, and for you folks there, so that everybody's very clear about what's happening. Everybody has an opportunity to participate, and everybody has an opportunity to be heard. When you don't do that, that's when you get your return mail from the AG's office, and that's what we're facing. That's all we're saying. We, not me, not Tony, not Michael Driver, not anybody else back here is saying you should or should not increase hours. That's not our bailiwick. Our bailiwick is to tell you when you're about to go off into the ditch. And you're about to go off into the ditch in a very expensive and time-consuming process. We're talking about 18 months it's taken to get here.
Well,
I have a question. All this paperwork that was sent out was public notice, and everything we're going over today, everybody had a chance to look at it. And it's on here about the 1,500 hours, just like we've changed that for the specific schools, that specific disciplines like aesthetics and manicures, we've added that they have to have a minimum of 5 students. We didn't notice that we were going to do that. Just like but it's on here, the subject matter. So the subject matter of the hours is on here, and we've decided with good reasons that we need to increase those. But everything on here, we didn't say we might change this, we might do this, we might do this. Everybody read this, and it was on there.
And what I went and said earlier was that these rules right here, this is not the current rules. This right here is the rules that this is how they're going to look when they're changed. And that's what I said earlier, is that it says right here, the changed rule, we're having a rulemaking hearing, and the changed rule is going to be 1,500 hours of curriculum. So they don't have notice. So anybody who would have any interest in how many hours of class they're going to have to take was not noticed that we were intending to change that. And that's what.
Well, then that's like everything else we've changed on here or added to.
Right.
We didn't specifically say we were going to do that.
Well, now, I guess maybe it's difficult to explain, but some of those changes aren't substantive changes, meaning they don't change the real intention of the rule. They're minor changes to it.
Well, I just see that from the very outset, the apprenticeship hours being so low, 750, less than any state anywhere, and that we've come up with a solution to kind of remedy that there's panic. There's panic.
No, it's absolutely not panic. What it is good advice that you have paid for, and to hopefully keep you from derailing your entire rulemaking process. You can ignore us. I can walk out of the room and you cannot take my advice or the advice of the 2 attorneys that have advised you pretty authoritatively why this is a bad idea. That's all we can do. You're the board. I'm going to leave it there.
But
you guys have got to do what you need to do.
Worst case scenario, we make these changes that we want to make. We send it up there. They don't like it. They derail this whole thing.
We have to start
and
over.
We start over.
Right. And that's bad for Tennessee. It's certainly not going to sit well with the legislature. And we already have legislators wondering what the delay is. So your staff, the board attorneys have spent a lot of time working on this to get us to this point. And it would be very unfortunate over school hours that should be debated, frankly. Let's be honest. That should be debated in a very public, transparent process with much deliberation and with empirical data and experts from each subcategory of your license group, and have a discussion. That's
But
the
what
reason we
what
have
I
a.
heard today, Bill, was that that's exactly what should have happened with the apprentice program.
I'm sorry.
That never happened with the apprentice program.
And look
That
at where
debate
we
that
are.
You just said should happen with the hours, which we all agree with, never happened with the apprentice program. That the apprentice program, as it's written, was handed to us, and we were charged today with coming up with rules on how to make it happen. And
Right,
that was
and
it.
that's exactly
But
what
there
you're
was no
doing, but
debate.
not expanding, again, based on the advice of legal counsel, expanding the school hours is not in the scope of the apprenticeship directive that you've been given by the legislature.
I know when all the apprentice thing come up, this place was packed, everybody was talking, and everybody was against it. I mean, it's like, you know, you take a doctor and cut his time in half, would you still go to him?
We're,
You know?
again, I do not want to wade off. I'm not a legislator. I do not make the law. Okay? All we do is administrate. We are here as your attorney and as your administrative arm of the executive branch of government to give you guys the best advice and to manage your money and your business. We're here telling you whether the apprenticeships is the greatest idea since sliced bread or it's the worst idea since sliced bread, whatever. That's not for us. I came down here to tell you when our two senior legal people tell me this is a bad thing that's about to happen, I would be not doing my job if I didn't come down here personally and tell you, implore you not to do this. You still have the authority to do whatever you want to do. We're going to send whatever package you wrap up to the AG's office. They can choose to send it back or not.
Well, I'm with Amy on that. We never had a discussion about the apprenticeship program. And I would say to my legislators, and I have, my legislators from my area, I've said, the board knew nothing of this. And you know how they get the bills run through, and that amendment for that apprenticeship school was a last-minute thing. And
But again, no
legislators,
respect,
they just signed. They
no
signed.
disrespect intended. I'm not going to get into that conversation because that's not what we're talking about. Whether apprenticeships is a good idea or not, whether it was broadcast on the nightly news, I'm not here for that. I'm here to tell you my rock-solid legal counsel, who I have complete trust and confidence in, is telling me this is a bad thing, and we are very potentially going to erase a year's worth of work and derail an entire rulemaking process for apprenticeships when we could have gotten 75% where you guys want to get now and worked on the other 25 rather than sending 100% of it over the cliff, which is what we're about to do. Thank you.
I just, a couple of years ago, I was appointed to this board, as Roxana and Rachel and everybody knows, and there was not due process. And I was actively involved in many things that we were making a lot of progress on. And I got that letter from the governor's office that it was not done in due process, and I had to sit on my hands for 7 months. So this could be fatal. I mean, this could be like we have had years.
And
I mean, I'm just sitting here thinking about all that, and it is a process. And I feel like if legal thinks we've gone out of the box, and with different things I've seen and watching the faces of these attorneys, I don't know, I just don't have a good feeling about getting anything we want. And maybe we should sit here and prioritize. I think Patty's idea on getting this theory test is brilliant. It's excellent. I think everybody can come to an agreement on that, and then the little tweaks that we did. But we've done good work. We can revisit it for sure.
I think that, this is my first year being on the board, so I don't know as much as you do, Mona, or some of you others. But what I'm seeing and hearing is that because we got slammed and thrown in the fire to make this happen, that we want to do the public like that. And I don't think it's fair. If we're going to increase the hours, that's not just a little minor change. The specialty schools, that's something new that we're bringing in order. So, making rules about that's different. But the school hours have been in place for a lot of years. So not to have the public's opinion about it and just say, oh, well, we got done like that, so we're going to do you like that, I think is completely, utterly unfair. And every comment that I made earlier, I do believe in, but I do feel like the public should have an opportunity to hear those things that I have to say, you guys have to say, the public have to say. And if the legal counsel, I mean, come on, guys, the commissioner came down here to intervene. Are we doing this for the public, or are we doing it just to say we can change a rule? What are we doing it for? Back to Mona, prioritize. You don't want to lose all this work for nothing.
Let's put something at the top and go down, because I really think we're not going to get very much or anything if we pursue this with the school rules on this package. Make another package.
Can we call a special meeting for maybe increasing hours or something?
As Tony recommended, our next meeting's in February. We can have a rulemaking committee that we talked about creating anyway, or we can go ahead and discuss at that point and start a process for the rules and the hours, and have a recommendation, a study on what the cost is, everything that they're going to want to do, like we did for bits and pieces of this, and start it on its way.
Or combine it in the one we're already working on, which is combining
law.
the Barber and cosmetology rules. That's already began.
The analysis in the spreadsheet that I sent out that Senator Bell is looking at is, I mean, it really was already due to him. I haven't been given any changes to give him. And so that...
It just didn't print well for me. Was like,
but basically what he's doing is taking the two boards' laws and looking at where there's differences, what makes sense to do. So we can send it again, but if at that point we want to add a major section, the board has decided that the hours under both boards are low, and here's the recommendation, that, as Denise mentioned, that's a good time to put it out there, because that's in the law.
So when will this apprenticeship start? Does it start?
The law, again, was signed in 2013, so the law is there.
Right.
The apprenticeship would start when the rules that we're looking at now, which include the bits on apprenticeship, go through all the processes. So timeline is a minimum of 90 days, probably 100 plus, to if it doesn't go through, then it doesn't.
I'll throw out a suggestion. I think everyone's seeing the light on how it's not probably the right day to change the hours. But we have to do the apprenticeship rules. We have to. So could we come to an agreement on the most conservative way to begin the apprenticeship program, which is going to begin in 90 days or whenever it is after we set the rules? Come up with the most conservative way to protect, students, the public, schools, everyone involved. Table the hour idea until we can go through the proper channels.
I think it's a way that we can hopefully win it. We will be in the process.
Ladies and gentlemen, we are the board. We're here to serve the public. I don't think anybody on this around this desk is trying to do anything to serve themselves. We've done some hard work today, and we've got a lot more hard work to do before we go. For our council, Tony, thank you very much. We appreciate you. We appreciate your advice, Rob, everything you've said today, Commissioner Giannini. It's good to have that type of input. I think it's obvious to everyone that no one wants to take us down a path that is not an appropriate path. Have we embarked on a journey that's going to take us to some dangerous lands? Absolutely. We're going to make some people mad along the way, and we're going to make some people glad along the way. However, this afternoon we've still got work to do. We do not want to derail this process, obviously. That would be foolish and irresponsible, and we're just not those type people. But we do want to make progress and move forward. So from where we stand now, we need to decide what we want to do about the hours that we those changes on those specific items. Does the board want to withdraw those recommendations? We voted on those and approved those. What type procedure would we have to go through to do that? Do we want to keep those? You know, this is not the first time in my life I've been scolded or spoken to strongly, and trust me, I appreciate the passion that everybody brings, and I understand there's a point to be made, so I do appreciate that. But sometimes, even when you're being scolded, you need to go forward. That's not for me to say alone. That's for us as a board to determine. So I will ask one more round for your opinions and some advice from our attorneys on what to do if we choose to undo some of this, so we can move forward and get our work done.
You can always make a motion to take away what you did with the hours. What we were intending to do is just get through all the changes to the chapter and then vote on everything together, but you've already voted on the hours, so you can make a motion now to take that away and leave them as they are, as they're written. Or
I
you
make
do
the
what you did.
I make the motion to take those hours away that we did earlier.
Second.
Judy McAllister.
Alistair. Second is by Ms. Kelly Barber.
Is there any discussion?
My discussion would be, can we, I guess we do have to vote on this, but I'd like to finish the rest of this
Absolutely.
and come back to it. But I guess, since we have a motion,
We can table the motion.
come back to it at the end.
We'll table the motion as it is. And we're on page 9. We left off on Rule 0440-01-.09. Number 4 is the creation of the exam. We were still in the debate of whether the individual can take the theory exam at the 50%, after completing the full theory. So we're trying to find the best words to put that in. Did you have anything already going? No.
750 hours, they're not going to be able to complete the book. So, have to
It would be-
combine them somehow.
The recommendation, if I'm wrong, correct me, would be that within an apprentice program, the student would have to take the theory exam prior to starting on the practical apprentice hours. That's what your recommendation, I think, is. Whatever those hours are, because if it's manicuring, it's 300. It's the completion of the theory hours must be there, and the exam must be passed prior to starting the apprentice hours. Is the board in agreement that we want that added? That you want that added? Okay, so we need to vote that.
If a student really, I mean, they are just dying to get into the apprentice shop, could they really go to the book and get through it if they tried super hard? Okay.
I think we're doing the student a service by making them finish some education. I see a lot of interesting business opportunities. I think we've alluded to those with students in the apprentice program working for someone in a for-profit shop, whether they're paid or not paid, not getting any education. I think this at least helps put the onus on some testing.
Want to complete school instruction, first half. Pass because I had passed the initial theory exam.
And that's correct.
Apprenticeship students shall complete all instructional hours and pass the initial theory examination is what I had.
That's correct.
Or the apprenticeship.
Before they can start their apprentice hours with a
Yep, prior to
under supervision.
what? Initiating shop.
Ryan heard, does that mean that the opportunity for them to do a couple days in the school and a couple days in the salon in the consecutive in that week, that's off the table then? That won't be allowed? Because like I said, it's going to take 750 hours to get them through a book, to get them to pass the theory portion of the PSI exam, and then we get to give them exactly the way Frank wants them, completely unknowing of how to even hold a comb, which I know is not what you wanted.
Well, school still teaches that
After
too.
200
Yeah.
hours, a school can
Yeah.
put them in their own shop if that's what you're doing for the
We put them
practical.
on the.
Not
can
if
put
you
'em on the
pass it to
floor.
where they're required to
the
do
theory.
750 hours, required to take that test before they can start the apprenticeship program, then that takes that ability out of
But
the
they
way.
can be on the floor working, like you do every day. Do you put your students on the floor doing hair?
Yes,
after
ma'am.
class? Yeah, they can still do that too, and that way they'll be having their hands on too.
Right, but I have the ability to take 1,500 hours to teach both. And now I'm going to have to get 750 hours and get a book taught to them.
Actually, you don't have to do anything because it's a
Right.
It's a choice, and you have a barber school, so you don't have to do anything.
Okay, then I make the choice to do that school.
You don't
Then
have
that
to
still puts
participate.
me in a predicament where
You
I'm
don't
not
have
able to.
participate in the apprenticeship program. It's a choice. They don't have to participate.
Okay.
I think the concern, if I'm understanding it right, is if we have them force the students to test and do all the theory all at once, then there's really no time for the half of the apprenticeship hours in your own salon. They're not going to be able to, if they've signed up for the apprenticeship, ever to go in your own salon and get any hands-on experience. For those learners that are hands-on, none of the practical, when they take their theory, is going to come into play. Am I right?
I agree.
Going completely against what Frank was saying earlier, now it's Frank's responsibility to teach him, this is a comb, this is how you hold it. So I'm going to give him a student at a salon that knows nothing whatsoever about a practical ability of doing hair.
I
That's
feel
a
your
concern,
pain.
whether I elect
hire
to be a part of it or not.
estheticians. I feel your pain, but that's just not what we're
We can't
here.
decide everything. We're here to just make the rules. He can choose not to accept apprenticeship students.
Right, so basically the salon would know that when this student come in on apprenticeship, they may not know how to hold a comb.
Actually, that's not even going to
You're
work.
comfortable with that as a board?
No.
Uh,
Actually, that's not even quite accurate because under the rules, under the statute, 50% of the general hours have to be taught, 50% of the physical hours, 50% of the chemical hours have to be taught. That physical is in there. So that's going to have to be dealt with. So in that 750 hours you got, that still has to be a portion too. So you don't even have 750 hours to train that
So I've
student
got
in
in
the theory
750
book.
hours, I have to do, like you were saying, I have to do half of the physical, half of the chemical, half of the, oh,
You always do.
okey doke.
I have a question. Is this what an apprenticeship program looks like? They sign up in a school that has an apprenticeship program. They take their theory portion of the hours. They have to take and pass the theory exam. Then they can apprentice. They go in a shop and they apprentice for the rest of the hours. Then they take the practical exam after that and have to pass it, and then they're licensed. Is that what it looks like? Okay.
Or they could choose to come back to school 2 days a week and get some more training. You know, they may not want to
Well, that's
apprentice
what we
every day.
proposed,
Oh, that's what
Nina. We proposed
Well, but
that.
each
I mean, it
school
could be
can
that they spend
decide, right?
200 hours in the
We
school,
don't need to decide
and after 200 hours in the school,
We're not able to, hold on, one at a time if we could for the court reporter to make sure. Yes, yes. 5-minute break? How about a 5-minute break for everyone?
Wonderful.
Thank you. I wonder if I'm gonna start, you can't read.
Probably rest around on top of it. That's what I used to do at the airport.
I think had Bill needed to say that, he should have shown up.
I mean, it's, nobody's forcing you.
He's low, that's why I know how to do all that.
Yeah, it may be later tonight, but yeah.
Christmas and home
I mean, you reel me in. Give me something to tell me.
So anyway, it was September. No, it was March.
salon who isn't teaching them anything, but they're awfully cheap and or free.
For that. But anyway, so it was that. So
I think, you know, I have
Okay.
she said, never, you're that. So, you know, I'm carrying on. She said, really, you look rough.
How many times you gonna hear that?
I leave and goes on down.
Oh, no.
Yeah. Damn, baby. You look like hell.
We've established that.
For today, Rob?
Hey, I can't.
Oh, that's why.
I was like, you know.
Bad, like hell. Ow.
Right, it's right. If you believe in it, we'll, you know, so you
hoping
hold
we'll
off.
be through with this, or, well.
It's 3 hours we can't get back.
But you know what, it's 3 hours. It's 3 hours we would have spent at the next meeting discussing it.
On page 9.
Well, I'm,
Putting the notes in there.
Where y'all gotta drive to?
Yeah. Or the bar. No, I'm kidding. I'm kidding. Did you recognize me? Yeah. I don't even drink.
Out of these recommendations from this morning, will you guys sort through those, or we have to approve each one that goes in there? How's it? I mean, that's kind of what we're doing right now.
Of course they were. It's gonna happen.
I'm stealing it, girl. You better get to it. We're on overtime now. I had no breakfast, lunch. What? Didn't have time.
That's what I told her. I had a Pop-Tart.
Eating these protein bars are driving me crazy.
That doesn't really count as food, I get it. It's like fake food, but it's not really like food.
Kind of.
It's not like we can't start another project right away.
That is so.
Hey?
I believe you may be the quietest person I know.
Notice.
Chocolate time, is that what you saying over here?
Look at him. He's made this big pile.
I got a pile over here myself. These doves are pretty good. I didn't realize. I didn't see them.
Is everybody getting a where are you? All right. Mr. Chairman, if you can reconvene us, we'll crack on. Thanks. I believe we're at rule number 11, teacher training programs. And if y'all just take a read there.
Page
Rule 11.
9, Rule 11.
Page
And
9.
keep in mind, if we do start speeding up, we've already read through all these. I think what we're gonna definitely all do is catch each other where there is a change or something that we know we need to insert and go back. And then we'll do one more take on, did we catch everything on the apprenticeship that we needed to incorporate? And then discuss the hours, if that's okay with everyone. So we may move at a different pace, but I think we've kind of read it, and the rest of this may fall into other smaller changes.
Something that may help you out that sort of segues with what we've learned about the hours is this document right here has the bullet point synopsis of what we've done to the rules. So all you have to do is read that, and it'll tell you what we were proposing to do to it. Might help you.
On page 10 and 11, I'm going to point out some things that we have added, not to interrupt your reading, but I think I may be able to point them out and you kind of keep going. Number 3, under renewals, the retired license reactivation, we kind of clarified a line that was there about shampoo, something that didn't need to be itemized the way it was. Basically, anyone that wants to reactivate a license is charged for a new license, so that is not a new fee. I don't want anyone to worry. If you've not been active, that's what we charge. However, on page 11, Number 6, under schools, penalty, late reporting the monthly hours report, that is a new fee, that $25. It's always been in the statute that we could, now we're putting a price on it and putting it in. And the fee below it, replacement, lost, mutilated, misplaced license, it's right now a $10 fee, we're changing it to $25. We just have a lot of applicants who want the 2 or 3 copies just because, and this will hopefully contain it. That really takes care of the changes for the next 2 pages onto page 12, so.
Roxana, on page 12,
Yes.
number 9, the
Yes.
reciprocity, that's a new fee as well, right?
The fee is not, it's a $50 fee, however, we now collect the fee at the end. And so we want to start collecting it when they apply, which is going to really not only help the office, but help the licensee make a decision, do I want to do this?
Right.
So, that's the change.
And on paragraph 10, right under it, Board of Cosmetology needs to be, add Barber examiners to that. Civil penalties, paragraph 1, same thing.
Number 10, Rob?
Yes.
Paragraph 10, Board of Cosmetology needs to be expanded. Right, and in paragraph 1 of the next rule, Board of Cosmetology needs to be Board of CBE. Let's see, what else do we? Civil penalties, we just compressed the list. Yep,
The new
start-
rules?
Yeah, under
It's
new
all new
rules,
after
the
that.
school's providing limited instruction. If you'll take a look at number 3, for the shop participating here or below this one, we may want to add a couple of things that have come up.
Are the apprentices required to wear a name tag that states they are
The
an
school,
apprentice?
yes, and the school affiliation was on a previous.
Okay.
So they'd have whatever the school's uniform is, they'd wear that into the shop.
Oh, yeah, I remember
Yeah.
now.
Get into chapter 2, sanitary requirements.
I'd ask, is licensed barbers, do they need a name tag too, or not?
But right now, currently under the current statute, they need to wear just an ID tag if they're working in a shop.
A barber? No, they have
Not
to wear
barbers, not in
anything.
a shop?
Yeah, nothing.
Oh, you're right.
Students in a school have to wear smocks, but they don't even have to wear a name tag.
All right.
The communication, I think that's all pretty clear. It's just, when you renew or change your address, it's just requiring the licensees to let us know.
Corresponding to the apprentice program, is there a deadline when they finish? I mean, could they be in the apprentice?
There needs to be.
Notes that we had this morning.
Right. We need to add that. There needs to be, because it was
I think that's
clearly on
important.
several people's, yes, we just need to see where it is that we need to put it under the students portion probably. When they sign the contract, that there's a timeline, and we add that in.
For number 3, 0440 shop participating in apprenticeship curriculum must post a sign at its entrance saying its participation must follow and must allow customers to elect whether to be serviced. Put something in there for size limitations, otherwise.
Yeah, I think right now it just says visible in several places or appropriate as opposed to, yeah.
There are some regulations under cosmetology law that has some reference to lettering size on signs. Do you?
I think it's 8 by 10 or something like that.
For the shop, it just says visible, yeah. Yeah. And this is for the school that has the apprenticeship or?
Shop.
Shop.
And I don't know if you could regulate that just because every shopping center has their own sign requirements.
Can it be just posted like inside in a bulletin board or where you have your inspection sheet and grade point?
You can make it, I mean, I just think if you,
You're right. You're right.
you can put it internal and you can
Says
make
at its
requirements, but external on the outside of the building is up to.
No, right, not outside.
Right.
No,
I
it
can't
could be
even
inside the
post
window
anything
or-
on the inside of my windows.
It would be number 4,
There's nothing.
under schools providing any shop participating in the apprenticeship curriculum. Yeah.
Just another sentence on 3.
I think so,
Sign shall be a minimum of so-and-so.
right.
Sign should be a minimum. Eight by 10.
They'll have their uniform on too. It's not like they're gonna try to sneak somebody in with an apprentice. Hopefully.
Roxanne, I have a question that just popped into my head, and I better say it or ask it. There, if an existing school right now, if they decide to start an apprenticeship program, does that have to come before us for us to approve?
We may require them to send us a letter saying that they're going to, you know how they add all of a sudden the aesthetics program or whatever because of the square footage, we inspect it. We wouldn't, I don't think, need to inspect it, but I think we would need to know. So they could probably just send a letter to inform the board that they are doing this, if that's okay with the board.
Is there a minimum amount of requirement for the number of students in an apprenticeship program?
One per shop, is that what it said?
2.
I mean, at the school.
Not at the school. Just like they don't have to do it, there wouldn't be a number of students that they'd have to put through.
Not to police if you had
Oh,
a lot.
I'm just asking.
Okay.
Okay. Rule number 18, the expedited licensing for military spouses. On paragraph 3 on page 14, the last sentence, there's a typo. It should say, if such requirements have not been substantially met, then the individual must apply for a license under the standard procedures as prescribed by the board's law and rules. Get to Chapter 2, sanitary requirements.
Okay, I'm there.
You're there, okay. Definitions. We added D, E, and F, which is a definition for shop, unprofessional conduct, and violation. And under violation, it says Tennessee State Board of Cosmetology. That needs to be brought out to barber examiners. Thing I have is posting of rules and licenses. We need to add paragraph 3. I think we already mentioned it.
So the rules, as you've got them, if you've had a chance to finish, I think we've either already mentioned the typos and the changes, or there's nothing drastic or any changes with anything further till the end. We're at the point where anything else we've missed on apprentice, we need to make sure to put in the proper place right now, and then Rob will have to read his final piece. Gillihan, you had pointed out one piece. I'm trying to still find a place for it. Was it regarding the time for the apprenticeship program to be completed?
Yes,
We need to find where we need to incorporate that and put it in.
I'm thinking 1.5 times of the length of the program as a
Gillihan, I'll let you dictate what you think we need to put. We're on page 9, I think is where it would fit. Rule 0440-01-.06, enrollment of the student. So along with the enrollment agreement, that would be the time to say how long this program's gonna have to be. And we're on number 7. You got it. I've lost your notes. Page 9.
I believe the standard language I've heard used with that is to the effect of the apprentice course must be completed in no more than 1 1/2 times its program length, and that would be the full 1,500-hour program must be completed in
No more than 1.5 times that of the traditional schooling curriculum, does that?
Yes.
No? Yes? Does that sound right?
Well, right now, it's, the entire program is
Right.
1,500 hours.
Right.
So,
Well, but the question is the time frame. Right
Oh,
now,
I'm sorry, time frame.
right now,
Time
they
frame.
can take up to 7 years by law. Under examination, dash .09?
the question you were asking me, though, was, do we need them to finish it in 6 months or a year?
Right, right,
Okay.
right.
School, I'm sorry, if they signed up for school, if they were 28 hours a week or if they were 15 hours a week. They should maintain that.
I can get your,
Before you take your practical?
we can't hear you, okay.
Just at a time of completion of it before, time is up. You need to be out of
Of
school.
the apprentice hours, is that the piece that you're wanting to add? How long can the student be doing the 50% of apprentice hours?
There's a triangle relationship there with the school, the shop owner, and the participants. So, I mean, it just has to be pretty specific.
A full-time student, the minimum requirement is 25 hours per week. And so we can do some math here with 750 hours to determine how many weeks that would be.
7 months and 2 weeks. It's 100 hours a month with 25 hours.
We'll use the same formula for all the special schools.
7.5 months.
That sound
I would allow 2 more weeks in case they're out sick or family emergency.
within 8 months?
Yeah, I would do an 8 months.
The apprenticeship program must be completed 8 months.
Within 8 months after starting
Salon.
in salon, under
So-
the supervision of a,
How about completed no more than 8 months?
Trying to set the outside boundary, yes. No more than 8 months.
Just so that I
Sorry.
understand, I'm sorry, but just because I'm just a little bit confused, because I don't, but is it the 750 hours of the apprenticeship in the salon, they would have to be finished in 7.5 months?
8 months.
In 8 months?
Yes.
Was there an earlier restriction on the order that they have to do it at?
well, the restriction's going to be laid by the fact that we've got a previous part of the rule where we're saying that they have to take and pass the theory exam.
And then if you're just a part-time student, it's 15 hours per week. So, it would depend if they're full-time or part-time when they do their apprenticeship.
I'm having difficulty, one, with how this would actually mesh with everything else we talked about. I've been cranking around in my mind about whether or not making someone take the theory exam at the end of 750 hours before they can actually go and apprentice in a shop actually complies with the statutory requirement that when they give an application, they give a fee for 2 examinations, and that really anticipates that application, fee, take their exams within 3 years of graduating. Is that correct?
There's no time frame that they have to take the exams.
They have to pass them within.
They have to pass.
Right.
Right now, we've added a piece to the rule that says that after they've passed the theory exam, they have 3 years to pass the second exam, which is the practical. And that's really added because PSI has always had that rule. So without matching our testing site, it was a little bit confusing. But they don't have a timeline to take the exam right now. They've got 7 years to finish their education. So what the statute that you read me says is that they apply to test and then get their license. And it kind of sounds like it's one and the same, but in reality, because there's 2 exams, they apply to take and pay for one exam, which is the theory. They must pass it, and then they apply to take and pass the practical. And until they pass the practical, they don't get a license. They can't do anything.
My overall concern and how we structure it, I really don't care. I'm concerned that these apprentices who go into these shops, 200 hours in minimum, right? You spend 200 hours at a school and then you are free to apprentice. if we are not thoughtful about an end date to when they would need to be fully licensed, these people, I mean, you're saying 7 years to complete your education. I could have someone working in my shop for 7 years.
And I don't see
Who's
that could work if they've signed on to the apprenticeship program.
Correct,
They gotta
because,
take the theory
I
before
mean,
they
you'll
can
have to
come to
dedicate a
apprentice.
chair to them. I'd have to get them a whole treatment room.
I mean, but I'm not worried. Don't take this the wrong way, Mona. I'm not worried about your business. You run a wonderful business. I'm not worried about my business. I know how I'm going to run my business. I'm worried about the businesses who are not here today, who are not in the audience today, who, if you said the apprenticeship program is unlimited and there's zero structure and they can work in my shop for $0 or for minimum wage for an indefinite amount of time, but they can work on clients and they can get tips, sounds like a pretty awesome business proposition for some business owners, in theory, if there's no end date. 7 years is a long time to be an apprentice.
That's why the 7 or 8 months, that's why we're coming up
Yeah,
with.
that's
the
that. I
income,
mean,
yeah.
and again, whether or not we want to do the theory up front, that is my beef. Is
If it's the rule, then it's their option to be an apprentice or work with the schools through the traditional program.
yeah, however we want to do
So
it.
it would be very disruptive to my practice to have someone hang out 7 years. I mean,
Then
that just,
you would be creating an apprentice.
exactly.
I understand. Is that your concern? Is that you have someone who says, "Oh, I'm an apprentice."
I'm not
and-
worried about Mona's business.
Right. Yes, I understand.
But we've also discussed earlier that it's also very likely that a lot of the traditional current schools may or may not choose to do this. So we are creating new schools who are specifically going to only offer an apprentice program, and we are really creating potentially brand new businesses that are for the purpose of hiring these apprentices and working for these apprentices that are that without some sort of regulation, right? I see a lot of folks sitting in the audience going, I haven't been licensed. I don't need to get licensed. I'm an apprentice.
Yeah, and I think you all do have the authority to make a end cap date on that apprentice time.
It's not
program.
intended to perpetuate forever like that. I don't think that's,
I didn't say that it was.
In general, it will take a student attending at a minimum 25 hours a week, 1 year to finish the program. So from the day their attendance begins, until the day they should be completely out of the entire system, 1,500 hours, ready for their final practical exam, should be no more than 1.5 years.
all right, well, we were saying 8 months after beginning training in a salon shop establishment.
Take that off, is what you're recommending.
From the date of enrollment in the school period to completion and application for test, 1.5 years.
What I like about that is both portions are treated as a program now instead of being segmented out.
Right. They no longer get apprenticeship credit after that deadline. Paragraph number 7, under Rule 8. The apprenticeship program must be completed no more than 1.5 years after enrollment.
But or is it all lost? Is it, I mean, because we have applicants who call after 6.5 years of going to school at various schools and want to know. So do we need to put, or is it just up to the board to then decide, have they lost it all? Like we do now with the 7 years.
Students like apply for leave or something sometimes?
Yes, they do. Sometimes they're called up on military duty. So we probably need to have a provision there. Ends that time frame by approved leave of absence.
We can put that on there. This provision can be waived upon, don't we have that for something else?
The military spouse, but that's a little bit different. But
We
yes,
have
I mean, if they
a
have a
sickness
child,
and stuff,
Well,
yeah.
what about the teacher continuing education?
right, once a year, they're allowed a waiver as a teacher continuing education. But it would be up to each school to look at the specifics. Provision. Account.
Kind of have to.
Yeah.
Seem like you can have a kid.
Yeah.
Showing good calls.
I think there has to be a statement from the establishment owner granting permission for apprentice training to take place. So you don't want to have a shop owner out here who doesn't want apprentices in his shop, but he's got a qualified stylist who wants to take one on. So
Is that not something that the school would work out with
Because they have
the
their own
supervising?
station too, right?
For the shop owner would just say to their employees, no thanks.
Or are you envisioning the schools receiving a piece of paper and keeping in the file
and it's
from the
something,
owner?
something in the file. What I'm seeing out of this is an apprentice is going to cut somebody's ear, and they're going to get in a lawsuit, and the supervising professional is going to be hanging out there with his apprentice for some liability, most likely, and that shop owner is going to back off and say, "Ooh, I didn't approve that."
It's the school, you know. They want it to come back to the school.
What do you think? I have seen that in some documents in other states.
Where, are we still on the same section where it would fit under student? Probably not. I'm thinking.
I recently saw some legal briefs on some proposals that the people who are renting the stations would become, as independent business owners, they have to have their own business license in Tennessee and pay the local and state business tax, and so that would be their liability with insurance on their specific need, and the owners would have to have an umbrella, of course.
Independent contractors should have their own professional liability insurance.
And I require, that with people who contract in with us. But, your insurance people are your own, they measure risk. I mean, that's their job, that's their livelihood. So with application, it would be on each individual basis about insurance.
As a school, we could require them to sign a waiver, releasing us for anything that happens, right?
I would get them to
And
have
there's
their
a
own
lot.
insurance and demand and demand a certificate of insurance from them.
Now,
Is
that's
what I
not
would
something
do.
that has to be in the rule. That would be up to the school that decides to do this, that decides to require all that. But are we saying that we do want to put in the rule that the shop needs to sign some type of waiver?
Not a waiver.
No, okay.
It's just an acknowledgement.
Acknowledgement that this is happening.
That the owner approves.
Okay. That the shop owner approves, okay. Under on page 7, number 3 talks about the supervising licensed professional, blah, blah, so we could add it, I think, there. Yeah. B.
Ron, you're saying if this person is the supervising licensed professional is a booth renter and an independent contractor in someone else's space, the owner of the actual space would need to be on board?
The owner of the establishment. In some cases, the individual independent contractors will have their own shop establishment license. In other cases, they work under the umbrella of one. So I'm just concerned that whoever actually owns the business, the facility, is aware of what's going on in there, because you have some people who are absentee owners.
A situation like that wouldn't They would have to rent a booth.
They would have a contract with the building owner or a lease or something.
Apprentice.
The apprentice would have to rent a booth?
If they were apprenticing under,
Supervision.
under,
Supervision, because you'd have to provide them their own station. So there would have to be 2 stations involved.
That's the way it reads now. You have to have a chair provided for them specifically. Can't be just an assistant.
Correct.
Maybe a school wouldn't choose to enter into an apprenticeship agreement with anybody except a salon who has traditional employer relationships and not booth renters.
It'd be up to them.
That's what I'm
All-
saying.
All shops are mixed. and
Yeah,
all
that's
kinds
what I'm
of
saying
arrangements.
is,
So it's something that we don't need to regulate?
I
We
don't
need to
think
have
so.
that?
I mean,
That's fine.
I've got,
That's fine.
Tap and Tony for business law then.
I've been avoiding it over here. Too many what ifs.
What heading were you under, or?
this is, number IV, Roman numeral small 4, under paragraph 3, page 7. This will be a new paragraph. The owner of the business apprenticing a student shall provide the school a written acknowledgement accepting the apprenticeship student. Accepting responsibility for the student, or just accepting the student?
I think accepting is probably fine.
Anything else we need to add in, change? Yes, you're going.
You were in a different heading. Was it supervisors? Supervisor
Yes,
trainers?
yes, we were under supervisor.
We had, they must complete or attend and complete all continuing education requirements as required for licensed instructors. Can we have them do continuing education?
The apprenticeship instructors?
Are not
The
required.
supervisors.
I mean, the continuing education is for an instructor.
It's for the supervisors, so that they're getting.
I think it gets
teaching
back to
methodology.
an earlier concern that I had, is that the statute doesn't contemplate that they're required to be a structure. To require them to do continuing legal education would be along the same lines of that. It would just be a branch of that. I don't think that the statute would contemplate it. I think it just contemplates that they be licensed in their field and have 10 years of experience.
I think because there is an interest and there's already an open door through the legislature to do that, we could
can bring it
certainly,
up in the next session.
certainly bring that forward.
Supervising professional shall train an apprentice only in the field in which the professional is licensed. Have we seen that in there already?
Yeah, and they can only use their license type.
Each supervising professional shall be approved for a total of not more than 1 apprentice at any time, and shall be directly responsible for that apprentice's training. Have a shop with 10 people, and each one of them, if you have sufficient space, can have an apprentice each. Well, I think that's covered down here later. I think we limit it to two to a shop.
We're limiting it 2 to a shop, but definitely 1 to each person. We don't think, okay, they can do more than 1. All right. Under which,
We
it would be
we
right
wanted
there.
to keep 2 for the shop.
2 for the shop, but only 1
Right.
apprentice per licensed profession, or what are
Or
they called?
supervising.
Supervisor.
Professional.
Where are we?
It's 2 per commission-based salon, right? 'Cause if it was a rental situation, it could be 1 per person, providing they have an additional chair. Yeah, because if somebody's got a 2-chair suite,
That person will have to rent 2 chairs.
Where does it say that?
Yeah, you know what, you could,
don't say that.
doesn't say
What I'm
that.
saying
Doesn't
is
say-
this is left open to that. To where now a rental environment can have more than 2, because each person can have 1.
you know, I mean, I'm thinking about my studios. If I personally chose to take an apprentice student, I have my studio that's a shop. You know, I wouldn't have an extra chair to give them. There's nowhere in the law that says I have to give them a chair. I just have to apprentice them, teach them things.
There's a recommendation here for a science station too.
It says it's gotta have your own station.
It's in our,
But not in the law or the rules. In his recommendations,
it's in the proposal. So,
It is not law.
It's not in there. You all have to, debate that, because from salon owners that I've talked to that want this, that have called, their thought or their question to me is, so they would sit with my client where I would have worked with my client, and I'm supervising them, just like an instructor does. I'm standing behind them, supervising them, but they're taking my chair.
in reality.
That's their approach.
In
I'm not saying
reality,
right or
what will
wrong.
happen is, there's your chair, you go cut hair over there, I'm gonna cut hair over here, and I'll watch you over my shoulder.
well, that's if they had their own chair.
If they've got an extra chair.
Which
But
you
I don't know
wouldn't
that we
really
want to
have.
tell them to put in the extra chair, I think is what you all need to debate. Yeah.
If there isn't a chair available, how are they gonna get instruction? How are they gonna work?
They're going to take the chair you would have used on your client and work on them in your chair.
When? The chair's not vacant from open to close.
It is if you're supervising them. I don't know that.
That's why I think
thought
it
is-
makes sense what he's recommended, because without a chair available, now it's gonna be susceptible to somebody just being observant and doing floors and towels only. And then it's not gonna be a true apprenticeship program.
Apprenticeship is learning by doing.
Right. So he's working on your client. You're not working on that client today. You're apprentices.
So now you're gonna ask me to come off the floor,
Well, not all day long, but if he is learning a cut.
$100 an hour.
Yeah. Now, if you've got the shop in space, I'm just saying, think about if you're going to tell them that they have to have an extra chair.
Necessary to let them know that they have to have one available outside the one that your client's gonna be sitting in, because if you got a busy clientele, it isn't
Never
empty enough to utilize.
You're trying to build their clientele.
So, Rob, we were at, one apprentice per professional.
Each supervising licensed professional shall be in responsible charge of no more than one apprenticeship student.
Number 5, page 7, right below the previous one we did. Because we're at the chair now. Was that the next one that we need to put in or decide to put in? This is,
Do we have to say anything about a chair? I mean,
it's not in there now.
I'm thinking, the lady that cuts my hair. I mean, okay, if I go to a shop and there's an apprentice student, why would I choose that apprentice over the one that's been cutting my hair?
I really think that they need a chair in there for the apprentice.
Why would the apprentice want to be an apprentice if they don't have a chair to work on?
That's true. They probably wouldn't choose that person.
But what if they wanted to and the chair's not available?
They're gonna be standing there watching all day.
That's right.
Not
Maybe
getting the
sleep on
hands
the floor and
on.
on the sofa.
So that's
And they won't
taking
get their
place of
hands
the
up?
practical they're not getting at school, right?
Yeah.
So we're saying they're not coming out ready now because they don't have enough time. How unready are they gonna be if they haven't practiced the second portion of their 750 or 1,000 hours?
They need a chair,
That's a
I
setup to
agree.
fail.
Yeah.
I can promise you that.
and he's right.
They need a chair.
Maybe they need
would
to
agree.
observe at the wherever they're watching, then go back to school and practice on, because they have clients at schools.
Well,
That's
not
not the
all
purpose of
schools. I would say the
apprenticeship.
better schools have clients, but I think that this is a real challenge in beauty schools is to have clients for all the students they sign up. I've been in my little 13 schools, and I can only say one school had people on the floor. Everyone else was just, I don't know how they're
So what's
getting
gonna happen
anything.
next is we're gonna have a tripod in the middle of the salon
Yeah.
because we don't have a chair, and then we're gonna turn into a beauty school.
I just think that I'd make a motion that every salon that is doing the apprenticeship should have a chair for the apprenticeship or
I second that.
Are we doing a separate motion or are we adding this
or
somewhere?
adding it to it.
Okay, well,
Let's
where
add it
are
to
we
it.
so we can add it? No,
Can you,
Can I redo that again?
can you withdraw that?
Let me withdraw, I'll withdraw that, okay.
Restate that?
I couldn't restate it, I'm doing good to talk today.
Are we still under the same section? Any supervising licensed professional, practicing schools conforming, participating in school, providing hours?
I had flipped my page. We've already covered that he has to, the supervising professional has to be present and supervises all the time, have we not?
My question is, I'm listening to all of these amendments. Is everybody on board that we will get a majority vote for this amendment at the end? Okay, we haven't done any amendments that you know, 7 of you all think, I'm gonna vote no for that. Does that make
That'd be a
sense? That
nightmare.
at the end of all of this, we could not get a majority vote and scrap
to
the
go
whole
back
thing
again.
because somebody has a beef with one of these other
Right.
amendments that we have. So is that so long as that's the rule that everybody's been following so far, is that if you didn't like it on these amendments, we would have raised our hand and said
I should ask that earlier, Tony.
As long as you,
because normally the way, I mean, when you have lots of amendments, you kind of do the motion, you know, at one, you know, each time you make that amendment. But if you're getting with, I didn't realize that we were going to have all of these types of amendments.
As long as you don't advise us not to, I won't vote no.
So at the end, when we make the motion to adopt all of these, I think we need to make a clear motion as to that it's all of these amendments. You know, the discussion can say, you know, I didn't like that one, you know, I would not vote on the package because of this and whatever. Does that make sense? I don't mean to throw a
No.
wrench in the process,
Yeah,
but
no,
it's a
it
lot to
does.
keep up with right now at this point.
Sounds like the 3 o'clock question.
Okay, so I think we're on the same section still
Still
for the
same
chair.
section. I have
Okay.
one thing here that,
Did we leave the chair, or are you gonna give us the language for the chair?
oh, I'm sorry, still waiting for the chair.
If everyone's in agreement, we're adding that it needs to have a chair. Okay.
I had any salon or shop providing training for an apprentice shall ensure that each apprentice shall have a permanently assigned working station meeting the requirements of the board. And that station is not shared with any other licensee for the duration of the apprenticeship.
Yeah, I think,
I think
I
so.
would,
Part-time.
That may be too far.
Yeah.
So
I think just must have
practice sharing.
a
oh, they're
chair.
there.
Practice sharing. Yeah.
Nobody works full-time anymore anyway.
For us, right?
But under the 30-hour rule.
Unless you're on the State Board of Cosmetology and Public
Any salon or shop providing an
Yeah.
apprenticeship.
That's a 95-5
Participating in
rule, isn't it?
apprenticeship?
Yeah,
Yeah, I like that.
participating in an apprenticeship.
I had a question about, or a note here about disciplinary actions brought against a supervising professional may result in suspension or revocation of the professional's approved status. If some-
Not being present, I mean,
not being present.
yeah.
So do we need something like that to be able to revoke their ability to train them?
But it's not law. I mean, we're working off of this page, right?
It's got the examples on it.
Ready? Okay, let's read the chair piece if we could.
Any salon or shop participating in an apprenticeship program shall provide a workstation for the apprenticeship student.
What was it you just said?
About the disciplinary actions? Okay. This one would be, a disciplinary action brought against a supervising professional may result in suspension or revocation of that supervising professional's approved status. What I'm trying to get at here is if that supervising professional is cited or has some serious violation, that we would ability to remove them from continuing with an apprentice. Now, of course, that would entail the apprentice being placed with somebody else or something like that, but
That's some accountability towards
it's
either
accountability.
management and mismanagement.
Well, if they're, look at our civil penalties rule here on page 12. Tennessee State Board of Cosmetology and Barber examiners may, in a lawful proceeding with respect to any persons licensed or required to be licensed, in addition to or in lieu of any other lawful disciplinary action, assess civil penalties, and so on and so forth. So we already have the ability by this rule to do any lawful disciplinary action for any licensee that's violated our law. So if we consider whatever they did misconduct, we could take that away from them. I think we need to do anything new.
Roxanne, I'm sorry.
I was just saying, with this being as new as it is and no historical data, whatever that might be, shouldn't it be known up front as opposed to being brought in front of the board and then finding that out later? You know, as far as if I'm going to be the person who takes an apprentice on, I should know what accountabilities are tied to my either performance or lack of.
Your disciplinary history,
Right.
you mean?
Well, suppose we get a complaint against one and we you approve a settlement offer for them to not be a apprentice teacher anymore. They have a choice of agreeing to that, or we can go to a formal hearing and revoke their license. I mean, I think they would rather agree to that.
Yeah, I guess that's past what I'm saying is knowing on the front end
Right,
what they're
to
signing
take
up
them
for. Is that there is a list of responsibilities of what comes with that, as opposed to, oh, I didn't know, because you'll get a lot of that. It's just my guess, but because it's so new, it's not anything that's been discussed or passed along. I don't know how to do that, but I'm just thinking that's going to come up, guys.
Possibly in the relationship agreement with the school and the person, that they could require that they do acknowledge that they have read and that they know cosmetology law as it pertains to this new situation. I think that's a standard way of doing it, because we've signed agreements on lots of things that they just continue, that we agree that we know this, we agree that we know that. And I think by signature that should, perhaps the schools would be responsible for providing that to them. And it would be for each apprentice person. I don't think it should be one per shop or something like that, because things get lost in that.
I mean, for each supervisor that signs
yes.
on. Yeah, yeah, I agree.
Supervisor's job is to instruct this apprentice in the law and rules. Seems like
Yeah, I think
seems like they're
I think
expected
in that
to know.
relationship agreement, and that should be part of our rules.
Okay.
This is probably a question for Roxana. I've got on here, approving schools will report the apprentice's progress on its monthly report, as with all other students, noting whether the enrollee is a regular student or apprentice. Is that something that needs to be in there?
No, I think what we'll do is at the time that these rules go through, we will tweak that monthly report that you all just saw and add maybe a column or a letter that identifies the apprentice folks, so we can keep track.
This is one that's more geared, I guess, for the school that's supervising. The approving school will maintain a current list of approved supervising professionals from that school and establishments under their direction, and shall submit said list as a note on its monthly hours report, noting any changes as they occur. What I'm trying to get at here is if Frank has got 5 or 2 folks out here who are training apprentices, and their status changes, they move, they leave, they quit, that somebody needs to know that. And does the board office need to know that?
I can't think of a reason right now. We know that they're going to school, but if they stop or don't until they're really done, I think it makes sense for the school to keep a list. And that's what
It would just be up to the owner to internally then make an adjustment of who's now
Right.
responsible.
Who are they responsible for now? Drop them at them.
Here's two requirements, they may already be in there. For the apprentice, for the salon or shop of the apprentice, no apprentice shall operate any establishment while registered as an apprentice. And I may not be stating it well, but my intent is that if Bobby is an apprentice in his own shop that he owns,
He can own a shop right now. You're right. He can't be the manager, though, so he'd have to have somebody
manager,
there.
but if he had Frank working for him, then he could apprentice under Frank in his own shop. And that really can present some conflicts, I think.
An unlicensed shop owner would not be
No, the
able-
shop would be licensed, but not the individual person.
Okay, an unlicensed owner of a
The
shop.
owner would be the apprentice under a
The owner would be the
licensed
apprentice.
person who is actually their employee or,
And has to be the manager.
and has to
I'm
be
gonna
the
get my
manager.
license. Wait a minute, this is awesome, never mind.
Exclude 3,000 hours instantly.
My big question is why? Why would somebody, I mean,
I guess what I'm trying to say is, I don't mind that, that someone who owns a shop is an apprentice in the shop, but
It's a conflict of interest, I totally agree
there's a
with you.
conflict.
Wouldn't the school determine that there's a conflict of interest and not sign them on if they see that?
maybe not,
Unless you tell them
Roxanna,
not to.
maybe not.
I mean, I'm just questioning if we need to put it in the rule. Because if you're saying, I want to sign on, and what shop do you work at, that you're going to give them a chair, and you say, oh, it's my own shop, or you're saying they wouldn't tell you that it's their own
Yeah.
shop. And we want to put it in the rules so that it's open.
What's your biggest concern of that happening?
Well, since he's paying your salary, he has
Right.
all the power
Yeah.
to get you to sign off on anything he puts in front of you.
Still gotta pass that test, and nobody's gonna be in there to help you do that.
Don't scare me.
I never would have thought of that.
Okay. We can fit it in the same place, I think. Am I right? Or if everybody's in agreement, we just have to.
There are interesting players in every category of business.
Especially hairdressing.
I want you all to know I don't always look at the dark side. And I'll try to wrap this up. Each time the apprentice changes a supervising professional or salon or shop, a new, the school has to approve the new supervising professional. That's what I'm trying to get at here is anytime there's a change in the status of the trainer or the apprentice in the shop, that they have to notify the school within 10 days. And I know we talked about that this morning briefly.
If that's the one that's ultimately responsible, they should be the first one. Well, yeah, but they should know, but at the same time, if it's not gonna be a weekly check, it may be a month before they find out if they're not
Well,
having to
and-
be notified.
Mhm.
I think they should have to be notified. Because they're still earning the right to do it for the school owner, right? I mean, with the school owner.
What I'm saying is that if there's a conflict between the apprentice and the shop owner, and folks, I can tell you, it's happened in the past many, many times. The shop owner would withhold the paperwork, no, he wasn't here, he wouldn't sign off on his records. That's why earlier we discussed keeping daily or weekly records versus monthly. They could really hold a student up and cause a lot of problems.
So would we put into the rules that, at a dissolution of that relationship, that the owner is to contact the school and settle up all the paperwork and business within 5 days or 10 days or?
I have no idea how you're gonna regulate that. I don't disagree with you,
Well,
but
if
I,
I tell all my students to take a picture of their time cards, even when they're working in a salon with their cameras. They can keep it on their phones. That way they have a record, and because we can screw up putting in like the wrong numbers and stuff.
As an apprentice, if I've had a change in status, I'm gonna go back to my school right away. And then the school is gonna be expecting the paperwork. And if that doesn't happen, then the board can get involved.
Is there an escape provision as well for that apprentice supervisor, that they can submit paperwork in 10 days and dissolve the relationship too? Because, I mean, that'll work both ways.
The 1.5-year provision we talked about earlier.
Okay, I have a question.
On a replacement.
So, I mean, at any time, the student can go just back to school and get the hours, right? I mean, as long as you get 1,500, PSI doesn't care, we don't care. I mean, right?
I think you are correct.
But they would have had to enroll in this school to begin with, right?
Right now they do.
I think all schools have to
All
have a
schools have to
practical.
have the square footage requirements.
Right now they do.
And sections and everything.
Yeah. 5 dryers, 20 stations.
That's today.
Yeah.
Okay.
Today.
Somebody's gonna be at that podium shortly.
next month.
Presenting
Yeah.
something else, exactly.
So,
To mess it up or fix it? Oh.
are we gonna have a,
I think the 10 days, I agree with the 10 days.
And it's in the same section still, are we correct? Okay. Read it back to us, Ron, if you could, or I think I was on your right. Is this number under for salon shops with apprentice? Okay, what number is it? No.
well, let me turn my page back. Let's look at number 3, I believe it is. And that's a little wordy, we don't have to have all that there. Each time the apprentice changes supervising professional or approved training salon shop, a new application must be filed with the approving school. Maybe application is the wrong word. A notice of change, perhaps.
You're saying the school needs to know where that student
Correct.
is and
Because they're
who they're,
responsible.
and it could be dissolved by either the student who decides they no longer want to work for that particular supervising professional, or for the supervising professional who decides they no longer want to work with that
Exactly.
student.
Or the shop owner dies and closes the shop, or any number of things. The supervising professional must notify the approving school that this apprentice is not training in the establishment under that supervisor, and submit a transcript of the total hours accumulated by the apprentice within 10 days of termination of the apprenticeship. Thank you for your patience. I'm not trying to be too wordy, but we've all thought about this for a long time.
That discussion brings up something else to me. In my mind, all of my employees sign arbitration agreements. Would, can we impose that on anyone?
Shop.
Well, not in the rules, but could that apprentice supervisor as an owner impose that as a participant in their shop? Because I know there's some categories of employees you cannot impose an arbitration agreement on. I mean, but my people sign it or they don't work there. It's a choice. You know?
Supervising professional must notify the approving school.
It really seems like that if they're working in their capacity as a supervisor of an apprentice, then if they did an arbitration agreement with that person, I don't see how that would affect anything that we do in here. Does that make sense? I don't see how we require it, we would care about it. This board doesn't care whether or not, if somebody gets, injured, whose fault it is in the shop and all of that. That has to do with them. It would make real difficulty to get that. I mean, the student always sign an arbitration agreement. I imagine I did it when I bought something last week. And didn't know about it, so.
Or whether it would stick or not, right?
Rob, there's a couple more questions I have, and I think I'll be about done.
Let Rob read this one to you so we can make sure to make, and then we really, just wherever you all think we have to add these in the rule, not just to necessarily add them, yes, of the hour.
Okay.
Where's it going, Rob, so I know?
The next one, 7. We're still within the.
Still there.
Yep.
The supervising professional must notify the approving school that the apprentice is no longer under his or her supervision within 10 days of the termination of the apprenticeship and submit a transcript of all hours completed.
Great to me. You should have been a lawyer.
Yeah. Play
For that
one on
money
TV.
This one is, I think, with the same listing. Any shop or salon providing training for an apprentice shall ensure that each apprentice is provided with sufficient towels and consumable supplies to allow the apprentice to successfully perform all services appropriate to the license. It is a requirement of all schools that the students receive kits and supplies with assistance from the school. Some schools do it in creative ways.
We've added a rule that they've got to provide them a workstation. I don't know if you think that's sufficient or not.
Or put workstation and necessary equipment next to workstation.
This thing is wordy and long enough.
I think it's 5.
Necessary tools. That's the chair, your station, your mirrors.
Providing the color.
Yes, in my salon, we provide all products, you provide all tools.
The employee does.
The employee does tools, yes.
Okay, so we have number 6 right now says, any salon, shop, establishment participating in an apprenticeship program shall provide a workstation for the apprenticeship student. We can add
Workstation and the necessary tools?
But what's the school's, what's the school have to provide? How is it?
A school generally provides a kit that comes with mannequins, shears, combs, razors, all those type tools. It's the consumables and not have, are they giving you the shampoo, the hairspray?
Every salon's different, really.
Exactly.
That's like
We don't tell
salons.
salons, what to
Right.
provide their staff. I mean, not at all.
Right, so the station obviously is a space that allows
Right.
them to.
Right.
And then I think it's the agreement between.
The two. I do too.
so they provide a workstation and all necessary materials.
Not necessarily. I think we're kind of
The
debating it, but
workstation.
I mean, Frank, I think that would need to be between you and the school.
Yeah, absolutely.
Because if the student is paying the tuition to the school,
Should have a good kit and not need anything.
I don't think it's your responsibility to provide them with endless amounts of color to practice with.
That's a good point too. That's a good point too.
No, we're not
Once the
have to worry
school
about
wants to share the funds.
Yeah.
But I don't think that's gonna happen either.
Just call L'Oreal. They'll fix it.
So
No,
we're
but I
not
mean, I
adding
think
it?
you're
Am
right,
I
though.
correct? We're not going to add it? Is everyone?
That's correct.
Okay.
Workstation.
We're on
yeah.
to the next one. All right.
All right, Ron.
No, it's perfect. I'm just throwing these out there because
They're all interesting conundrums.
ideas are, anywhere I see problems, that's what I'm looking for.
Are there any other?
Just a couple,
Okay.
and I think this is really it. We had mentioned this earlier, a salon or shop shall have no more than 2 apprentices in training at any one time.
We added one that
That had to do with the individual training.
each supervising licensed professional shall be in responsible charge of no more than 1 apprenticeship student.
And do we need to limit it to a certain number in the facility, or can they have 10 or
I
20?
guess why, yeah, if the shop is huge,
Yeah, why would you?
Okay.
why would we limit it?
They're gonna have to provide a chair for them. That
Yeah,
might dictate
that
how many are.
dictates, yeah,
Okay.
good.
Yeah, because if you have a 10-chair even suite like you have, if you have 10, then you got to have 20 chairs.
There's number 5 under apprentice training. This is rather wordy, and I wish I could say it better. Each apprentice who completes training under the supervision of a supervising professional in an apprentice program and fails to make a passing grade on the state board examination will be required to complete a minimum of 300 additional hours training in a licensed cosmetology school. I'm not sure that's a good idea.
And
I
keep
don't
in
think-
mind that, at least what we've said so far, unless we change it here as we wrap things up, that we're asking them to take the theory exam up front. So they've got to pass it, is what so far the board has still left in the books.
In years past, on the Barber side, if you failed the practical exam, you had to go back and take additional training.
So now we definitely need to discuss the hours issue. Is there anything else that we've missed or meant to go back to?
I have one question. Under the sanitation, it says the enclosed storage area for clean towels, soil towels. Are those still, do they still need to be labeled? Because it doesn't say they need to be properly labeled. It only says that containers for cosmetic products must be properly labeled. Page 15.
Thank you. One covered container for soil towels?
Yeah, but it doesn't say it needs to be properly labeled.
No.
Okay.
No. I think the properly label, and maybe, and if I'm wrong, correct me at this point, because it's been a long day, but I think it's mostly about the cosmetics and those items that these shops move from their original container to a different container, coloring agents, to where they can make a mistake and hurt the client because that container is not labeled. And so they could be using something that has bleach in it. That's probably the rule behind it. Towels are no big deal, hopefully. Okay.
Is there anything else that we've missed up to this point? Ladies and gentlemen, we have a motion on the table that we need to bring back to the floor.
Motion was made by Ms. McAllister, am I correct? And seconded by Ms. Kelly Barger to take away the previous motions on increasing hours. If I'm saying-
We have a motion that's properly seconded. We need to ask one more time, do we need to have any further discussion on that?
Well, I would like to just say that I don't know how it can be handled in the future, if that's what we need to do, but I think as a board, majority of the board members, and maybe unanimously at some point, do feel that there needs to be more hours for these programs. So I'm not sure how the best way to go about this. Maybe we get somebody to get a legislator to present a bill, or I'm not sure. But I think that is, it's out there.
Publicity.
We need to take care of it as soon as we can, and if today's not the right time to do it, according to advice from those smarter than me, then I still think we need to really think about that and present it in the future as productively and as expediently as we can get it going. So anyway.
I don't like that we went through all that and then all that came about, but I certainly respect it. And I'm always been a firm believer, if something's right for today, it's also right for tomorrow. So I will definitely heed the advice of the recommendations.
I just want to say that I'm really proud to serve on this board, and I'm really proud of the work that we did today, because we wouldn't be here and we wouldn't be putting in as long as a day as we all have if we weren't genuinely very passionate about our businesses and most specifically the people who work for us, which I think this is what the whole discussion about hours is all about. So I know that maybe we didn't all agree today on everything. I don't expect us to, but I am very excited that we are all approaching this, I think, with the best interest in mind for people in our industry. And with that, I want to make sure that maybe if we are not submitting the hours, that it is very much on the record that it was discussed. Being told no anymore is just part of my daily life, so it doesn't really bother me that much. But I think we did a lot of work around it, and I wouldn't like to see that go away. Because I think that what I heard today was, in addition to that, it was either extended hours or some very clear understanding about what's going on in schools, about why people are or aren't being successful when they graduate, or coming to work for us in a variety of fields and not being prepared. And that could be the number of hours currently required or what's actually happening within those hours or not.
Before I ask for a vote on this, I'd like to say that while this has not been very pretty today, and thank you for your patience and indulgence, I think it's still work we can be proud of. All in favor of this motion, say aye.
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 Those opposed, say no. That motion carries, and we still need another motion for the work we just did.
That motion would be something like the motion to approve the proposed rules is amended.
I'll make a motion to approve the rules as amended.
Second.
That was Ms. McAllister. Any other discussion? All in favor say aye.
Aye.
Those opposed say no.
Last thing is the Regulatory Flexibility Act memorandum. It looks like this. On the front cover, it tells you why we have to do this and what it's all about. So I'm not going to read it to you.
Which one is it, Ron?
It's enough.
It's this one.
Long one?
Oh.
With the seal on it.
Regulatory Flexibility Act, Economic Impact Statement, Impact on Local Governments. There's a cover paragraph here that tells you what that's all about, why we have to do it. On the second page, there's a description of the proposed rules. Thank you. The first page, it gives you bullet points of what we did for the Barber rules.
Does this need to be amended for all of the work that we did today?
Well, I wrote this before I knew we were going to talk about hours, so.
Well, not
It's
necessarily
actually
with the
back
hours,
to the
since
way-
we didn't do that, but any of the apprentice changes, do we need to
Well,
include any of that, or are we good?
We need to look at the suggested answers and see if we need to tweak them based on today's discussion. The second, there's a paragraph relative to the practice of barbering, blah, blah, blah. 4 rules relative to the practice of cosmetology. There's a couple of pages of bullet points of what we propose to do for the rules. Page 3 is when we have to start discussing. Economic impact statement. As part of the rulemaking process for any proposed rule that may have an impact on small businesses, each agency shall prepare an economic impact statement as an addendum for each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State, and made available to all interested parties, including the Secretary of State, Attorney General and Reporter, and the Government Operations Committee of the Senate, and the House of Representatives, and is described for rules in Part 2 of this chapter. This is a reason that we were kind of advising against changing the hours and all, because this document doesn't say anything about that, and everybody's going to see it. That would be a question of theirs. The type or types of small business and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. And my suggested answer is any barber school, barber shop, cosmetology school, and any shop holding a license to provide regulated cosmetology-related services to the public could be impacted by these rules. It's really not could be. These rules implement temporary permit system for military spouses and an apprenticeship program for cosmetology students, both of which could provide wage-earning service providers to small businesses in an expedited manner. In the case of the apprenticeship program, cosmetology schools would likely bear some costs through the necessity of devising a reporting system for students who participate. However, the apprenticeship program is not required, and no additional cost would be associated with cosmetology schools who decide not to participate. So does that sound like a true statement, or do you want to tweak it?
Providing they get the full tuition, that would be accurate.
Number 2, then. The projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. My answer was, for cosmetology schools which elect to participate in the apprenticeship program, a system to maintain records for apprentice students would have to be devised in association with the partnering shops. The administrative skills necessary to do so would not exceed those required for existing record-keeping duties. Registered licensees who serve as overseers for apprentice students while employed at a participating shop would need to be utilized by that shop. The skill level of this employee would need to meet or exceed 10 years of continuous experience. Now we know it's not continuous, so we can take that off. So, how does the board feel about that? From taking off continuous.
Sounded accurate to me. The record keeping gets questionable sometimes when you have your ad on and people say there's no additional costs, but it's probably minimal enough to not really argue. There'll be some associated costs, but I don't think enough to identify.
Somebody under?
Yeah.
Number 3 is a statement of the probable effect on impacted small businesses and consumers. The potential workforce immediately available for small businesses would be expanded somewhat through the temporary permitting of military spouses who qualify and the apprentice students participating in these programs. I don't know how else to say it. Number 4 is a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business. And the answer I suggested, with these two methods of expediting persons into the barbering and cosmetology professions do not exist prior to these rules. Therefore, there is no less burdensome, intrusive, or less costly alternative methods of implementing them. 5. A comparison of the proposed rule with any federal or state counterparts. The State Board of Cosmetology and Barber Examiners is the sole agency for licensing and regulating the professions it oversees. There are no counterparts at the state or federal level. Last one, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. The apprenticeship program is made elective by statute and is therefore not required for any school or shop holding a license with the board. And then the last question there is impact on local governments. The State Board of Cosmetology and Barber Examiners does not project any change in local government revenue at any level as a result of these rules. The board needs to discuss and adopt this if it's their pleasure, or change it and adopt it.
Adopt the.
I'll second that.
We have a motion and a second to adopt this report. Is there any other discussion? All those in favor say aye.
Aye.
Those opposed say no. Motion carries.
Right, we have no further business to transact, as far as I'm concerned.
No further business. I would be willing to entertain a motion.
Motion
to adjourn.
Second.
Third, fourth. 10th motion.
I have a motion seconded by Ms. Coppinger to adjourn. All in favor say aye.
Aye. Aye.
Safety.
That wasn't so bad, was it?
Yeah.
What's up? I hit you with the apple over the holidays, were you? Christmas party.
I'm staying at your house tonight.
You know where I was?
Oh, never mind.